The Committee on Juvenile Justice and Family Issues will come to order. Clerk will call the roll.
Chair Dutton.
Here.
Vice Chair Lujan. Representative Cook. Representative Leo Wilson. Representative Lopez. Representative Martinez Fisher. Representative Smithy.
Here.
Representative Tallarico. Representative Wu.
Here.
The quorum is present.
Quorum is present, members. Thank you all. Thank you all. I know there's several things, committees going on, and members are going to those committees. And so for all of you that wish to here to testify on bills, just know that members will have to run out back and forth to other committees where they have bills, and they also serve on other committees, so they will run out. Let me make this announcement once. If you intend to testify, please register at the kiosk outside. You have to do that before you testify. The other thing I would say is that, look, when you come up to testify, tell us your name, who you represent, and your position on the bill. That's three things you got to remember. Your name, your position on the bill, okay, and who you represent. With that, what's his bill? Okay. The chair at this time lays out House Bill 2658 by Leach and recognizes Chairman Leach.
Thank you, Chairman and members. Hope you've had a good day today. I appreciate you allowing me the opportunity to lay out House Bill 2658 this afternoon. Members, I've been doing this now, not as long as you two, Chairman Dutton, and you, Representative Smithy, but Representative Wu and I came in together in 2013, so we're in our sixth session now. And one of the things I've learned, and I'm confident you have as well, is that oftentimes the best legislation, the best ideas don't come from inside this building, don't even come from our own minds or from advocates here or lobbyists. They come from our constituents who have seen a problem, have a story, have a personal experience, and reach out to us and communicate an idea, a problem, and work with us on a solution. And this issue, this legislation in front of you today is a perfect example of that. About a year and a half ago, a mother of two reached out to my office to request a meeting with me and my staff on certain issues relating to family law. We scheduled a phone call, and she proceeded to tell me and my team her story. She communicated problems that she saw in the law based on her own personal experience. Her now ex-husband has been, or had been at that time and still is, indicted on charges of online solicitation of a minor sexual conduct. When researching how she could best protect her young daughters at that time, she discovered the problem. While she could petition to have parental rights terminated upon a conviction for criminal solicitation, that was not an option for online solicitation of a minor. So while her ex-husband could have had his parental rights terminated for conviction of criminal solicitation, it is not an option for online solicitation. So we we asked questions, we looked into the code, we researched the law, we talked to other moms specifically who found themselves in similar situations, and they're right. Again, under current law, a conviction for criminal solicitation is grounds for termination of parental rights, but the solicitation online is not. This bill seeks to address what I would consider to be a major but very easily fixable gap in the law by adding both a conviction for solicitation of a minor and online solicitation of a minor to our statute as grounds for the termination of parental rights. Members, you've got in, I believe in your files, I don't know if they're printed or if they're in your drop boxes, your staff certainly have letters from some mothers of young children. These are parents who desperately want to protect their children from potential predators, even if that potential predator is a family member or a parent. Those folks could not be here today, but I do encourage you to read each of their stories. They know, we've communicated very, very clearly to them that this bill may not impact their specific cases, but they wanted to add their voices to the legislation to help ensure that no one's affected by this loophole in the law. Again, I think it's a big problem, but it's easily fixable, and we have an opportunity to do so with this bill. I'm happy to answer any questions and would request my right to close, Mr. Chairman.
All right. Thank you, Chairman Leach. I think there's several witnesses we have. And it's okay, and we'll give you the right to close.
All right, thank you, Mr. Chairman.
We'll proceed with the public testimony at this point. The chair calls Carlos Salinas.
Good afternoon, Chair, members. Thank you very much for hearing this bill, and I appreciate you very much for all the hard work I think you'll be doing this evening, this afternoon, and you've been doing this session. This bill proposed by Representative Leach, it creates a termination.
Give us your name,
Oh, I'm sorry.
position on the bill.
I apologize. I
represent,
apologize. I'm going to
okay.
be in trouble for that.
That's all right.
My name's Carlos Salinas. I'm a family lawyer here in Austin, Texas. I've been practicing family law for the last 20 years, and only family law. I'm testifying on behalf of the foundation, and I'm testifying in favor of this bill.
Okay, thank you.
Thank you. I think this bill's very straightforward. It adds solicitation of a minor as a grounds for termination. I think Representative Leach laid it out pretty well, and I think this is a very clear loophole that existed in the law that, in fact, I have a case right now that we had to bend over backwards to find an alternate grounds for termination in order to move forward on the termination. It doesn't change the fact that you still need clear and convincing evidence in order to for the court to find termination, nor does it remove the fact that the termination still has to be in the best interest of the child according to the court. So to me, this is, like I said, a no-brainer. I'm happy to answer any questions.
Any questions of this witness, members? Not hearing any. Thank you. Thank you, Mr. Salinas, for being here. Chair calls Jeffrey Morgan. Oh. No, we won't.
Thank you. My name is Jeffrey Morgan. Sorry for this. I left my papers at home today, so somebody's going to be bringing a copy later, but this will be a little bit awkward right now, so I apologize for that. My name is Jeffrey Morgan. I'm testifying on behalf of myself, and I'm testifying on the bill. I do agree with Representative Leach that in situations like this, that there are very that a child should be protected. There's no doubt about that. The one thing that I do once again mention in this whole bill is that the whole thing about the best interest of the child, how is that to be determined? I've stated that repeatedly. It sounds, I'm sorry, Representative Wu, but I came down here to testify.
But that doesn't.
And I just think that, you know,
The
when we
determination
come down
of
here-
best interest
Hold on.
is in the code.
Yeah.
Hold on. Hold on. The best interest of the child is not changed from current law in Chairman Leach's bill.
Right, no, and what I'm saying is that there is no definition of best interest of the child. There's no definition in the Texas Family Code. There's over 140 mentions of it.
But that's not relevant to this bill because that's not being changed in this bill. You understand that?
No, I understand what you're saying,
Okay.
but I'm just
Well,
saying.
you have to
that in-
testify on the bill then.
Right. It says that, and again, I'm sorry, I don't have it pulled up. I've been trying to get a hold of the bill up here so that I can actually read the text. But what I had down here on page, I thought it was page 7, it says this termination is in the best interest of the child. I will always have questions regarding how that is determined. And I'm not saying, I'm not by any means saying put a child in front of a predator, whether it's a man or a woman. And I don't see anything about false accusations. I guess from what I heard, if there's clear and convincing evidence, that's what's going to be taking place. The only thing I was saying is that right now, as far as the best interest of the child is concerned, I have seen so many perversions of that standard that I have no confidence in it.
But you understand, that's not in this bill, right?
I thought it was, and again,
Okay.
I apologize, I had everything.
That's not a change in this bill.
Okay,
All
okay.
right, so
Anyway,
we'll
so
have
that's all I was saying here, that's fine. Like I said, if, wait, let me see here. You know, if the, the charges that are being made, and, you know, I'm sorry, I guess I don't have the entire thing in front of me right here, so it's my fault. I left my paper sitting on my printer. I have somebody else bringing in a second copy of them, and I just don't have it here with me, so I apologize for that. I was hoping to be able to pull it up here. That's it.
Okay, all right, thank you for your testimony. Chair at this time calls Julia Hatcher.
Chair Dutton, committee members, my name is Julia Hatcher. I'm an attorney in Texas. I'm also the president of the Texas Association of Family Defense Attorneys, and we are testifying in support of this bill. I realize that may seem like an oxymoron to some of you because we defend families, we keep families together, we represent parents and children in CPS cases. Generally, we don't like terminations. But in this case, we understand that Representative Leach is just adding a ground for something. The criminal solicitation, as he said, is already in the code. And this is just adding the online solicitation that just probably a new offense or a new in the penal code since the family code was written. And we also represent children, and so we understand the need to add that. We did have one suggestion that perhaps instead of adding another letter to the alphabet, because, you know, we're always trying to not have letters added, maybe consolidate this with S, which already calls for termination based on convictions of certain offenses.
T.
Is it T?
Because we,
Oh.
Well, there's another ground in there that already calls for termination based on conviction of like murder, attempted murder, and probably wherever the criminal solicitation already is. So we would just suggest maybe adding it to that ground instead of adding another letter to the alphabet. But other than that, we're in support of the bill, and I'm open for any questions.
All right, have you finished, ma'am? I'm sorry.
Yeah, I'm
All right.
finished listening.
Okay, so your testimony is you like the bill, you're for the bill, you just believe that it ought to be placed in another section in the code.
Just another letter, not another section of the code, just another,
Well,
consolidate it with
section
another
of the
ground.
current code.
Correct.
Okay, all right.
Yeah,
Any further questions of this witness, members? Not hearing, thank you for being here.
thank you.
Chair calls. That appears to be all of the witness affirmations we have. Is there anyone else here who would like to testify on, for, or against House Bill 2658? Not hearing any, the chair recognizes Chairman Leach.
Thank you, Mr. Chair. Sounds like, Representative Wu, you want to make a few changes to the bill?
Representative Wu.
thank you. No, I had the same comment as Ms. Hatcher. As under T grounds, it's now T because we removed something last time. That I don't know what was removed.
All right.
But T T spells out all the different types of criminal charges
Yep.
where this would apply. So
Okay. Well, I would, Mr. Chair, I'd request your favorable consideration on this and where we are in the calendar. I know it might prove to be more difficult to get this through the general calendar, so I'd request, if possible, that we get this to local and consent. I'm happy to work with you on any changes that need to be made, but I think local and consent would be an appropriate place for this, and because I think this needs to be done. And this is a simple, easy fix. It's almost closing a loophole, like I said earlier, and I'd like to get this over to the Senate as soon as possible. So,
Right. Thank you.
Thank you, Mr. Chair.
Any further questions of Chairman Leach?
All right.
Not hearing it.
Thank you.
Thank you, Wolf. Chair leaves House Bill 2658 as a matter of pending business without objection before the committee. Chair hears none, so ordered. Chair lays out House Bill 968 by Representative Gates and ask him to explain it.
Thank you, Chairman and members. This bill is a refile of a bill I passed last session unanimously by 139 votes. It died in the Senate on May 26, 21, so I'm working again to pass this great bill. When CPS is identified an alleged perpetrator of child abuse, HB 968 amends the Family Code to allow the alleged perpetrator to agree in writing to an order subject to a court's approval to leave the home. This allows for the child or children to remain in their home, thereby reducing the trauma associated with these situations. This proposed law would have been extremely beneficial to my own family 23 years ago. After having 2 children, a couple miscarriages, my wife and I decided to adopt children whose mothers were in jail or been in drugs and so forth. Eventually, we even adopted a sibling group of 4 from CPS that brought us up to 13 children. Because some of our children had learning challenges, some issues arose with their school districts about getting services in which they were entitled. And on Friday, February 11, 2000, a school district made a call to CPS alleging abuse, and CPS unlawfully entered our home when I was not there, and later that night removed all 13 of our children. Our children were returned after emergency case hearing on Monday, and the case was eventually dismissed. But if you talk with any of our children, they would tell you about the dreadful weekend haunts that haunts them in their hearts and minds to this very day. Recognizing that I cannot be the only family this has happened, filed a federal lawsuit, and the Fifth Circuit decision in 2005 has now been cited in over 900 federal cases around the U.S. Ironically, the day I was sworn in as a House member, on February 11th, 2020, was 20 years to the day that CPS had illegally entered and wrongfully took our children. I can assure you if this law would have been on the books back then, I would have gladly left that night to allow my children to stay in their home and not be unnecessarily further traumatized. HB 968 prohibits an order from being used against a person as a mission of child abuse. Moreover, the person has a right to revoke the agreement, at which time it could lead to removal of their child or children. The court would still have to make findings that a child would be removed without this order in place. I'm happy to answer any questions and ask for permission to close.
Okay, thank you, Representative Gates. May I ask a question, though? So the perpetrator, or alleged perpetrator, child abuse, could enter into a written contract with CPS to leave the home, and that means they wouldn't take the child away.
Right, it would be a court order, and so they would have to go to court, and the court would have to sign an order that could be enforced to keep them out of the home if they decide to do that. They would voluntarily agree to this order and then have the court issue an order that they remain from the home, the kids stay in there.
Okay, but it would be only subject to a court order.
Right.
to Have this done.
Right. That way it's enforced that they couldn't come back.
Okay, I think I got it. Any further questions of Representative Gates, members? Not hearing any, let's see if we have some witnesses.
Okay.
We'll open the public testimony and give you the right to close. Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I'm testifying on behalf of myself. I'm testifying for this bill. I think that this bill is very definitely needed. I have not experienced this with Child Protective Services. I've talked with multiple people who have. I've interviewed them. And I think that Representative Gates, that this, wherever you are, oh, I'm sorry. I missed you there, sorry. I agree with you as well that had this bill been in place, that there would have been a lot of unnecessary trauma and damage that would have been stopped in the state of Texas. My perspective on Child Protective Services is not a good one, but I do stand in favor of this bill, and again, I thank you for actually putting it forward to keeping children within their families. Okay, I think that's
All right,
it.
thank you.
I'm sorry.
Let's
Thank
see
you.
if there are any
Yeah.
questions. Any questions from Mr. Morgan, members? Not hearing any, thank you for
Thank
being
you.
here. Chair calls Julia Hatcher.
Chair Dutton, committee members, my name's Julia Hatcher. I'm an attorney in Galveston. I'm also president of the Texas Association of Family Defense Attorneys. This is a great bill. We colloquially call this a kick-out order. There is already a statute which allows for the department to petition the court for an order to remove an alleged perpetrator from the home so that they do not have to ask for removal of the children. However, they don't do this. Whether it's because they don't want to do it, they don't know about it, or whatever, this is just not happening. And so many times we hear judges ask the department, why didn't you just move for a kick-out order? It would have been much easier to just kick out the alleged perpetrator than to remove the children from the home and cause them trauma. This bill would force the department to utilize the provision that's already in the statute and seek that kick-out order initially, rather than jumping to a removal of the children from their home. As you know, removal is very traumatizing to children, and if they can be kept safe if the alleged perpetrator is removed, then we don't get why the department continues to take custody unless, they get paid for every child they have in their care. The other part of the bill is about PCSPs, which are parental child safety placements. Parental child safety placements should be better utilized to prevent removals as long as they are not indefinite. There needs to be guidelines on parental child safety placements so they don't last in perpetuity. If a parent agrees to a parental child safety placement to last longer than the court would allow it, then that's fine. But if a parent agrees to a parental child safety placement initially so that CPS can continue their investigation, and in a month or two the alleged danger is gone, then children should be able to go home. What's been happening is that a parent will voluntarily enter into a parental child safety placement, and then it just gets strung out for months and months. I had a client in my office last week who had been in a parental child safety placement for 8 months. 8 months, had done everything that CPS wanted her to do, and then they just wanted her to do more. So that needs to stop. 8 months is almost the life of a legal case, and if someone is going to have their child out of their home for that long, it needs to be there needs to be some court oversight. So we think that this bill is great, and we respectfully urge the committee to vote it out.
Any questions for, show Representative Cook present. Any questions of Ms. Hatcher, members? Not hearing any. Thank you, Ms. Hatcher. That appears to be all of the witness affirmations we have. Is there anyone else here who would like to testify for, on, or against House Bill 968? Not hearing any. The chair recognizes Representative Gates to close.
Brandon Johnson wants to go sign in, and he would like to testify.
You should already be.
Well,
He's,
if he's not here, sir, we only recognize those who have done so. Do you know where he is?
He left in the middle of the testimony, and he went to the back to go ahead and sign in. He went to the kiosk? Yes, sorry, it's behind him.
Show Representative Tallarico present. I'm sorry, but we're going to move on. Chair recognizes Representative Gates to close.
And I close.
All right, thank you. The chair's intent to leave House Bill 968 as a matter of pending business before the committee without objection, and chair hears none, as so ordered. Oh, the chair lays out House Bill 2716 by Representative Hull, and
Thank you, Mr. Chair, for allowing me to lay out House Bill 2716. Medical decision-making is one of the most important duties and a right of a parent. This includes decisions related to psychological or psychiatric treatment. Texas law is very clear. Parents have the right to make medical decisions for their children. With recent attention to and discussion of youth mental health, it is imperative that the Texas Family Code reflect that if a parent makes the treatment choice for their child to refuse to administer or consent to the administration of a psychotropic medication or refuses to consent to any other psychiatric or psychological treatment, that refusal does not constitute neglect unless substantial risk of death, disfigurement, bodily injury, or have an observable and material impairment to the growth, development, or functioning of the child is demonstrated. It also makes sure that removals of children and terminations of parental rights are not based on these grounds alone. My bill in no way limits the ability of anyone to make a report of abuse or neglect when that person believes a child is in danger or being harmed due to such a decision. It does not prevent DFPS from doing their duty to investigate such accusations, and it does not deny the department any of the tools they have at their disposal or even removing a child when harm has been caused to that child. HB 2716 ensures a balance between parental rights and the sometimes warranted intrusion by a governmental entity that might be necessary only if a child is truly harmed or endangered. This bill simply states that a parent has a right to choose the best medication or treatment for their child. I'm happy to answer any questions and reserve the right to close.
Show Representative Lujan present. Any questions of Representative Hull, members? Not hearing any, thank you. We'll give you the right to close, and let's see if we have any witnesses. Public testimony is opened. Chair calls Lee Spiller.
Thank you. My name is Lee Spiller. I'm with the Citizens Commission on Human Rights, and we are for the bill. In 2004, we had a case where a family's daughter participated in a mental health screening program in her middle school in Pflugerville. The first day she got a screener, everything was hunky-dory. The second time she got screened, she answered every question in the worst possible way, and she was known to be a smart aleck. The researchers decided that she needed to go to an inpatient psych hospital. The parents wanted a second opinion. Weeks later, the CPS showed up at the school. They took this family's child when the dad wouldn't come get her and take her to a psych hospital because mom had the car. It was 4 months before they got visitation. She was restrained 26 times. She was cycled through numerous drugs. And the whole time, a CPS case is going on. And if you've ever seen a CPS case, I mean, generally in the petition, they put everything but the kitchen sink. And this family had to fight to keep their daughter. This bill would clarify that unless you've got something that you can really hang your hat on, you don't get to terminate somebody's parental rights over that. And the sad thing is that was not the only case that we dealt with that was that way. So yes, we support this bill. Thank you.
All right, thank you, Mrs. Spiller. Chair calls Brandon Johnson. Who is with the Texas Association of Family Defense Attorneys, testifying for himself and the organization for the bill. Is that right? Oh, I'm sorry, you're testifying for yourself against the bill. My computer's acting up here.
Unless there's two of us here.
Don't change it. Don't change it. Okay. Chair calls Brandon Johnson.
All right, Brandon Johnson for myself without an organization.
All there, so I'll go down the list like that.
And I was out in the back checking in to testify during that last bill, so I didn't catch all of Ms. Hull's, what she was saying. I put off against the bill, but I was listening to the gentleman earlier, and he was saying, well, there's a little confusion to me, but I see red flags whenever I read that a parent refuses to administer psychotropic medication to a child. Now, I understand the extreme circumstance is not something I've personally been involved in, so I can't testify on that side of it, but any time that the state is involved, especially DFPS, and you're talking about having these so-called experts involved in the kid's life, I understand and I sympathize with erring on the side of caution, but I just think it's going down a slippery slope, and I could be totally wrong. And I apologize to Ms. Hull for not having the time to come by and talk to her about the bill prior to testifying on it. I'll mention that as well. But language like that, with its best intentions, I can see going down a bad road, and I think it deserves additional consideration. Thank you.
All right, any questions of Mr. Johnson, members? Not hearing any, thank you. The chair calls Julia Hatcher, Texas Association of Family Defense Attorneys, testifying for herself and the organization for the bill.
Chair Dutton, committee members, my name is Julia Hatcher. I'm an attorney in Galveston, and I'm the president of the Texas Association of Family Defense Attorneys. We support this bill. It is a very sad fact that children are over-medicated, and it's usually not the parents that are wanting them to be medicated. It's teachers, it could be counselors. I myself, when my son was in high school, the teachers wanted to medicate him. When he was in grade school, they wanted to medicate him, and I refused. I wouldn't let him do it. So I know firsthand how this goes down, and it is very important that we do not remove children from parents because they don't want to give their children medicine, and it's just as important that we do not terminate their parental rights because they don't want to give them medicine. Parents have custody of their children, and as such, they get to determine what's in the best interest of their children. That's constitutional law, and they can determine whether or not to give them medicine. If it gets to the point where they need the medicine, the doctor says they really need the medicine, then I think this bill covers that the parents would then have to give them the medicine in order to prevent harm. And that's all I have, if you have any questions.
All right, any questions of Ms. Hatcher, members? Not hearing any. Thank you, Ms. Hatcher, for being here. Chair calls Jack Finger. Jack Finger going once, twice, 3 times.
Jeffrey Morgan.
Where did he go?
He's right there. It don't do, that's not how that works.
What happened to Jack Finger?
Because he's not testifying.
But I wanted to talk.
Oh, my bad.
We're having computer malfunction up here. Jack Finger was here to testify for the bill for himself, but he will be shown as being for the bill but not testifying. Chair calls Jeffrey Morgan.
Thank you. My name is Jeffrey Morgan. I'm testifying for myself. I'm testifying for the bill. And one of the big issues that I look at is when you talk about parental rights, the opinion by the Texas Attorney General Ken Paxton, February 22nd, 2019, opinion KP-0241, standards courts apply when balancing the rights of the state against fundamental rights of parents to raise their children free from government intrusion. The Due Process Clause of the 14th Amendment protects fundamental parental rights. Among these, the due process protects the rights of parents to make medical decisions on behalf of their children. So I do stand with Representative Hull. Once again, thank her for submitting this bill. When it comes down to the rights of parents or the rights of Children's Protective Services who are not parents, we need to stand with the rights of the parents. Thank you.
All right, any questions of Mr. Morgan, members? Not hearing any. Thank you, Mr. Morgan. Chair calls Lee Spiller.
No, you already called him.
Oh, did I already call him?
That's all. See, it's only done.
That's why you have to put it in. But once, so I can go down a little
But
bit.
if you want the
Stop, just do what I ask. Anybody else here who would like to testify for, on, or against House Bill 2716? Chair hears none, the chair recognizes Representative Holt to close.
Thank you, Chair Dutton, for allowing me to bring this bill. I believe this will help families make the best decisions for their children. I ask for your favorable consideration, and I close.
All right, thank you. With that, the chair's intent is to leave House Bill 2716 as a matter of pending business before the full committee. Without objection, chair hears none, so ordered. The chair at this time lays out House Bill 5370 by Representative Harris. I recognize Representative Harris.
Thank you, Mr. Chairman and members. I appreciate the opportunity to lay out this bill before you. Currently, the Juvenile Board of Navarro County is composed of district judges, the district attorney, and the county judge. Previous legislation established a county court at law, which has jurisdiction over juvenile cases. Stakeholders in Navarro County have asked us to amend the statute to include the county court at law judge on the Navarro County Juvenile Board, and that's exactly what this bill does. Thank you, Mr. Chairman and members. I reserve the right to close and will defer to witnesses.
All right, any questions of Representative Harris members? Not hearing any. We will start the public testimony now. Chair calls James Lago Mauricio.
I want to thank Representative Harris and the committee members for having me here today. My name is James Lago-Marsino. I'm the district judge for the 13th District Court, which is Navarro County. Our juvenile board, as Representative Harris said, it lays out the current members, plus we can add 5 members from the public. That was, I think, done in 1989. Government code, then with the county court of law, gave our county court of law a concurrent jurisdiction in all matters, including juvenile matters. That was in 2011. 2012, myself and the current county court at law judge executed a document for assignment of cases and having them split evenly. So for a period of time, our county court at law judge served on our juvenile board until we reviewed the current statute in effect. She became uncomfortable with it, and I certainly understood her hesitation. She got off the board, and then that's where we are here today. As y'all all know, we have lots of issues dealing with juveniles, especially detention, transport of juveniles, and I myself would like to have as many judges that are handling juvenile cases to be on that board. And so I'm the only district judge. There's only one county court at law judge, and I would like to have in the future, whether it's we have other courts created, other judges that they be able to serve, represent, or hopefully have more than just myself. I'd like to have another judge there to hopefully put our heads together. So thank you for your time, and
All right.
appreciate it.
Thank you, Judge. Are there any questions for this witness members? Not hearing any. Thank you for being here. Chair calls Brandon Johnson.
Chairman Dutton, what I did, I just want to make you aware,
Tell us your name, who you
Brandon
represent,
Johnson.
your position on the bill.
I'm neutral on the bill, and I'm representing myself.
Okay.
And what I'd like to say is I signed up to testify on all the bills so that if I want to put my 2 cents in, even though it might not be worth one, I want to reserve that right without having to walk back and forth. And so what I did is I put that on there. And so I'm just going to say, I'm going to sit back there unless you need me to get up.
Do you have something to say about this bill?
No, sir. Okay. But I don't know how to properly address you otherwise than getting up here.
Thank you. Thank you then. Chair calls the next witness.
May I ask, is it okay if I just sit there, or do I need to get up every time you call me?
No, sir. The way the process works around here is you sign up on a bill to either testify for, on, or against it. And if you do that, then I have an obligation to call you as a witness. If you don't want to do that, however, you can simply not sign up for that bill.
Yes, sir. It just asked on the kiosk if I want to testify or not, so I just put yes on all of them.
Right. And so, but if you don't want to testify, you have to check, I don't want to testify.
Yes, sir.
And we'll show you that way, okay?
Okay.
Whatever your position is, we'll show you that way, but not testifying.
Thank you.
So you don't have to testify, okay? All right, thank you. Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am testifying for myself. I'm testifying for the bill. And I'm testifying largely because of my understanding of what Mr. Harris has done. So I wanted to show support for Mr. Harris in this bill. The one thing that I noticed in this, and Chairman Dutton, as you mentioned in this one thing, I've been looking at these bills right now, and I apologize again, I don't have the printouts with me. But it was talking about the change was the judges the county courts at law in the county. What I was referring to was something that was not actually a change that I was going to testify on, so I'm going to stop that part, but I am for the bill.
All right, thank you. Any
Thank you.
questions? Chair has none. Is there anyone else here who would like to testify for, on, or against House Bill 5370? Chair has none, and Chair recognizes Representative Harris.
Thank you, Mr. Chairman and committee members. With that, I close and would request favorable recommendation to the local and consent
All
calendar.
right, all right, thank you. Mr. Chair's intent to leave House Bill 5370 as a matter of pending business before the full committee without objection. Chair has none, so ordered. Which one is it? Okay. You ready? Yeah. Chair Chair. Oh, okay. Chair at this time lays out House Bill 4161 and recognizes the Honorable Barbara Gervin Hawkins. to
Thank you,
explain.
sir. I appreciate that. Thank you, Mr. Chair and members, for the opportunity to lay out House Bill 4161 before the House Committee on Juvenile Justice and Family Issues. Simply put, this bill aims to ensure that families of children who have been taken into DFPS custody are informed in a quicker manner regarding the seizure. This issue is of great importance to some of my constituents. I have worked with my constituents on cases involving the department, and they have brought up serious concerns with the efficiency and transparency of DFPS procedures and processes. As Texas law exists today, when a child is taken into DFPS custody, the department must notify the family of the child within the 4th degree of continuity, such as grandparents, aunts, uncles, and cousins of the seizure child. The department must inform the family that the child has been removed from the home and is temporarily managing care of the department, and in temporary managing care of the department. The department must also inform the family of options available to participate in the care and the placement of the child. The notification of family members of DFPS action to take the child into custody is critically important because it gives the family an opportunity to potentially become a substitute caregiver while the permanency goals of the child are established. Each day that DFPS delays in notifying family members, the child spends one more day away from family in a scary and often traumatizing situation. It should be the goal of the department to inform all eligible family members immediately so that the harm incurred upon the child is minimized. In current statute, DFPS must use due diligence to identify and locate all eligible family within 30 days of when the department files a suit affecting the parent-child relationship. We're talking 30 days. I believe this is far too long of a delay. As an additional note, there is much uncertainty about when the department is required to file suit. Upon Chapter 262 of the Family Code, the department is required to file suit before a court-ordered removal. However, in the event of an emergency removal, the department must file suit without unnecessary delay. An unspecified time frame leaves uncertainty about how quickly the department needs to file suit after an emergency removal, potentially allowing the department to notify family members more than 30 days after the seizure of the child, and I have seen this happen. In a hypothetical situation, a child who is taken into family care on the first day of their DFPS conservatorship will spend 30 times more away from family and 30 more times alone than the child who was taken on the 30th day. To reduce the emotional, mental, and psychological harm on children seized by DFPS, my bill will seek to reduce the time DFPS has to inform the child's family members. HB 4161 will decrease the time the DPS has to contact family members to 72 hours from when the department files suit affecting the parent-child relationship. Furthermore, The bill requires the DFPS begin to contact family members no later than 24 hours after filing the suit. This ensures potential caregivers are informed as soon as possible of the child's situation so that the child can be placed with his or her family, not complete strangers, at a very traumatic point of their life. The bill also adds an oversight mechanism to require the DFPS reports to the child's state representative, state senator, and the governor whether or not they were able to contact all of the family required. If they were unable to contact all of the family, the department must inform the aforementioned parties why they were not able to. The department must also annually report information to the legislator regarding kinship, discovery, and placement. As current law stands now, there is no such mandatory report to the legislator, so we don't know, but yet we're getting those family complaints. A concern has been conveyed to me that this bill may place too great of a burden on the department, that it creates incumbent administrative processes. I respectfully reject this notion. In the current budget, the department will be appropriate over $2.5 billion each fiscal year. With resources like these, DFPS shouldn't have trouble fulfilling a few more administrative tasks, which will benefit the safety and mental health of children. We have met with stakeholders and have been listening to their concerns. I am open to working with committee members and said stakeholders to ensure that the bill best assists the children and families of Texas. Chair and members, this is a bill that will help some of the most vulnerable Texans to be placed with their loved ones in times of great stress and trauma. It also ensures the department is minimizing the suffering and harm of a child. With that, Mr. Chair, I reserve my right to close.
Any questions of Representative Gervin Hawkins, members? Not hearing any, thank you. We'll give you the right to close and proceed with the public testimony. Chair calls Brandon Johnson.
I'm Brandon Johnson, representing myself, and I believe I put on there on the bill. Is that correct?
No, it says here you're registered for the bill.
Absolutely. I'm for this bill 100%. I think any time you can place deadlines and on the government to do something, especially when they're taking our children, it's a very good bill. And I think she spelled it out very nicely. So thank you.
All right.
And, for the bill.
Any questions of this witness, members? Not hearing any. Thank you. Chair calls Jeffrey Morgan.
Thank you. My name is Jeffrey Morgan. I am testifying for the bill. Boy, this is going a lot faster than last week, isn't it? And I am for the bill. I'm testifying on behalf of myself. I also agree that Representative Gerken Hawkins has a great bill here. When the government comes and takes away, or a government agency takes away children, they do have a responsibility to contact the parents, the grandparents, the fourth degree of consanguinity. I'm 100% for that. The only thing I would say is that I believe it was said that the budget for the CPS or DFPS was $3.5 billion. I thought that was even more than I thought. Honestly, I'd like to see this reduced personally. I'd like to see grandparents or aunts and uncles more readily be available to take over the functions of DFPS.
Okay,
Thank
let me
you.
stop you. You have
Right.
to stay on the bill now.
Right. No, I am, yes. But I'm just saying, right, that was just an opinion.
No,
But
you
I
have-
want to say
oh,
thank
hold-
you.
Hold on for a minute.
Okay.
Hold on for a minute. If you come up here to testify for a bill, you have to stay on that bill.
I am on the bill.
Well, this bill doesn't have anything to do with grandparents.
Well, it says fourth degree of consanguinity, so that would
Well,
be relatives.
well, that would be relatives, that's true.
Right.
But it doesn't say anything about grandparents.
No, it doesn't.
Okay. All
No,
right.
I
So
was
let's
using them
just
as an
stay on the
example.
bill. Let's just stay on the bill.
Right. And absolutely. I mean, there have been too many times when a child is being taken away from a parent or a family, often for no good reasons. And then they don't know where they are. They're with strangers. And they need to be returned back to family as quickly as possible. And I thank you again for this bill. I will support it 100%.
All right, any questions of this witness, members? Not hearing any. Thank you. Chair calls Christina Perron.
Thank you, Chairman and members of the committee. My name is Christina Perone, and I'm an attorney in Northeast Texas, and I am here testifying for the bill today. I am also a member of the Texas Association of Family Defense Attorneys, and I am in support of this bill on these very specific and short, strict timeframes for the department to be able to identify and locate the necessary relatives or kinship caregivers to provide care for children who are removed from their families. As members of the committee might already know, the adversary hearing in a CPS case oftentimes takes place sometime within the first 14 days that these children enter care. So allowing this process to begin and requiring that the department start the process of identifying these relatives within 24 hours and making due diligence in order to complete it within 72 hours, we're ensuring that these relative and kinship caregivers have sufficient time to perhaps obtain counsel for themselves and to prepare to attend an adversary hearing where they can go before the court and ask that they be considered for placement of their relatives. Additionally, it alleviates the common pitfalls that many of us attorneys who practice in these child welfare cases see all too often, which is that oftentimes the Child Protective Services investigator doesn't send off the required notices for identification and contact information for potential caregivers. That report comes back from a special investigator and is commonly referred to as a finder's report. Unfortunately, many times it's been my personal experience that we have to wait until a conservatorship worker takes over this case, many times weeks after an adversary hearing has been held. Waiting at that point in time for months for a finder's report to come back so that relatives and potential kinship caregivers can be contacted requires that these children spend time in these unfamiliar environments, thereby extending the trauma that they are enduring by having been removed from their parents. I'm fully in support of having this bill, shortening these timeframes and holding the department to the strict requirements of notifying relatives to remove these children from care, foster care, and into relative care or kinship caregiving home just as soon as possible. Thank you.
All right, thank you, Ms. Perron, for being here. Thank you for your testimony. Any questions, members? I don't believe so, Ms. Perron. Thank you. Chair calls Charles Suze. And I probably didn't say that right, did I?
I'll help you out.
Thank you.
My name is Charles Stephen Cease. It will look like Seuss, and if you say Seuss to me, I'll be okay with that too. I'm testifying in support of this bill. I am representing myself and my family. When I was doing my homework, just looking through all the bills that we're going through this afternoon and this evening, I wrote down my summary was grandparents, find them. I understand the bill doesn't actually use the word grandparents. We're talking about certain degrees of freedom within relations in the actual text. And I think maybe I picked up grandparents from talking with people about the bill before the hearing. It's not always that we get to hear what inspired the bill. My understanding is that we've got kids who get kind of lost in CPS, and CPS is supposed to find family, but they don't. Well, for how long? Months is my understanding. I'm absolutely for this bill. I'll keep it short. I don't know, is there a motivation for CPS to not find the family? Is it to extend and harvest federal funding? Because they have these kids. Please, let's move this bill towards getting passed and a vote on it. Thank you.
All right. Any questions of this witness, members? Not hearing any. Thank you. Chair calls Julia Hatcher.
Chair Dutton, committee members, I am Julia Hatcher. I'm an attorney in Galveston. I'm also the president of the Texas Association of Family Defense Attorneys. We're a statewide association of attorneys representing parents and children in CPS cases. We are for this bill. This is a wonderful bill. Thank you, Jervin Hawkins, for filing it. It is imperative that CPS find these family members sooner rather than later. As it stands right now, we don't get finders reports until the case has been open for months. Children have been in foster care, and by then, CPS doesn't want to move the kids, or CASA or ad litem doesn't want to move the kids out of foster care because it would be traumatic to move them to be with their family. So it's very, very, very imperative that family members are identified and located early on in the case. I myself have found family members before CPS has, and I find them through Facebook. I can't tell you how many people I have found through Facebook. And I asked a caseworker once, why don't you use Facebook? Oh, it's against our policy. We can't use Facebook. I don't know what that's all about, but that to me would seem to be a pretty good resource. So if it takes a bill like this to make them use Facebook, then so be it. But they should be using whatever is at their disposal to find these family members so we can get these kids out of foster care and with the family where they deserve to be. Thank you.
All right, thank you, Ms. Hatcher. Any questions of this witness? Not hearing any. Thank you, Ms. Hatcher. Chair calls Beverly Morris.
My name is, thank you, Chairman Dutton. My name is Beverly Morris, and I am for the bill. And I also represent Texas Grandparents Raising Grandchildren, and I'm a grandmother. And my grandkids, 6 of them, they were in CPS custody. It took them 5 months to find me. So I'm for this bill because when it takes this long to find children that are in CPS custody, and here I'm a grandmother willing to take my 6 grandkids, they had lots more trauma when they got to me, and they were just like, well, why didn't you look for us? And why, I didn't know. I live here in Austin where they were taken. And I'm on Facebook. I have a phone number and a cell phone number. Of course, you can't find a cell phone, but I have a residential phone number where they could have contacted me. So for 5 months, my grandkids suffered going from foster home to foster home, being separated because it took CPS so long to find me. So I'm for this bill, and I thank you for creating this bill. And I speak to a lot of grandparents who come to the Texas Raising Grandparents meetings, and they're having these issues, and I think it needs to be stopped. It shouldn't take that long for kids, relatives to be found, and relatives who want to take the children, and this will eliminate so many children being in the foster care system. So I'm for this bill, and I don't know if I will be allowed to give you all a document or not.
Oh, you have to speak into the mic now, okay.
I'm going to be down here speaking on other bills later, and I want you all to get to know me because these bills need to be passed to help grandparents that are willing to step up and take their grandchildren, and some of them, they can't afford it because they're on fixed budgets. Am I on a fixed budget? Yes, I am, but I have a team behind me that supports me, and so when I got my 6 grandkids, I had people to support me to help me through this process. So I just really feel like this bill needs to go into effect so children don't remain under CPS custody longer than they have to when there are relatives willing to take them. Thank you so much.
All right, thank you. I think Representative Wu has a question. I'm sorry, there's a question, Ms. Morris.
I'm sorry.
Chair recognizes Representative Wu.
Thank you, Mr. Chairman. I just want to try to understand the situation that you went through just a little bit. Do you know why it took them so long to find you? Like, was it your daughter or son or?
It was my daughter.
Daughter?
Yes.
Did your daughter not know where you were?
She knew I was here in Austin.
Okay.
But did she tell CPS? That I can't answer. I don't know if she told them or not.
Okay. I think CPS naturally looks for grandparents for initially, like, I'm just trying to figure out the situation where was it like they didn't know your name and they couldn't look you up, or like they asked your daughter and you said like, no, my mom's not alive or something like that?
My daughter and her children, they lived with me. I'm the one who registered my grandchildren at the school where they attended. So from my understanding, even from the school said they told CPS about me. but I don't know why CPS never contacted me for all of those months.
Yeah, because normally the way we do it in court is, you know, when a case is started, a parent's, well, one or both parents are given a parent resource form that has, please list friends or relatives who would be willing to take custody of the children. It's the first thing that's on the sheet. So I'm just curious, like whether your daughter just didn't list you or had gave misinformation to CPS or what it was.
So I don't really know how it works. So if my daughter doesn't list me, and they don't go around and try to find out are there relatives or there's no way to find out. I don't really know how it works or why I wasn't contacted.
Thank you.
You're welcome.
Didn't CPS ever find you?
Yes, they eventually did find me 5 months. It was 5 months that
How
they
much
had to
later they found you?
Yes, they did find me.
And did they tell you how they did that?
No, they did not
Or
tell me.
why it took so long?
No. They just asked me, was I willing to take the children? That was the question that, when they called me, that was the question they asked me.
Okay. All right. Any further questions, members? Thank you, Ms. Morris.
You're welcome.
Thank you for being here. Chair calls. Chair calls Denise Kendrick.
Thank you. Good afternoon. I'm Denise Kendrick, and I'm here to testify on behalf of Embrace Texas in favor of HB 4161. I'm the founder and executive director of Embrace Texas, and we're located in North Texas. We're a support system for foster, adoptive, and kinship care providers. We're not a child placing agency, and last year we served over 700 children with direct services. All that to say, we interact with a lot of foster parents, a lot of adoptive parents, and a lot of individuals who are taking in their kin. Their feedback shapes our programming. Beyond what's shared by those we serve and the observations I've made in my professional work, this issue is deeply personal to me. I was a foster parent for over a decade as well as a kinship care provider. The risks, joys, challenges, and hardship of kinship care have played out in my family and under my roof. I believe many of our foster care system's flaws stem from an emergency or triage mentality. A child's removal from their parents launches a frantic search for placement, which often, in haste, bypasses or overlooks family members who are willing and capable of caring for their kin. A child's initial foster placement is more than just a place to stay. It's a decision that sets a child and a family on an often unalterable trajectory. Siblings who are separated into different placements at the time of removal are unlikely to ever live under the same roof again. And with every mile a child is placed away from their home community, their chances of reunification decrease. Honorable committee members, these are life-altering placement decisions that must be made with urgency and intentionality. One facet of that intentionality should be an immediate and exhaustive search for safe caregivers from within a child's family or community. I have spoken with many relatives, and I have experienced myself the frustration, shock, and grief that accompany finding out through the grapevine or secondhand that a relative child is in foster care. With an unfamiliar legal process ahead and so many unknowns, a viable kinship care provider may decline involvement if they feel that the child is already settled into a placement. Instead of feeling a kinsman redeemer, they may feel like an interloper in the case. Family first might not be easiest. It might take perseverance and detective work, but if family first is what we believe is best for children, it needs to be a priority, not just in policy, but in practice. With every successful kinship placement, we're building momentum behind kinship normalcy. Improving the way we approach, engage, and support kinship care providers has the potential to create ambassadors, an environment where kinship care is preferred, valued, and successful. It requires the contributions of agencies, the courts, communities, and organizations like Embrace, but it begins with the buy-in and investment of DFPS. Today, I'm here to speak in favor of increased accountability within DFPS. Deadlines and admonishment won't right the ship, but they may create the incremental change necessary to prove the value and validity of kinship care, to build some muscle memory in this area that the department lacks strength and consistency. Long term, I believe the results will speak for themselves. What causes a temporary burden to caseworkers might be the step that creates long-term stability and permanency for children, ultimately reducing workload and recidivism. I believe a culture of urgency, thoughtfulness, and excellence are possible within the department, but we have a long way to go. I'm here to support efforts that keep children in the least restrictive environment. I'm here for what I would want for my own children, the opportunity to be with my people, to stay immersed in our unique family culture, traditions, and support system when they need them most.
All right, thank you. Any questions of this witness, members? Not hearing any. Thank you, Ms. Kendrick, for being here. Thank you for your testimony. Chair calls Cody Taylor.
Afternoon. My name's Cody Taylor. I represent myself, and I'm definitely for this bill. I want to speak on one portion of this. Any state agency who decides to make a decision to intervene in the lives of our families, our Texas families, and take a child from that care and custody should have nothing but to have to report that within a timely manner. 24 hours is, I even think, is a little bit long. Within a matter of 24 hours, a lot can happen if you have the right people that don't understand the situation and have had a history and a habitual history of making poor decisions in child's lives. So what to do now with a fraudulent case that goes to CPS? Is anybody inside that bill going to be pushed to that extreme when there's a fraudulent claim and CPS takes a child away for it being drug abuse, alcohol, whatever that may be? Something to look at, only because it does matter, right? 30 days. Mr. Wu, I appreciate you asking this lady questions, because we all took time out of our days to come testify for this, and it matters. 5 months is too long if you have family members who can absolutely make a difference, and they need to be with family, not strangers. So I'm very much for your bill. I appreciate the time, and
Thank you,
to testify.
Thank you, Mr. Taylor, for being here. Thank you for your testimony. Let's see if there are any questions. Not hearing any. Thank you. That's all of the witness affirmations we have. Is there anyone else here who would like to testify for, on, or against House Bill 4161? Not hearing any. The chair recognizes Representative Barbara Gervin Hawkins to close.
Thank you. Members, I do want to ask you a question, Representative Wu, on that. So what happens a lot of times in terms of where information is not disseminated is according to where the child is picked up. So let's say, for instance, that a child is not picked up at the home where the parent is, that is in the evening, that there was a complaint made, and someone goes out to the house that night, and they pick that child up. The caseworker then has to have that a placement for that child. And so they may place that child somewhere temporary. But remember, the caseworker has how many kids on the caseload. So they feel that they fill that gap, and then that next day they don't go directly to the school or do the research it takes to find out where that kid is. So then another day happens, and another day, and another day. And so then they're finally going to get to it. But if I have a caseload of 100 or more, then that kid right now is not my priority, or that group of kids, because they're somewhere temporary. That's one of the issues. One of the other issues that we find is that the lack of communication, particularly when caseworkers, because they're human beings and they're on the 8 to 5, okay? They're only going to work certain hours and do certain things. And so time goes by, I'm off the clock now, and not everybody's going to put in that extra time and those extra efforts. The other thing is, if you pick up little ones who can't speak to you about where they live, who can't speak to you about who grandma is and where she lives. So there's some challenges with communication, particularly with our little ones. And what we find from the caseworkers, who I believe not all, but mainly took a job to do the best they can, sometimes are overburdened. And so, members, I want y'all to know how important this bill is. I've seen too often kids that are being picked up and parents who are scurrying around, who don't know the system, who don't understand the system, and can't access the things to do to be able to find their child.
Yeah, I think Representative Wu has a question.
No, I appreciate your answers, and thank you for bringing this bill, because I know this is a serious issue, but I do have some questions, but I mean, outside of the $70 million fiscal note, here's sort of like a few concerns. One is all of our CPS cases are confidential.
Yes.
I mean, like, even as an attorney on CPS cases, I can't look at other CPS cases without, like, written court approval. And, you know, sort of the concern is that if you have a parent whose their own case is confidential, and they're like, hey, I don't need my family knowing about my business, right? My business is my business, and my kid's business is my business. So if you have a parent who says, hey, I don't want people knowing about this, I'm going to take care of this on my own. I mean, does this override their right to privacy, their right to have a confidential case? That's just a concern over here. I mean, maybe there's something in the code already that adjusts for that. The second issue is actually more just like how you would make this function, assuming that we can get the money for this and everything else. And I think you mentioned it earlier. Somebody mentioned it earlier. Is that the CPS investigators, who are different from conservancy workers, are not necessarily the best people to do like this type of investigation looking for people. So like my story would be like back when I was in a DA's office, you know, I'm pretty good at tracking stuff down, finding evidence, but I'm terrible at finding people. And we had special investigators who did nothing but track witnesses down and find people. And I would suggest that like if you wanted to modify this bill, is to, instead of directing the employees to do this, is order CPS to create divisions where they have either retired investigators or just hire police investigators who their business is to find people. Because as an attorney in CPS, like a lot of times, if I have a client who is a parent and I think they're going to lose their kids, I want to try to place those kids with a relative too. I'm looking for relatives myself. I'm not really all that great at doing it, but I try, right? But if you have someone who is actually dedicated to looking for people, like that's their business, it may work out better. Because I think if you tell CPS, you have X number of days to go notify everyone, and they're like, well, we tried to look for them, and we couldn't find anybody.
Well, I think, Representative, and that's a fair question. I think the reality is with the amount of dollars that they're getting and the way their infrastructure, their organizational chart, they have to be able to put in place that strategy. You know, and just a simple case I want to give you. There was a family of three that he was two, the little one was two, there was a 4-year-old, and there was an 8-year-old. So the sheriff went and picked up those children, and the parent was not home. So there was a complaint from a neighbor. And so they said the house was dirty. The sheriff went, had the child unlatch the back door, let them in. They took those children. Mom comes home. She can't find her children, okay? So where do you begin to look, right? So now a 2 and a 4 and an 8 who don't necessarily know their address or anything like that, to me, if they should have had someone stay at that house until an adult came home, okay? But no, they collected up those children, took them where they was going to take them, put them in temporary places. The mom is upset and frantic about where her children are. And so the disconnect and the ability for FPS to make these rash decisions is what's hurting the system, okay?
I get it. And I appreciate that. And I know it won't make that situation better, but I want to say that like all the changes that we've made in the last few years hopefully have tried to make some of those situations like that better, where instead of just removing the kids, I think that's probably like CPS's concern is that those a 2 and a 4-year-old being left home by themselves,
and an 8-year-old,
and an 8-year-old being left at home by themselves without any adult supervision, which is concerning. But the right situation to do, maybe in that circumstance, would maybe like talk to mom about, hey, do you need help with childcare, right? Can we get somebody to be with you? Can you help? Can we work out something where you can find a relative to stay with the kids when you're at work? Something like that.
Well, the only way she found her kids, it was on the news.
Yeah.
So they went to the house, and the next thing you know, they called the news, and they said that how filthy the house was, diapers, la, 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 okay, how the house was. But they never spoke on, here's our process. And one of the things I think as we look at the department, who needs help, obviously, we wouldn't have these many complaints, okay, is that maybe if it's not a caseworker or an investigator, they hire these folks that be able to do that day city until they're able to locate and work with. You know, a lot of times from our law enforcement agencies to these type of environments, it is a belief that they can do it on their own, and they can't, okay? As well as families are divisive more today than they've ever been. So we've got to be able to develop systems to be able to capture some of this.
So when CPS, excuse me for cutting you off, so when CPS went into the house to take the kids,
Yes.
there wasn't an adult present?
No.
And CPS took the kids
Yes.
and didn't leave any kind of notice that they were there
No.
and they had taken the kids?
And she, the sheriff, yes.
That's what I mean.
If your kids aren't home, when you call the police?
Well, first of all, you're shocked. You're in shock. Okay, you go home.
Yeah.
And you're shocked because you're telling your kids don't go anywhere. Okay? And then how did the kids get taken away? So now you don't know what to do. Do you call the police? Do you call the sheriff? Who do you call? So now you're trying to figure out, was it a neighbor? Was it a robber? Who was? So you're in disarray, not knowing what to do. And everybody ain't as intelligent as we'd like for them to be.
Well, somebody should have left some indication that they were present in the home and they had taken the children.
Correct.
That should, I mean, that's just common sense. It's commonsensical that, I mean, if you live just about anywhere and somebody goes into your home, they usually leave a notice saying that they have been into your house. And certainly if they went and took your kids, that's the least you could expect.
And I concur, but we know the systems don't always work. And when you're in certain communities, people take advantage of that.
Yeah. Well, the system ought to require that, is what I'm saying, that notification. And that's something we may have to look at too, because, I'm not sure why an 8-year-old, a 4-year-old, and a 2-year-old were home by themselves.
Well, her thing was she was running to the store, so it's almost like, I'm gonna be gone for 2 hours, right? And that 2 sometimes is earning 3. And I want to share something with y'all that's so important. When I first had my children, some odd years ago, right? And remember when babies were being left in cars? Okay?
Still.
And so I think I'm gonna run into this store real quick, and it's only gonna take 10 minutes. So I would be getting out the car trying to think, am I gonna take the baby or not, right? But for some reason, I could never leave my child. I would always, I got to take time to unstrap them and take them. But sometimes folks are in a hurry, and they think they're going to run in for 10 minutes, but they didn't know it was 10 people in line, and it takes longer. So those quick decisions sometimes get us into situations, okay? And so when we're talking about those extraordinary situations, that things occur, but we do believe a system should be in place to be able to make sure that when we're talking about taking people's kids, I mean, think about grandma who talked about 5 months. Come on. But if the kids couldn't tell, where they went to school, or they can't articulate where grandma is, it is very difficult. And the system sometimes just keep pushing these kids on and on. I'm going to get to it. I'm going to get to it. I'm going to get to it. And they don't. That's real.
All right.
And with that, members,
Well,
thank you so much.
Thank you for bringing this to our attention. Any further questions, members? Not hearing any. Thank you. It's the chair's intent to leave House Bill 4161 pending before the full committee without objection. Chair hears none. House Bill 4161 will be left pending.
Thank you.
Okay. Chair at this time lays out House Bill 4715 and recognizes Representative Basut to explain it.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 4715. This bill is filed simply to ensure mothers are provided for in connection with a pregnancy. The bill does that in 5 ways. First, the bill extends child support back to conception and provides compensation to the mother from the father for pre- and postnatal expenses if not paid for. Second, the bill disincentivizes frivolous paternity contests by increasing child support in the case paternity is contested but then subsequently established. Third, the bill increases victim compensation in the case of sexual assault that results in pregnancy to ensure mothers receive restitution, child support, and coverage for medical bills incurred. Fourth, the bill provides victims of sexual assault with access to enhanced priority from the Victims' Compensation Fund. And finally, the bill ensures mothers are advised of their rights under the bill by various professionals, including medical professionals. Happy to answer any questions I can about the bill and respectfully request the opportunity to close.
Any questions of Mr. Vasoot, members? I had one.
Yes, sir.
On page 2, if the person does not or denies paternity, there's a I guess the defendant will have to pay a certain amount of money because they chose to do that.
No, it's if it's ultimately determined, as I understand it, or as it was intended, it's if they contest and are later determined to actually be the father.
Oh, if they contest the parentage. Mm-hmm. Okay. I know. But so, okay.
Yes, sir.
Well, I think I got it. And in terms of the medical expenses, how do you propose that would be determined?
So it depends on which provision it's under. I'm looking for the one that's related to.
Okay.
It's pre and postnatal care. It is
Yes.
defined on page. Top of page 7. So in ordering retroactive child support under this section, the court shall apply the child support guidelines provided by this chapter and on a proper showing order the man to pay an equitable portion of all the prenatal and postnatal health care expenses of the mother and the child. So it leaves it to the discretion of the court based off of the evidence presented.
Okay. All right. Okay. Any further? I think Representative Cook has a question.
Is your bill asking that the court order guideline support? I mean, like the same as if the child was born in...
Correct. Back to conception,
Yeah.
or as near as this can be determined.
Yeah, because I asked this question last week. I mean, I think we all know what the most expensive expense for a child is daycare. And obviously you don't have daycare during that 9-month period. So I'm just curious what the thought process is to charge child support, or guideline child support, and plus the medical expenses.
Well, it is to provide a degree of care to the mother during that period, both the pre and postnatal care as well as an additional compensation during that time period.
We're providing compensation for carrying a child?
Yes.
Is asking for a DA or requesting a DNA, would that be considered challenging paternity?
That I'm not certain on. I don't practice family law,
Okay.
so I apologize if I can't answer that one directly. But the intention of the bill is to crack down on frivolous claims,
right.
challenges, because during that period of time, the mother's not compensated, right?
Right.
So it's to encourage the maximum amount of compensation we can for mothers to be able to care for them.
Okay, I think I got it. Any further questions, members? Not hearing any, we'll give you the right to close and
Thank you,
proceed
Mr.
with
Chairman.
public testimony. Chair calls Brandon Johnson.
Chairman Dutton, I'm Brandon Johnson, represent myself. I am against this bill.
Wait, now, we have you down as neutral.
I would like to change that.
Change that. You want us to change it. So it's with your permission, and we're changing your designation from neutral to against. Is that right?
Correct.
Okay, thank you.
All right, thank you. This bill is similar to the two that were heard last week. This bill incentivizes promiscuity with women. Nobody's getting married right now. There's no benefit to getting married. And the birth rates are down. We're not really seeing it in Texas because of everybody moving here, but that is the case. Everybody's worried about overpopulation. Or not having enough people is going to be the next crisis that we're going to be facing. And a large amount of this is due to what I'm just going to spit out some stuff here. It's the cash prizes and custody incentivization of single motherhood. And, I don't know what he's, and look, I have, Representative Vasut has been supportive of us in the past. And I apologize for not talking to him prior to this hearing. But all this bill does is reduce a man to a paycheck. And they want to saddle us with the responsibility, or saddle men with the responsibility of a paycheck, but not with the benefit of actually being a father and raising a kid. So without some type of equal custody from conception, or not from conception, because that wouldn't be possible, but from birth, I would be against the bill. And basically, if you feed stray cats, you get more stray cats. And I know that's a blunt way to put it, but when you incentivize these women to have children, they're the ones. I know y'all passed this bill, or it was brought up about. I'm sorry, Ms. Jones, but it's the truth. Now the abortion's illegal or whatnot. Women still have ultimate say over having children, birth control, and such. Thank you.
All right, thank you, Mr. Johnson. Any questions, members? Not hearing any, thank you. Chair calls Charles Sways.
My name is Charles Stephen Cease. I represent myself and my family. I'm testifying against this bill. I was neutral up until I heard the point that challenging paternity, or possibly even asking for a DNA test to confirm that child is mine, would be punished. I think that's a valid question that these days every father needs to ask. Thank you.
All right, thank you. Any questions of this witness, members? Not hearing any, thank you for being here. Chair calls Joel Rogers. And you're just a resource witness, right, Joel?
Yes. Mr. Chairman, members of the committee, I'm Joel Rogers with the Child Support Division of the Attorney General's Office. I'm Associate Deputy Attorney General for Child Support and Legal Services, and I'm here as a resource. We did attach a physical note to this bill. It was based solely on the unique interest accruals that were created in Section 6 of the bill. It's something our mainframe system, it would require us to calculate interest differently than we calculate current retroactive child support or current child support or anything that we do now. So the fiscal note is based on that. If it went back to just calculating interest on the retroactive child support judgment like we do now, then that would be eliminated. There were several concerns that our agency has expressed with some of the wording of the bill that may have created some unintended consequences. In Section 6 of the bill, because it creates a new section for retroactive child support, that just for cases where there's paternity findings and acknowledgments of paternity, those rules would apply to those type of cases. But because it uses the word man, that could create a situation where we have cases where the father may have never been established legally, but he does have the child post-birth, and we're concerned that could the wording of it could eliminate the ability of a man to get retroactive child support post-birth from the mother of the child. So there's some ways you can fix that. There's also a concern that it treats children born of a marriage different than children born outside the marriage, because the section establishing retroactive child support from conception applies only to acknowledgement of paternity cases and only to and also to paternity acknowledgement of paternity where you sign that, or if you're litigating the paternity. We have cases where the parents are married, but let's say the father leaves the moment he finds out his wife is pregnant. This would exclude those types of cases because there's not a paternity. We're not trying to establish paternity, and an acknowledgement of paternity most likely was not signed if the child was born of the marriage. There's also a couple other, to answer the question that came up earlier about the procedure to get a DNA test. Typically, you have to contest paternity to get the court to order a DNA test. So I don't know that was the intention of the to charge 150% of the child support obligation in those cases. But typically, in order to get the court to order a genetic test, you have to file a denial saying you're not the father and you want the court to do that. Most courts in the Title 40 courts, most of our judges actually encourage people to request paternity testing if they have any doubt that they're the father. In fact, in our caseload, we did about 15,000 children last year conducted paternity tests at no charge to the folks that are utilizing our services. So I am concerned a little bit that the wording of the statute might make some judges think that you have to pay more child support if you ask for a genetic test.
Okay. You said something that piqued my attention. You said that if the man has the child, he might not be able to get the sort of medical for...
Well, I think what I was trying to say was that because it creates a new section outside of the existing retroactive child support section in the family code, it creates a new section for cases where there's acknowledgments of paternity and where there's an AOP or there's a paternity is being litigated. That because it creates a whole new section, it's not tied to the other section. It would seem to indicate, and they use the word man is entitled to retroactive, a man would have to pay retroactive child support. Because it uses the term man, that could, some judges could read that to say, well, I can't ever order a woman to pay retroactive child support in these types of cases, even post-birth.
Yeah. Okay, I got it. We'd have to fix that.
And we'd be glad to work with Representative Vassout's office and we've already been in contact with them about some of these concerns and submitted some suggested fixes to that. So we'll be glad to keep working with him on that.
All right. Any further questions? I think Representative Cook has a question.
I don't see anything in the bill. I know that Representative Vassout, a while ago, he kind of paused a little bit when he said he doesn't practice family law, and I get that. I don't see anything in the bill that says if you contest that's when this applies. I mean, in fact, I see it says the opposite. It's Section 6, where the new section for retroactive child support is. It talks specifically about Chapter 160, which I think you were just talking about, but it says notwithstanding any other provision of the chapter or other law and order in any order rendered under Chapter 160 establishing a man's paternity of a child or in any suit to establish the child support obligation of a man whose paternity has been established by the execution of a valid acknowledgement of paternity. So I think what this bill would call for is regardless if you acknowledge that you're the father or if you ask for a paternity test, they're going to ask you to pay child support when there's really no other expenses other than medical.
The concern we had was in Section 7, where it rebuts the child support guidelines and says that you have to pay 150% child support if you contest paternity, which typically is the way you get a paternity test in court.
Yeah, so it just seems to me it seems to contradict itself because it is talking about the AOP that you brought up as well.
And the case you also talk about on where there's a presumption of paternity. That's, how is that treated in here?
Well, the bill addresses the conception, child support retroactive through conception, only on cases where there's the party assigned an acknowledgement of paternity, or if we're adjudicating paternity, which you don't do in married and divorce cases typically. So in those cases, we don't, we file it as a different type of legal action, as a different title, because we're not trying to establish paternity.
So this would exclude those cases?
Under our reading of the bill, I don't think that was intended, but I think that could be an unintended consequence from the language, the way it's worded.
All right. Any further questions, members? Thank you, Mr. Rogers, for being here. Chair calls Jeffrey Morgan. Did I call David? No, that's it. I didn't think so.
Thank you. My name is Jeffrey Morgan. I am against this bill. I'm speaking on behalf of myself. There was one point of clarification I would like to ask, though. Is this bill for the establishment of paternity only in cases of sexual offense? The way that it's written, it's very unclear. It can be read ambiguously. So is this only in situations where there is a sexual offense that occurs in pregnancy or not? It just is not very clear the way that it's written. As I see it right now, if it's talking about the paternity, if it's talking about a sexual offense, it says 200% if valid acknowledgement of paternity, and then 350% of the defendant contested the parentage. I think that deprives him of the due rights of due process to actually, as people have been talking about, to find out whether he actually is the father or not. I'm very concerned about this idea with the acknowledgement of paternity. I think that there should just automatically be a DNA test to make sure that that's being done, because of the acknowledgement of paternities, people can be almost forced to acknowledge paternity when they're not the father. I don't know, as far as this page 3, it talks about him getting out of jail, I think, and then he would have to, if he's confined or imprisoned, I don't know how he's going to be able to get out of jail from this imprisonment and get a job right away. I think that just the fact that he's been imprisoned for some type of a sexual offense would almost eliminate him from a number of jobs that would enable him to pay child support. Compensation of the victims of the crime fund, I don't know anything about that. I'd like to know more about that. But the other question is, what is the proof of the crime? And I have to go back to a couple of cases with this. I think about the Duke Lacrosse rape case that took place, where basically the entire country held several people to be guilty without any evidence on the allegation of a person. What about the situation where there is two people that have consensual sex, and then the next day she says, oh, I was drunk, I woke up, and I was raped? What about the time when, in my time in the military, this goes back to 1992, I heard about a case with one of the women who visited the soldiers, loved having sex with soldiers, had sex with about 12 or 13 that night, and then when it came down to the last one, said, no, I withdraw my consent, and he was going to be charged with rape. What about female teachers who have sex with their students, and how does that work into the whole thing there? So I don't. There's some things with that I just don't know what the proof is as far as the actual offense taking place. I do want to make sure that the individual who has been accused actually has some type of due process, and actually the proof is solid. With retroactive child support, I'm just not sure why all these bills are having retroactive child support. That seems to be crazy to me. But anyway, if I understand the bill correctly, and I'm not sure that I do, because the first sentence is a little bit ambiguous, whether it's to any pregnancy from a sexual offense or just any pregnancy period, I just am not sure. But I'm against this bill.
All right, thank you, Mr. Morgan. Any questions, members? Not hearing any, thank you. Thank you for your testimony. Chair calls David Green.
Thank you, Chairman and members of the committee. My name is David Green, and I am testifying on behalf of myself, and I am opposed to this bill. Similar to last week, I won't go through my whole speech from last week, but this bill, and I didn't catch it on the first reading, I thought it just related to cases of sexual assault. But now reading it again, it appears it's for all cases. It will be for retroactive child support using the section of the Family Code 154.0091, which is the child support section. And those guidelines for child support were not based off of a child who was not born yet. Those guidelines were based off of expenses like childcare, food, and other related expenses. So there's really no basis or study for using the guideline child support for retroactive child support back to conception. I am in favor of including some sort of splitting the medical costs, but utilizing the Family Code section for child support, I don't believe is appropriate. Thank you for your time.
All right, thank you for your testimony. Any questions of this witness, members? Not hearing any, again, thank you for being here. Is there anyone else here who would like to testify for, on, or against House Bill 4715? Not hearing any, will Chair recognize Representative Pursuit.
Thank you, Mr. Chairman, members of the committee, and the witnesses for testifying. I certainly will work on this bill, to bring you a substitute, address some of the things. Low-hanging fruit, of course, is to address the contest of paternity and not having an enhancement when you do. Generally, the import of this bill is I'm pro-life. I believe that every single human being is made in the image of God and has inherent dignity and immeasurable worth from the moment of conception. But I'm pro-life so much so that I think, we need to take care of moms. And I think if you're convicted by a jury of your peers beyond a reasonable doubt of sexual assault, I'd probably put you under the jail cell. But since I can't, then I think we ought to hit as hard as possible. And this bill is designed to do that. I also think that I'm old school, guys. I'm old school.
All right.
I think a man owes an obligation to take care of his spouse, or if he gets someone pregnant, the mom. I think he does. I think that's morally required, and I think this affirms that. And but happy to work on the language and improve it, and of course to address some of the concerns that were raised. I do agree with those.
All right. And just to confirm what the one witness raised, and that is this only applies where the pregnancy results from the criminal offense of sexual assault.
Sections 1 through, I think, 3 are for that instance. The rest of the provisions of the bill deal with, there's 2 sections that deal with notice of rights.
Okay.
And then there's 1 or 2 other sections that deal with basically the bills you heard last week. They're very similar, if not identical, to those provisions, which is retroactive child support to conception, generally.
And that retroactivity applies to all pregnancies and not just pregnancy resulting from sexual
Correct.
offense. Okay.
Correct.
All right. That's what I thought. Any further questions of Mr. Pursuit, members? Thank you.
Thank you, Mr. Chairman.
Mr. Chair's intent to leave House Bill 4715 as a matter of pending business before the committee. Without objection, the chair is done. Chair lays out House Bill 4355. For committee substitute 4050. The chair lays out the committee substitute, the House Bill 4355, and asks Representative Wu to explain it.
He has a sub. He has a substitute. I can remember.
But he's, oh yeah, that's right, the one we saw.
It's fine, I can do it.
The one we saw.
Lay out the committee substitute.
I did, I just did.
Oh, I thought it was.
Members, this is a very simple bill. The code allows for the interview of children, originally, as it says in a code, in chambers, meaning the judges' chambers. All this legislation does is just saying that the court can interview the child in another location generally used by the court. I know that some of our judges don't want to have interviews in their private space and would rather do it in a closed courtroom where they tell other people to get out. I think this is just providing just a little more leeway for judges to do what they need to do. That's it.
Okay, all right. Any questions of Mr. Representative Wu, members? Not hearing any. We will start down the public testimony now. Chair calls Brandon Johnson.
Brandon Johnson, neutral on the bill, testifying on behalf of myself. I believe the bill, I think it's a good idea that it remains, I think it's a good change overall. The only thing that I think should be added that we talked a lot last week was just record the interview. But I think that's in there as well. So as long as it's recorded, whether it's in chambers or, I would think the judge would be, they don't like to interview kids anyways, but it's always just kind of nervous. I know a lot of parents want their kid interviewed. What does he want? And to me, the only reservation I would have is if you have two parents present and the kid's having to pick between one of the parents. I think it just puts the kid in a precarious situation. But I think if it's recorded and it's done with that, in mind, that it would be a good bill. Thank you.
All right, thank you, Mr. Johnson. Chair calls Cody Taylor. Cody Taylor going once. Twice. Okay. He was neutral on the bill, but will be shown as not testifying. Chair calls Carlos Salinas.
Good afternoon. My name is Carlos Salinas. I'm testifying on behalf of the Texas Family Law Foundation. As I mentioned earlier, I'm a family law attorney in town. I do want to say I completely concur with Representative Wu that this is a very simple bill, and I think today I'm only testifying on very simple bills. I think it's important to make the children as comfortable as possible, which I think the judges are making a great effort to do. Chambers isn't always the best place. Sometimes they've got a special room that they like to use that for. So I like the bill very much as written. I do know there's a committee sub offered that we had some feedback on, and we want to thank very much Representative Wu for working with us on that. He's always been fantastic to work with. On behalf of the foundation, I can say that. The committee sub would automatically seal the record that is made of the interview with the child. And the reason for that, while I think it's probably quite apparent to anybody who's been involved in any sort of a family law case, is a parent could use that in these acrimonious cases to really let into a child, and we just don't want to see that. Now, for those of us who are concerned about the record for the purposes of appeal, if there's a notice of appeal, then the record would be automatically unsealed, so there wouldn't be a problem with that. So I think the bill, all told, is a good one. We ask that it be voted. Thank you.
Any questions of this witness, members? Not hearing any. Thank you, Mr. Salinas, for being here. Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am representing myself. I'm actually speaking against this bill. I do not support it as is right now. What I would say in section 2F1 that the court should not say the court may, but the court shall record. I also believe that that the record should not be sealed. The parent should be able to see it, and I say that based on what I've seen take place in the court so far, where judges have interviewed a child in chamber and then never let the parent know exactly what was being said and basically hid that. And according to the child said something other than what the judge said. I don't, maybe that thing about sealing the records or unsealing the records, maybe that addresses this issue. I do not know that. I'm also concerned, and this is not 100% with regard to what Representative Wu said, to determine the child's wishes, that almost leads to the parentification of a child. I have real concerns with that because a child is a child, a parent is a parent. Child needs both parents. I think it's very almost abusive to make a child have to choose which one do you wish to live with. I think that can be very traumatic for a child as well. So I am not for this bill. I already know that part of this is established, and I understand that the intent is to try to make the child more comfortable. From what I've heard here, that's my intent. But I still am against it. I do think that the parent should be able to see the interview and not just rely on the words of the judge.
All right. Thank you, Mr. Morgan. Chair calls Delilah Crosby.
Hello, my name is Delilah Crosby. I'm representing the Crosby family, which is my family, and I am for this bill, but it could use some changes. Overall, this is a common sense bill. We should be recording what these children are saying. I personally have had experience with this. My bonus daughter actually did have an interview with a judge, and the first time around it was recorded but sealed. The second time around they changed it. They did not want that one to be recorded, and it was also sealed. Well, the judge's notes were sealed, shall I say. The reason why I believe this is important is because the first time around, our daughter had not seen us for 1 year and 9 months because of mom, solely because of mom denying access. This child then told the judge that she wanted to see us, and just like that, after 1 year and 9 months, she was given right back to us. Within a month, the mother started a CPS case and claimed sexual abuse. She put the child in counseling and said the child was having a hard time dealing with being a Black child. And the child went through multiple investigations, multiple interviews, and multiple counseling sessions. Both CPS and the counselor determined that the mother was the issue in the case. Yet, the judge did interview the child again, this time this time not recorded, and suddenly turned around and terminated my husband's rights to his daughter. So that is why I'm in favor of this bill, but I do believe that some things need to be changed in this. There should not, if there's going to be a sealing, there should be some sort of access to Department of Family and Protective Services. I believe counselors should be able to access these things because judges do not know if a child is being coached. They do not know the psychological damage that has occurred, but there are professionals who can determine those things just by watching these interviews and what the child has said. Because my child went through 2 different interviews, it would have been clearly easy to see that the CPS investigation for sexual abuse and the counseling for saying that she had problems was the cause of her changing and basically affirming what her mom wanted in the courtroom. So I do think that that needs to be switched, and it should also say that it's required that all child interviews are recorded.
All right. Thank you, Ms. Crosby. Thank you for being here. Thank you for your testimony. Let's see if there are any questions. Not hearing any. Thank you again for being here. Thank you for your testimony.
Thank you.
Is there anyone else here who would like to? Oh, okay. I think Mr. Taylor was not here when I called his name, but the chair will now call Cody Taylor. Testifying neutrally on the bill, right?
And the reason why, Cody Taylor for myself, and I would love to change this, Representative Wu, to 4 and strongly 4. I testified last week to 4062 Harris's bill, and there's a reason for that. We're humans. We sometimes...
Wait. You want to change it to what now?
No, sir. Let me state that again. I'm neutral.
Okay, you are.
I want to change it strongly for what he's doing and what he's advocating, with the caveat the same as Ms. Crosby. I think that it should be audio and video recorded for the multitude of reasons. Anybody who's dealt with family court or anybody who's dealt with the judicial system knows that some things can be biased, some things can be coerced, along with judges make improper calls. My specific case was a judge who's not a mental health professional decided to take what another professional said and claim it as an outcry. Can't do that. There was no reports to law enforcement. There's no reports to CPS, DFPS, nowhere, which is mental health is mandated to report. When you do things like that and a judge can just make his own determination with discretion, we have issues, because when my daughter then went to a child custody evaluator, everything that was stated prior to that to the mental health professionals was not accurate to what she told them. He believed that the child was being genuine with him, and the statements made to the other professionals was not. It was coached. It was woodshedded. I would ask that this be added to this, that is audio and video recorded, along with the way that we worded it in 4062 for Mr. Harris' bill, because you can clearly see what's going on. The same goes with sealing any type of records. I don't think that should be 100% sealed until the issue itself. Child custody case, once it's filed, it remains open. It just gets another letter at the end. So if you're sealing it for one, and then we have clearly non-res judicata issues, then they need to have access to that recording. That's my personal experience. I don't know what everybody else has, but it's similar to what Ms. Crosby in the sense of it. We have an issue. The only way that this is going to happen in a better long term is both parents having equal rights, duties, and a possession to them to start with. The second one's going to be is that there's recordings of what's going on behind so-called chambers or in certain capacities with mental health professionals. So, Mr. Wu, I think it's a great start. I do think that we need to add some audio and video to that. There's a camera in the corner. None of us pay us any attention that people are watching us all over the place. Press and record does not affect a child whatsoever. And any mental health professional that decides to tell a child, hey, I'm going to record you, that's already starting an abusive pattern, because now they feel that they have to do something that maybe they didn't want to or somebody told them to do. That's my personal experience. Thank you.
All right. Mr. Taylor, thank you. Any questions, members? Not hearing any, thank you for your testimony.
Appreciate it.
Again, is there anyone now who wants to testify for, on, or against House Bill 4355? Not hearing any. Chair recognizes Representative Wu.
Thank you, Mr. Chairman. And just to briefly clarify, the ability to record is already in existing statute. If you look in the statute, the unmodified portion of the bill says on a motion of a party, amicus attorney, or the attorney ad litem for the child, that the court shall cause a record of the interview to be made. So it's good news. It's already in there. And with that, if there are no questions, I'm happy to close.
Oh, but no, you can't talk, speak, sir. The chair's intent is to withdraw the substitute for House Bill 4355 without objection, and House Bill 4355 will be left pending before the full committee. Chair at this time lays out House Bill 1520 by Representative Canales. And there is a committee substitute, so the chair lays out without objection the committee substitute, House Bill 1520, and asks Representative Canales to explain it.
Thank you, Chair Dutton, Vice Chair, committee members. Generally, my layouts are relatively short. This bill does not permit that. So House Bill 1520 is a sunset bill for the Texas Juvenile Justice Department and the Office of Independent Ombudsman. Members, the sunset process offers us an opportunity. It's time as we as lawmakers can dive more deeply into the agency's operations, and we typically have a capacity for and make necessary changes to improve the lives of everyday Texans. As this committee has discussed, change is absolutely necessary at TJJD. This agency seems to have been trapped in a cycle of instability since its creation in 2011. Over time, longstanding staff shortages, fueled in part by chronic underinvestment by the state of Texas, have heightened safety risks, decreased access to rehabilitation, and prevented greater focus on diversion efforts. This committee has heard the stories of what high turnover looks like in practice. It's forced facility lockdowns, which in turn increase youth dangerous self-harm and aggressive behaviors. It's overburdened counties where youth must wait months until TJJD staffing levels are safe enough to transfer them into state's custody. And it's burned out our remaining employees, perpetuating even more turnover. Pay increases and operational changes have improved staff retention in the last few months, and ended the need for 20-plus hour facility lockdowns. But more work is definitely needed to break the cycle of the scandal, the reform, and fatigue, and more scandal after scandal. Many proposals have been put forward to get our juvenile justice system on track, but they've all have the same goal. We need to take thoughtful steps towards expanding regionalization reforms that were designed to keep the youth closer to home. We know regionalization works for our kids, but TJJD and counties need more support to push these reforms to the next level. That's what you will find in this bill. It advances regionalization by requiring TJJD to partner with universities to map available resources for justice-involved youth, requiring TJJD to update its regionalization plan biennially with options for building out capacity and county capacity, and authorizing TJJD to incentivize county-level diversion and collaboration through grant making, and requiring counties to apply for state diversion funds before committing youth to these state facilities. Among other changes, the bill also revamps the agency's governing board to jumpstart the engagement. It aligns TJJD's regulatory practice with best practices and updates the OIO statute to clarify its oversight authority and increase its access to information related to youth rights. Finally, the bill sets up to continue making meaningful, iterative changes towards moving forward. The bill continues TJJD for just 2 years and requires Sunset staff to conduct a limited scope review next biennium on the agency's implementation efforts. TJJD continues to stabilize and the county capacity expands. The demand for the state beds will fall. Staffing pressures in the state facilities will decrease, and Texas will be in a better place to right-size those facilities. Lasting change takes time. But creating a pathway for improvement is exactly what the Sunset process is here for. This bill will help take Texas to make concrete steps towards modernizing our juvenile justice system and increasing safety for our youth, state employees, and communities. I want to thank the Sunset staff. They are also here as a resource, and I'm happy to answer any questions.
Representative Wu.
That was a long layout. I want to see one of the short ones. No, thank you for working on this. I know this was a lot of work. Appreciate it.
Members, any other questions?
Yeah, let me ask, how's the board changed in here?
So I'll let them answer.
Oh, that's right.
So I've got a resource
The
witness.
staff is here, yeah.
Yeah, but
okay.
I've got the answers to some of the questions.
All right, because
it is a large bill.
yeah, I know, and it's I guess it represents a fairly significant change to the agency. And because one of the things
I do have the answer to your questions. The bill reduces the board size from 13 to 9 members. It reduces the number of county commissioners on the board from 3 to 1, and the number of public members from 3 to 1. It also allows for one mental health professional or an LMHA representative, one certified educator, or a juvenile justice professional with experience managing the facility. It does not reduce or alter board member slots reserved for 3 juvenile probation chiefs, 1 juvenile court judge, and 1 juvenile court prosecutor.
Okay, so the maximum number is 9 now.
It's going to be 9.
It's going to be 9. You know, one of the things we continue to hear about is the over 50% turnover rate for employees at the agency. What do we do about that, if anything?
So I believe the bill, because of many of the changes, and we've already seen some of the implementation, we've already seen a decrease in turnover. So I know in 2015, we passed a bill requiring TJJD to develop a regionalization plan to keep kids closer to home. Right. That also helps the retention. But I will let the Sunset staff talk to you more about what they've done and what retention efforts have been kept. But it does improve staff shortages. There's provisions designed to expand, like I said, the regionalization and build capacity at the county level. Additionally, removing subjective and prescriptive certification requirements for local certified officers opens up opportunities for counties to hire more qualified staff and keep the youth shallow in the system. So legislators weighed in on other turnover fixes like pay raises through the budget process, but that wasn't necessarily, isn't covered in this bill.
Okay. Let's see who we have here from the agency. From the Sunset staff. I can't see who that is now.
Do you need me to come staff you?
Nobody came. Oh, okay. Have you registered?
Yes.
What, tell me,
Rachel Gandy.
what's the name?
Rachel Gandy.
Yeah, I know, but I don't have that for some reason. Thought that's who you were, but for some reason it's not
Maybe it didn't go through.
showing up here on 1520. I'm not sure why. Let's see if I'm trying. She's
Rachel,
yeah, but it's not on here.
I thought she registered not to.
I got the boss.
Perfect.
Oh, she ready? Okay.
We have counsel here, so
All
we're
right.
okay now.
All right, Rachel, we show you as having registered not to testify.
I'm
But-
just here as a resource.
Okay, thank you. We'll change that to showing that you testified then.
Perfect.
Question, what do we do about in the bill and in the, I know there's an amount of money in the appropriations bill that, I've forgotten what the final amount was in the House side, but the House and the Senate were somewhat different.
Sure.
Yeah, and so part of what we had to address and the need was related to the turnover rate. What did we do about that?
Sure. So I'm Rachel Gandy, Sunset staff, and I'm on the bill, just for the record. So we tried to, through the Sunset process, take an approach that was iterative and that used different parts of the legislative process. So as Chair Canales had spoken about, the budget included some funding for the agency to then raise salaries so that they would be able then to retain more staff. They've already seen then some decreases in their turnover, as the chair also mentioned. And some of the ways that's impacted youth would be like when we published the report back in May, youth were only spending about 35% of their time in normal programming. And so that's 14 hours a day that they're in a schedule of receiving treatment, school, recreation, that type of thing. Only 35% of the time. Last month, that became about 90%. So they have been able to staff up. I think they're about 75% staffed at the moment. What this bill does is then sort of take us from getting stabilized through the staffing process to then moving forward so there's less demand for those facilities in the first place and therefore relieves some of the staffing pressures that exist. And that's largely through the regionalization reforms that the chair
And how many children do we think that'll affect?
Regionalization?
Yes.
It really depends on the capacity that counties are able to build out. So what this bill does is first figure out which are the services or the programs at the local level that we're missing right now, so that the state can then help counties to intentionally fill those gaps, and then more youth can be kept closer to home. What I can say is the original regionalization reforms passed in 2015, and since then, using state funds, there have been about 1,200 kids who have been able to be diverted from the system, from state custody, and those are kids who otherwise, by definition, would have been coming to the state.
1,200.
So that was the first money would have gone out in 2016,
Yeah, 20.
and that was by the time we published last May.
Right. So so do we have an estimate how many we anticipate keeping out of the system now?
So the agency has a target of 245 youth annually, and that's based on the funding that they've had.
Okay.
With this increase in funding and with building out county capacity, that should decrease the amount of youth coming to the state, but I don't have an estimate for you because it will depend on the types of programs that counties develop.
So is the whole program hostage to what happens at the county level?
So the counties already are maxed out, and that's sort of the problem. Yeah, I think what you'll probably hear from other folks testifying too is that we've hit this sort of stalemate. Counties are already handling 98% of referrals to the system solely at the local level. So, and they're also dealing with staffing issues. So they need some greater support and greater ability to expand their capacity so they can take on some more youth. I think what we were trying to do through our recommendations is be really iterative and really thoughtful in the approach of decreasing commitments to state custody and keeping kids both closer to home and in their communities rather than in facilities. But in order to do so, you have to build out those resources first. So we want to avoid some mistakes from other states.
So what should we expect?
What should we expect from regionalization? Yeah. I think step one is the developing the regionalization plan and having that updated biennially. So before it was done in 2016, it wasn't updated again until I believe December is when that new one came out. So the first step is figuring out where are our gaps in resources, and then the agency through its grant making process will be able to help counties to actually fill those gaps through discretionary state aid.
And so how, I guess what I'm asking is, how far along with regionalization should we expect to be after this legislative session is ended?
It truly depends on the funding that's going to go to the agency that they then dole out to counties. What I will say, though, is counties are ready. They've already been working on this. They've already been partnering with the agency, and they've already identified where some of their gaps in programming are. I think one of the ones that stands out is programming for youth who have violent treatment behavior needs, for youth who have sexual behavior treatment needs. And so by identifying what those gaps are, it will allow the agency to then provide grants so that counties can fill the gaps.
So counties are the real linchpin
in the juvenile justice system in general. They're really carrying that burden.
And certainly in terms of our effort to increase regionalization.
Absolutely.
And so we've got to do something to help counties get out of the box they're in.
Mm-hmm. And that's what we're trying to do with this bill, trying to give them more support, trying to give them more options, trying to develop more incentives for collaboration across counties. That's what you'll find in HB 1520.
Counties will say what you didn't say. We need more money.
That's in the budget.
It's in the budget.
I know.
And there are significant increases in funding. This is really and truly the largest investment the legislature has made in the juvenile justice system since TJJD was created.
Right, and that's what I was getting to, that we expect the counties to live up to the agreement that we have with them insofar as us, the legislature, actually putting money, a significant amount of money, into the counties.
Yes, but the programs that they have put in place so far are working. The youth who have been kept out of the system using regionalization dollars have, I believe it's an 85% or greater success rate, and then being discharged from those programs without ever having to come into state custody. The programs work. There's just not enough space in them to have even more youth stay there right now.
So in the whole system now, in TJJD and the facilities at TJJD, how many juveniles do we have?
In the TJJD facilities, the average daily population last fiscal year was around 600. But there's also what's kind of missing in that number is there are about 100 youth who have been committed to TJJD.
We haven't gotten there.
Right, that are still at the county level.
That's right. And so that's my next question, though, is the county kind of, in terms of the regionalization plan, how is that 100 going to affect them?
So, and that's sort of what I had talked about in like taking thoughtful steps throughout this process to really stabilize the system. So step one that we discuss in our report is stabilizing state secure facilities in terms of their staffing. That then allows for those 100 youth to actually come into the system. And the agency has been working on that. I think at its peak, that wait list was 165 youth. So it's down to about 100, which is still high. but they need to have more stable staffing in order to bring those youth in without having to resort to the lockdowns that y'all have heard about since the beginning of this session. So once that is able to happen, then the shift toward this regionalization group that's discussed in the bill and the tasks that they have to go through to identify the gaps can really be the focus.
Well,
But recently it hasn't been.
That's what I'm getting at. I'm
Yeah.
sorry. But we've got to solve, before we end up trying to impact the regionalization plan, we got to figure out what to do with the hundreds that are waiting.
Yeah.
And so if we don't figure that out, we don't ever get to the point where we start to developing the regionalization plan.
So in order to take those 100 youth in, they have the physical beds. It's just a staffing issue that they're not able to bring them in and maintain federal standards for staffing ratios. And so it's with some of the changes y'all are making through the budget, as well as operational changes the agency has made, that they're able to now staff up. So instead of being at 200% capacity that they were last summer, they're now closer to 140. Still difficult because they have more youth than they can actually put into facilities, but it's getting better. And counties are working through the advisory council and by partnering with the agency to get moving on regionalization as well.
Well, all of the moving parts
There are a lot.
right now seem to be working against the regionalization effort.
You mean because their youth still waiting at the county
Yes.
level?
Yes. And so while we sit here, members, and we'd like to have regionalization not only begin, but accelerate.
Right.
That's not going to happen until we resolve the problem of the waiting youth.
Correct, which can't be solved until they have more stable staffing.
Right, which can't be solved until, and the way we're going to solve that at the moment is we're increasing the salaries
Substantially.
And we hope that's going to change that whole ratio.
We have seen success in that in the past with this agency. And then last summer, the agency was able to make permanent a 15% pay increase with the help of the legislature.
Right.
That's when we started to see a shift. And so I think of the summer really being this critical point where the agency was kind of in maximum crisis. At that time, about 56% of new hires were leaving within 60 days. So they weren't even getting to the floor of the facility to actually supervise youth. After that pay raise went in place, pretty quickly after that, that dropped to 23%. So they're starting to see those improvements. They haven't had to do a full lockdown since October, but the pay increases that are then discussed in this budget will help them get to the next level. And then again, there are operational changes they've made too to retain.
Yeah, that's what I'm going to mention too, because part of the problem has to do with the working conditions that they were facing, given the overall shortage of employees.
Right.
Okay. I think Chairman Lujan, and then we'll go to you, Representative Tallarico.
Thank you for being here. A question that I have: who's driving this initiative? Who's like in charge of this whole regionalization plan and movement?
So the agency is required to develop the plan, but they do that in partnership with counties. So they have an advisory council on juvenile services that already exists, and that's made up of county representatives that the board leans on quite heavily to help them figure out how can we better support the probation field.
Okay.
But then there are also requirements in the bill of the different folks, including youth advocates and folks who have been, who have actually experienced the juvenile justice system, so they can get their views as well.
Okay, so then we should be able to see individual project plans of this being from county to county to county, and those are going to vary on different degrees, right? Because my whole thing is we just throw money at it, and then, man, I would love, from a business perspective, I would love to see a project plan. Like, we're going to be here at this time, we're going to be here at this time. I don't know if we have anything like that. I know it's my first session and first time on here, but I think if we don't have something like that, what do we work toward? And that's what's done in business, and I think it would work ideally here because we have our goals, we're doing our analysis, we'll look for the gaps, begin to plan for those gaps. But unless we have something physical to look at, and it doesn't have to be set in stone, because in business those things change. But as we develop here, then we can, shift it. Do we do anything like that?
Absolutely, and that's a really good point because the juvenile justice system looks different based on where you are in the state. And so what the regionalization plan does is it divides the state into 7 regions, and then it really looks at what are the gaps in services within those regions. There are some, I think West Texas doesn't even have a post-adjudication facility for youth. At least right now. And so when the first plan was published, and the agency may have more information here, what happened was they divided the state into those regions, and then they also gave some money that allowed the regions to really make their own call on what is it that you need that will benefit your youth. So there are some that used that money to invest in telehealth services, others in aftercare services. It was really individual to that region. And that's really already how the system is set up.
And those
They already
regions-
have those regional associations that work closely.
And those regions, and just so I can get an understanding, they don't work in silos, do they? Do they work for best practices so they can utilize the things that are successful, stay away from the things that are not successful? Are they coordinated? Are they working together for that?
So 2 thoughts there. First, the counties do work together all across the state, because the reality too is that you may have a youth who, say, is in West Texas and has some sort of treatment need. In order to avoid coming to a state secure facility, there may be another county that has the services they need but isn't necessarily in their region. So they're working with, maybe folks in Houston who might have that treatment service, and that's where regionalization dollars come in. So that coordination does occur. One of the things that we found is because the agency has had to focus so much on essentially putting out fires in their state secure facilities just to keep youth safe, because that's really at the end of the day what everyone is interested in. They weren't able to maximize the benefits of regionalization and complete all of their legislative duties when it came to this reform. And one of those is sort of what you're talking about, making sure that we're monitoring the performance of different programs and then providing that information to counties so they know what mistakes to avoid, what programs to move forward with. And so that was actually, it's not in the bill, it was a management action to the agency to make sure that they're able to fulfill those pieces as well. And the increased funding, again, will help the agency do so. They have some new positions they're trying to fill for that.
Thank you. Members, any questions? Mr. Talrigo?
Thank you, Mr. Chairman. And thank you, Rachel. Thank you, Chairman Canales, for this bill. There's a lot that I'm encouraged by in this bill, and I think we are trying to move in the right direction, which I'm excited about. But I do, as I bang this drum every time we're having this conversation, is I want us to zoom out.
Sure.
Because my first session, I was here in the 86th legislative session, and Joe Strauss was speaker, and I remember I was freaking out about something as a freshman, and he said, "Don't worry, we've done this 85 times before you got here." Right? And I think it's helpful for us, especially with this problem, to realize committees like this have been coming together and saying these things over and over again. I think Chairman Canales mentioned the cycle of scandal, reform, scandal, reform. Mm-hmm. And you detailed some of that in your report.
We did.
And that's just for TGJD, which has been around for a little over a decade. Mm-hmm. Before that, it was Texas Youth Commission, which had a lot of scandals. Before that, it was Texas Youth Council, right, in the 50s. Right. Mm-hmm. So I do want to just make sure we all understand that this cycle of reform and scandal has been happening for more than a century. Mm-hmm. And people have been saying, well, we got to just add some more money and we got to, Band-Aid after Band-Aid, right? What I appreciate about this is that it does seem to be thinking, is the model itself not working, mm-hmm. right? The idea of warehousing children in remote areas in a prison environment, is that model flawed? Is that why it's always led to abuse, always led to trauma, always led to more crime, and will always lead to abuse and lead to trauma and lead to more crime? And I will say, it will make it harder to recruit good people and keep good people. So these are all, it's bad for kids, it's bad for the adults, which is bad for kids and bad for the adults. It's a vicious cycle. So I'm thankful that we are having those conversations. My question to you is about the new facilities that are being proposed, which I want to clarify if that's part of Sunset or if that's coming out of the Senate and House budgets. How are these two things? That's what's gotten a lot of attention, is the idea of new facilities from TJJD.
It has. That is not in this bill. That's something that the House weighed in on through the budget.
Okay. And then a 2-year sunset.
Yes.
Is that unusual in this process for an agency, and what is the reasoning behind that?
It is. Typically, we continue an agency for 12 years. So a shorter date usually shows that there's some sort of implementation that we, as Sunset staff and as a Sunset Commission, would like to see before we become comfortable with a longer term continuation. And so the commission actually modified this recommendation to be 2 years so that we would have a limited scope review to see how implementation was going. And if there are specific barriers, we don't have to wait much longer before we remove those.
That's great. And again, I just want to thank you and Chairman Canales and frankly the leadership at TJJD for zooming out and trying to ask some of these more fundamental questions. Because it's my opinion, based on all the evidence I have, that even if we were funding it fully and staff salaries were where they need to be, it still wouldn't work. And just because we're not having a scandal that's hitting the newspaper or on the front page doesn't mean it's not quietly hurting kids and hurting adults every day. So I do want to recognize the baseline we're trying to get to is still a bad baseline. But I'm very thankful for y'all and the agency leadership for starting this conversation, and I look forward to participating along with my colleagues. Thank you, Mr.
Change
Chairman.
takes time.
That's right.
Get there.
Change takes time.
Members, Representative Wu?
Thank you so much. And I'll echo what Representative Talarico said. I share a lot of the same views. Although I do have to add that I think in my time working on this stuff, since I've been elected and since from the time I was a prosecutor working on these cases on the other side, that I feel like things have gotten better. And while there's still room for a lot of improvement, I want to say, like, just from my own personal experiences, and which is not to say that the experience is the same across the state, but the things have gotten significantly better. And I do applaud all the people who work at TJJD and like especially juvenile probation offices around the state who have made concerted efforts to actually do better, which is not an easy task. I respect that. So my question is, well, the same question I ask all the time.
Okay.
And is the question I know Director Carter has already heard from me before. And that is just a couple of sessions ago, I did this back of the napkin calculation, taking a look at how many kids are in TJD facilities from each county, and then dividing the number of kids by the county's population, and you get a rough estimate of number of kids in custody per 100,000 population. And the trend that I ended up noticing was that there was these really wide discrepancies, not necessarily from the smallest population counties, but from like the mid-level population counties. That, if I can remember the numbers correctly, like Harris County sent something like 4.5 kids per 100,000, right? But there were other counties, smaller counties, that sent somewhere like 15 to 20 per 100,000. So my question is there anything in this bill that directs TJJD to take a look at why do we have this sort of like gulf in between what the average county in the state is sending to TJJD versus some of the outliers, right? And I know actually Travis County is one of the lowest, sends the lowest number of kids to TJJD, but they have a special arrangement where they keep a lot of their own kids. So that's just my question is, like, do we have anything here that takes, because I know we're trying to make everyone work better, so like seeing a county that has the big discrepancy from the central norm would show that, hey, maybe this is a county who needs extra help.
Yeah.
Right? Let's figure out why this one county or these 5 counties are sending 3 to 4 times as many kids to TJD facilities as comparable populations?
Yeah, so a couple of things come to mind. First is I know this is an analysis that the agency does. So they have regional program administrators who are really specific to the regionalization reform in general, but they provide support to the probation field. And so they are paying attention to the counties in their region or regions, because I believe at the moment there are only 5, but there are 7 regions. And they're trying to figure out why do these discrepancies exist, and trying to provide that support. Really, if you look at the crux of this system, I do have to shout out these staff. They are beloved because they do a lot of on the ground work in figuring out, okay, here's where you're struggling. How can we improve? I think the key there is figuring out not only which counties are committing at higher levels, but why. And what we continue to hear throughout the review, it's because that they feel like they don't have other options a lot of the time. There are definitely outliers who maybe don't buy into the regionalization plan. But I think the majority of the time, it's these counties have exhausted resources. They're not sure what else to do, and so they end up committing youth. What this bill does is then really try to go through and map out where are the resources, where are the gaps, and then intentionally fill them. And I know I've said that multiple times. I sound like a broken record, but that's really what we continue to hear over and over in the review from a bunch of different stakeholders is we have to figure out, really go high level, as Representative Tallarico is saying, and figure out where do we need to have more capacity so that there isn't a need for that commitment.
Would it be helpful for the legislation to include like both an analysis, a yearly analysis of these trends, and also recommendations based on what they're hearing back from the counties? Because like I can imagine that as we keep pushing more and more resources into counties, the reasons of why certain things are happening or why kids are being committed may change.
Yes, absolutely.
Right? And so it would be good to note any changes and trends of why more kids are being sent, right?
Yeah, so the regionalization plan in the committee sub is updated every other year, so right before a legislative session, so y'all could make some of those changes because it'll include recommendations. But if there's more specific language you would like to see, happy to chat with you. I know Chair Canales has worked hard on this, and I'm sure he would be open to conversations as well. It's been a long process, but we could absolutely chat with you about it.
Appreciate it. Thank you.
Members, any other questions? All right, thank you very much.
Thank you.
Members, we have another resource witness from TJJD if y'all would want to have any questions. And now we'll go on to our witnesses. Just go to the witnesses. Chair calls up Martin Martinez. Mr. Martinez, give us your full name, who you represent on for against the bill.
Yes. My name is Martin Martinez. I'm a policy advocate at Texas Appleseed, and I'll be registered to testify on House Bill 1520. Good afternoon, members, Mr. Chairman. My name is Martin Martinez. I'm a policy advocate at Texas Appleseed. I'm here to testify on the bill. First, I want to thank Sunset members for all of their attention in evaluating TJJD and thinking about ways to ensure that it is better equipped to serve youth in the agency's care. We all know that TJJD has been struggling through historic staffing shortages, and youth in their care are suffering because of it. I want to acknowledge that the conversations that are happening, even today, are getting us closer to building rehabilitative system. This includes some of the language in the Sunset Bill, which encourages diversion efforts and increased regionalization. However, there are 2 opportunities before us to make our juvenile justice system stronger and ensure there is greater data transparency for youth in it. Specifically, the first is adding language that clarifies that TJJD's aggregate non-identified data is not confidential and would be crucial to supporting parents, nonprofits, and others to understand what is happening in our juvenile justice system. Currently, it is difficult to access TJJD's aggregate data in a timely manner as the agency considers it to be confidential and requires a statistical research agreement to be in place in order for someone to receive that information. This process to acquire a research agreement usually takes 1 to 2 months and is out of line with Texas's Public Information Act. Now, I want to be clear, aggregate data does not contain any identifiable information for youth in the juvenile system. In fact, some aggregate data is already shared through the department's State of Juvenile Probation Activity Reports, which they publish yearly. However, this information can be published because it is in the aggregate form. It is just the total counts of youth. But an example of data we cannot access, which would be beneficial, is the total number of 10 to 12-year-olds who are referred to TJJD due to school-based behaviors. This kind of information helps us understand the trends in our juvenile justice system and think about ways we can make it more effective at rehabilitating youth. Additionally, Section 33 of the committee substitute has language in it that we think would be counterproductive to building a system that is focused on rehabilitating youth. It makes it easier to transfer children as young as 16 to the adult criminal system when they exhibit troubling behavior. Placing this language into statute is unfair as it creates a pipeline to transfer kids to TDCJ. I just have a couple more. Given the conditions over the last few years because of the historic staffing shortages in TDJD, we think this kind of language, putting into statute, is setting them up for failure. And happy to answer any questions you guys have. Thank you.
Thank you. Members, any questions? Yes. Representative Talarico.
Thank you, Mr. Chairman. Just a comment that this committee did pass out unanimously my bill, which would address the aggregate non-identifiable data information, and looking forward to working with Chairman Canales and any of the Sunset members about how we can get that done, whether it's through my bill or some other way. But I appreciate you bringing it up, Martin.
Thank you so
Mr.
much.
Chairman.
Thank you. Members, anyone else? All right, thank you.
Thank you.
Chair calls up Jim Allison. Mr. Allison, I'd like to remind you full name, who you represent, on for or against the bill.
Good evening. I'm Jim Allison. I'm the Senior Counsel of the County Judges and Commissioners Association of Texas, here testifying on the bill. And my hope is that we'll be able to fully support the bill as it finally comes out of committee. We do fully support the reforms that are in this bill, including the regionalization proposals. And I must commend Representative Wu and the other members of the House for the budget that you've passed to step forward and begin sharing the load with counties. As you heard, up to this point, 98% of the youth remain in county probation or county facilities, and counties through property taxes fund over 80% of the current cost of the system. But we also believe that it is time to put this agency back under sunset in 2 years, as Chairman Canales proposes. This is a critical point for this agency and how we go forward in our juvenile justice system. Our concern with the bill at present, as you've heard, it will require county cooperation and leadership in order to implement these changes. And the bill as presently drafted reduces the membership on the board of county representatives from 3 to 1. And it reduces the public membership from 3 to 1. At this critical time, as we make this transition, it seems even more vital that the county partners have representation on the board at all levels, as well as the public. As y'all have recognized, there's a great deal of difference in the state right now in both the ability and the availability of services at the local level. Large counties, for the most part, have been able to construct and operate their own juvenile facilities. Smaller counties typically have to contract to use facilities made available by others. The board, in order, we think, to properly implement these programs and regionalization, needs representation from all of those areas in order to get buy-in and participation by all of those areas. We can't do it alone. We have to do it together. So for those reasons, we believe it would be most appropriate to maintain that representation for the next 2 years as we see how we progress and come back and revisit any questions about the board membership when they come under sunset again. I'd be happy to answer any questions.
Thank you. Representative Wu?
Thank you. And I definitely thank you for your service, and I appreciate you being here. And so I think, my reading of the bill was, it was the county commissioner seats and the public seats that were removed, right? But there's still, the county is still represented through the juvenile probation chiefs who would have the most direct contact and direct knowledge of the of how like juvenile justice systems work.
Absolutely, and I would not recommend in any way that you do anything to reduce the representation of what I call the subject matter experts on the board. I also would not change the line in the bill that says that the county representatives must have juvenile justice experience. Our county judge member who's on the board right now is a former probation officer, and I think that that's needed. But I also think as you put state resources in and we put county taxpayer resources in, it's important to have elected officials, not just appointed people from the industry and from the profession on the board, and frankly, that the public participate. We need buy-in at all levels.
Thank you.
Thank you.
Thank you. Members, any other questions? Thank you, Mr. Allison. Appreciate it.
Thank you.
Chair calls Jeffrey Morgan. Mr. Morgan, your full name, who you represent, on for or against.
My name is Jeffrey Morgan. I am representing myself. I am for this bill. It was a long bill. I'll tell you right off the bat, I didn't understand the whole thing. It was very difficult to follow part of it, but overall, I thought it was what I saw, what I understood, I thought was good. There were a couple of things in particular that you mentioned, and Representative Tallarico, you know, in the past, we have not necessarily agreed on a lot of things, but I do agree with one thing that you've said at the very first day that the meetings took place. Texas is very good at handing out Band-Aids and not solving real issues, and I appreciate you saying that. We may have different solutions, but I do say that I thank you for saying that. One of the root causes, or one of the solutions that seemed to be mentioned within this bill was talking about keeping children within their communities and closer to families. And I'd like to say, why don't we look at some other things too? This is going to be a bit of a longer term issue. Why don't we look at trying to find ways to keep homes together more? Because if I used to work in the prison system, I taught in the prison system. And what I saw that a lot of people in the prison system either came from broken homes or fatherless homes or homes that had never been formed. And that's a big issue that we need to be looking at. The warehousing of children in prison-like facilities without families, removing them from families, removing them from grandparents, from aunts and uncles, that is traumatizing. And somebody mentioned that we have the cycle of scandal and then reform and scandal and then reform. I think Representative Lujan, Chair Lujan, you did that. But it's even more than that. It's not just the scandal and the reform. There is real damage that takes place in these instances. And that's why it's imperative that we actually address these issues. I'm not sure that, I mean, if raising the salaries is one thing, throwing money at it a little bit, you know, it is what it is, right? But there were two things as well, Representative Canales, that you had in this bill, the Chair Canales. I guess you're chair, right? Okay, sorry, I didn't know that. First time. But you talked about a couple of things in here, avoiding the appearance of a conflict of interest by not voting or participating in any decision. And then also, you talked about the issues of conflict of interest, because as I've seen things, and I'm not talking necessarily just about this, but I've seen service providers come and testify before this committee. And they're like, we have this solution, we have that solution. And, you know, and then 2 years later, they come back and there's another issue that has taken place. The idea that you're willing to address issues that may cause a conflict of interest, I appreciate that as well. There was one other thing I was going to mention. I remember being at a forum with divorce attorneys, and they were talking about amongst themselves, and I was shocked to hear them say it. They said, we have destroyed families. Do we have any responsibilities to help fix them? And this goes back to the point that I was saying earlier as far as what's the root cause. A lot of it's a destruction of the family. And I wanted to hear them say, yes, we do have some responsibilities toward that. So, you know, once again, Chair Canales, I think I'm for your bill anyway. I don't understand all of it. It's very technical and detailed, but I do thank you for it. And I also hope that we start addressing the other issues, like keeping intact families, keeping fathers and families, because certain demographics, fatherless people, much more are likely to be represented within this.
Thank you, Mr. Morgan. Members, any questions? No? Okay.
Thank you.
Chair calls Brendan Johnson.
Brandon Johnson, testifying on the bill. And
We have you registered against the bill?
I'm just going to testify on the bill.
So you want to change that from against to on?
Yes, sir.
Okay.
Okay.
Go ahead.
We're good. Okay, thank you. A couple of things that I just reading through the bill that I found.
I'm sorry, did you say who you're representing?
Myself.
Yourself.
Yes, sorry. Got hung up on that first part. Let's see. Just removing the mandatory yearly inspections. This was a lengthy bill, and there was another one too, so I hope I'm not too getting them mixed up or combining them, but I do know on page 3 and 4, it talked about removing the mandatory yearly inspections and kind of tying back to these other bills. Anytime that we can make sure that these agencies and whatnot that of the state are more accountable and have deadlines is more important. Regarding the appointment of the board members, I would ask, I think it would be ideal, instead of reducing the number of board members from 13 to 9, that you fill the additional 4 slots with watchdog advocates who are appointed independently from the governor and the Senate on the criteria these individuals are free from the bias of government who knows best. And then I would also suggest trying to figure out a way to pay those people so that they have the time to actually sit on that board, because all the government people, they're getting paid to show up. So I think the citizens, if you do that, they will be more attentive to the details of what's going on. And then as far as the decrease in the turnover, I believe this is because buried in that bill, or possibly the other bill, you're removing all the clauses that hold the people to any kind of standard. You're lowering the standard for who you're hiring. So when you lower the standard, well, then you open up the possibility to hire anybody. And I don't know that they necessarily need a college, degree, or even, some kind of doctorate degree to serve in these facilities. But most importantly, if you put fathers back in the home by incentivizing fathers to be active in their children's lives besides a paycheck and passing a bill of shared equal parenting.
We need to stay on the bill. Right?
I get it, but the whole basis for this bill is the ineptness of the state of Texas to handle these cases that are created from fatherless homes. Thank you.
Thank you, Mr. Johnson. Any questions, members? All right. This time the chair calls Alicia Castillo. Ms. Castillo, don't forget to give us your full name, who you represent on for against the bill.
Good afternoon. My name is Alicia Castillo. I am Director of Policy and Advocacy at Texas Center for Justice and Equity, and I'm on the bill. So it's true. This has been a very long process, and I just want to thank Chairman Canales. I want to thank his incredible staff. I want to thank the incredible staff at the Sunset Commission for their tireless labor on this. The work of the department, I mean, there have been so many people pouring so many hours into this, and rightfully so, because as Representative Talarico mentioned, this has been over a century of devastation happening at the hands of the state in this agency. And so it requires this type of attention. And while I agree, this bill, there has been, some word from the Senate that this bill is going to solve the problem. I don't have any sort of illusions that that's the case. I am really happy to see a lot of the improvements that have been made, particularly in the committee sub of the bill. Even just that original filed language to what we have now has been so substantially improved and is really tremendous. So I'll just quickly walk through some of the things that are concerns for us and some of the things that we're very supportive of, maybe starting with our support We appreciate the Section 13 allowing the board to work more collaboratively and outline more responsibilities for the committees that they'll be allowed to form through this bill to assist with substantive work. Because as you've heard, there are so many moving pieces here. One board of 9 or 13 members can't handle it all, right? So relying on those other experts in the field is going to be crucial for continued improvement over the next biennium. We strongly support Section 15 and the outlining of additional considerations for regionalization plans and advisory committees. It was really refreshing to see in this language a lot of the research-based solutions outlined as things that the committee has to use as goals, right? Inclusion of a diverse set of stakeholders from various child-serving agencies, not just correctional, right? Because there's so much going on with these specific kids. It will really strengthen the ability of the legislature to make meaningful changes next legislative session by ensuring that those goals are aligned with research. Section 23 we support because it increases flexibility and funding to the things that we know work and towards prioritizing diversion. I'd love to come by your offices at any point and tell you about some of the incredible programs we've worked on in Harris County, or some of the programs that we've worked on in Travis or Williamson County that are doing phenomenal work. Huge counties that are, Williamson County only committed 2 kids to TJJD out of an 80,000 population of children in their county, and that's because they're using programs that work. We support everything as it relates to expanded oversight in the department, and of course support and would support even more improvements to publication and gathering of aggregate data. There are just a couple of areas that I really advise, and I've been grateful to work with both the office and with the Sunset Commission on some of these things and hope to make improvements here. But Section 33 of the bill is the biggest concern for us. The provision would remove discretion that's already outlined in procedural mechanisms for the agency to certify youth as adults and transfer them to TDCJ. I know we haven't been in the headlines this week or last week, but we are about to be in the headlines once again for some of the things that continue to go on in these facilities, and particularly as they relate to transferring children to adult prisons in this state. Removing discretion for TJJD to be able to, requiring those transfers for these scenarios is an overreach, and we would recommend removing that section of the bill.
All right, thank you. Any questions, members? Not hearing any, thank you.
Thank you.
Ms. Castillo? Oh, the chair calls Cody Taylor.
Cody Taylor, represent myself, and I believe I'm on this bill as neutral.
Yes.
Is that correct?
Yes.
I like to leave it that way. So I have a unique background, or at least it's unique to me. That's all that matters in my world. But I started out a career after college in adult probation. And sorry, James, I don't know how to say your last name, and I'll butcher it all day long. But you stated about dumping, putting money into something that would essentially become a Band-Aid, right? So when I came into adult probation, I was actually immediately head of interstate and intrastate probations. When I showed up, there was about 18 different file cabinets, this tall, every one of them full. I showed up making $30,000 a year. It was not incentivized if any of those went away or how my caseload was. It was dependent on how many years you worked, right? So to the report, do you think that I would have done my job, or somebody else before me, because they were removed from their position, would have done their job better if they made $100,000? Or should they have just done the job that I was now $30,000 of a salary to do? I was able to take that caseload down and actually get rid of those cases and get down to a file cabinet that was around 3 or 4 on $30,000. I now work in an industry that, you talk about a business model, I now work in an industry that I make a little bit more than that. But if I don't do my job, it won't be tomorrow that I'll be fired. I'll be fired that day that they feel I'm not doing my job. We can throw money in a barrel and burn it for all I care, which is what our taxpayers are doing when we Band-Aid these issues. We start adding more incentive to make money, let's do our job. So when we talk about adding facilities and we start about adding caseworkers, are they doing their job? My money is valuable to me. Our money is valuable to everybody because we work for it. Without it, we wouldn't have the things that we do. Where I'm going with this is that if we're not getting the performance out of the caseworkers that are there, I'm not saying that I know everything about their jobs, right? But I do feel that everybody has a lazy bone in them at some point. Sometimes that lasts over a course of a career. If we continue to incentivize by just money and not doing the actual work, then we're going to continue to have the individuals and the facilities and our taxpayers paying for that. I don't feel that facilities is the way to go. I think we need to look at the root of the problem. The root of the problem is back where the kids are coming from. What's happening at that level to get them into where they're at right now and in these programs. We need to keep them out of that. Both parents, strong background of family, and move forward with that to start with. Adult probation showed me a different side of what this world is, and nobody walked through your door happy after court. They walked through your door because they had to, and there was a court order that made them. So that's just my 2 cents on where we're at with the sunset.
Thank you, Mr. Taylor. Any questions, members? Not hearing any. Thank you for your testimony. Chair calls David Bellow.
Good afternoon. David Bellow, I'm representing myself. And just like Cody, actually, I got a background that...
Are you neutral on the bill?
Oh, sorry, neutral. Yes, neutral. I'm speaking on the bill, and I'd like to see... so, just like Cody, I've worked in areas that help me see the inside of prisons and what goes on and how kids end up going to juvenile and end up going to maximum security penitentiaries where I was a federal officer. And it's, as Mr. Talrico, I do know how to say your last name, as he had mentioned, this is a lot of money that could be a Band-Aid. And I believe that part of looking into extending these, programs with youth and reforming youth programs like this, juvenile programs, I believe we've got to look at the root of the issue, which statistically, it's children who grow up in broken homes and have fatherlessness issues. And that, the facts don't lie, and they're pretty shocking. From the 85% of all youths in prison come from fatherless homes. And, the majority of teen crime come from fatherless homes. And so I believe, this bill is good. It puts more money and more, tries to reform the juvenile system. But I do believe that we really can't, it's just a Band-Aid until we look at the issue of, which is a fact. This is completely relevant to looking at solving these juvenile issues. We wouldn't have understaffing issues at juvenile facilities if we didn't have as many juveniles in there. And we wouldn't have as many juveniles if statistically more children were not from broken homes and came from homes where both the mother and father were involved. And so that's what I'd ask of y'all. I know y'all have a hard job. There's a lot of issues that involve money and complex child issues of what's best for the child. And if in order to keep, from my experience, and I think the statistics show that if we want to help look at the root of the problem, maybe there could be an amendment of a study, a state study on how we can help children stay out of these facilities by ending fatherlessness. So thank you very much for your time.
All right, thank you, Mr. Bellows. Any questions, members? Not hearing any. That is the last witness affirmation we have. Is there anyone else here who would like to testify on, for, or against House Bill 1520? Chair hears none, recognizes Representative Canales, Chairman Canales, to close.
Thank you, Chairman. I do want to mention a couple things. So the TJJD's board has already been operating with only one county commissioner slots for over a year. That was one of the questions that you had. Sunset found the board size, governing practices, and lack of expertise among some of the members contributes to diffusion and responsibility at a time when we greatly need to be engaged and have active leadership. However, Sunset's open to working with the stakeholders to address concerns about county level representation. Talking about throwing good money after the bad. Until this session, the legislature's never significantly invested in this agency to ensure it can effectively perform its services or its functions. In the last decade, TJJD's budget actually decreased, even as the youth of TJJD's care have presented higher level treatment needs over time. So investments in operational changes since last summer have positively impacted the youth and staff, and we've shown great progress in how it can happen when we focus on reforms at work rather than yet another structural overhaul. Examples of improvements after staff raises took effect in 2022, that was July. We haven't had a full lockdown since October 2022. In May of 2022, you spent 35% of their time in normal programming versus 90% in February 2023. And throughout the summer of 2022, state secure facilities operated at 200% of their operational capacities versus 140% in February of 2023. So before TJJD implemented pay raises, 56% of the new hires left TJJD within 60 days versus 23% after the pay raises. So we've made some huge changes. Is that where we have to stop? No. One of the things that you mentioned, Representative Tallarico, was sending these kids to some place that was far removed. I actually have a TJJD facility within 2 miles of my house. It's called Evans. And Evans is routinely in the newspaper. But the reason is because we're in a major media market. Most of these places are not. And so we don't know what's happening, and you're absolutely right. And so that is one of the biggest concerns is, and I've been to the Evans facility on multiple occasions. In fact, walking in one of the rooms gave me an anxiety attack where we kept some of the kids. Is this the solution for everything? No. We've been at it, yes. The legislature's been trying, yes. But it makes some real positive changes from trying to fix the minutia and taking a 1,000-foot view and saying, let's look at this whole thing as in its entirety. So I think that's for the first time in a long time, the sunset process is really, truly making some meaningful change. The regionalization is largely an appropriations issue. We need money, and the agency needs money. And the reality is that if there was ever a session to put money in it, we've got it. Unfortunately, I don't see the money in the budget that would make even greater changes. But we know that money does move the needle, and it moves it significantly. I do want to thank the Sunset staff. I do want to thank this committee for listening. I do think that this bill makes real positive changes, and I hope that you will pass it out because it's desperately necessary. I do think it's important to mention that we are coming back to review this agency in 2 years to see what we did, and hopefully I will be able, or somebody will be able to report to you that the changes, positive changes continue. That I stand for questions. If not, I close.
Yeah, are there any sunset recommendations for the agency that need legislative authority that's not in the bill?
Can you state that again? So is there any legislative recommendations that are not
that came out of the Sunset Commission, any Sunset Committee?
At this time, I would like to represent to the chair. I don't have there was a lot of recommendations. And so I believe that the majority of all the recommendations and the analysis are included in the committee substitute. If not, I'll have my staff check and I'll report back to you, Chairman Dutton, to make sure anything that was not included and the reason why it wasn't.
Yeah. Okay. All right. Thank you. Well, let me thank you and the commission staff too, because working on Sunset is one of the greatest challenges I had, and I enjoyed it.
I'll leave you with this. That when I was as a freshman, I thought it was the opportunity to file amendments because it was so broad, and it left me with the subject, with the idea that that's extremely inappropriate. And so I now look at it as a completely different view.
I think Representative Tallarico has a question.
Go ahead.
Thank you, Mr. Chairman. Not a question. Just want to thank you, Chairman Canales, for this bill. And I also just want to add on the praise for your staff, both Rachel and Brian, who's sitting back there, have spent time with my office, and they're just some of the best staffers in this building. So just want to thank you and your whole team.
Well, we want to thank you for your active engagement because we know that you're one of the members that truly does care. Thank you.
Thank you. Thank you.
Thank you, Chair.
Any further questions, members? Not hearing any. Is the chair's intent to withdraw the committee substitute for House Bill 1520 without objection and leave House Bill 1520 as a matter of pending business before the full committee? Chair at this time lays out HCR 81 and recognizes its author, Representative Schatzline.
Right. Thank you, Chairman Dutton and Vice Chair Lujan, and members as well. I really appreciate the opportunity to lay out this HCR 81, which would affirm the state's commitment to fighting the ongoing battle against fatherlessness. This is a really personal one for me, and I'm so grateful that you would take the time to hear this out. I've spent the last 10 years working with at-risk kids, whether it be through football programs, at-risk student programs in public schools. I was an educator, and I was a pastor as well. And in the process of doing all this, one of the most common themes we saw with our behavioral issues was the lack of a father in the home. And not being the only factor, but one of the major factors that we see. Fatherlessness plays a major role in the crime spikes we're witnessing here in Texas and across the nation, and the research shows it. Many studies show that the less interactions between a father and child, the higher chance they are to commit a crime or to have contact with the juvenile justice system. Another study shows that children who come from father-absent homes are at greater risk of using illicit substances at a younger age. HCR 81 simply affirms that the legislature recognizes the importance of fatherhood in the lives of children. It also affirms the legislature is committed to researching and understanding the root causes of fatherlessness and crafting public policy that supports and encourages fully engaged fatherhood. While this is only a resolution, supporting this sends a strong message to Texas families and the rest of the nation that here in Texas we are committed to solving the issues that affect our next generation. Members, at this time, I'll be happy to answer any questions you may have, and if there are none, I'd like to reserve my right to close.
Any questions of Representative Schatzline, members? Not hearing any, we'll give you the right to close.
Thank you.
And we'll start down the public testimony at this point. The chair calls Taryn Champagne.
Good evening. My name is Taryn Champagne. I am representing myself, and I am in favor of HCR 81, and I'd like to give a special recognition to my representative, Representative Tarico. It's a pleasure to testify in front of you. This resolution is long overdue and recognize the importance of fathers that they play in the lives of children. Truly, the best interest of the child is for children to be raised in an intact two-person household. Unfortunately, we do not live in such a world where this ideal is celebrated and must instead realize what we are facing in the state of Texas. In the state of Texas, out of a total of 1,476,908 cases with the Attorney General, the father is listed as the non-custodial or absent as per the OAG software in 1,349,688 cases as of February 27, 2023. This is 91.2% of all the cases where the father plays less than equal role in the child's life. Clearly, there's some sort of bias at play here that cannot be explained away simply by assuming the dad abandoned the kid. I'm certain an interim study, if it was done by this committee, they would find that an overwhelming absence of fathers in children's lives is not from dad walking out, but from the state forcing dad out. As noted in the resolution, having the father involved in the child's life is a boon to the child. Bills that would have gotten fathers more involved in the raising of the child, such as equal parenting bills, have languished in this very committee for years. As the resolution notes, there are disincentives to father involvement, and a huge part of that is our broken legal system. I have equal custody of my son, and his life is all the better for it. He even told his mother that now things that are equal, he doesn't feel like he's being torn apart. What did it take to get there, though? My son's mother spent almost $100,000 fighting to keep me from being equally involved in his life. It took 7 years of fighting, a divorce case, a SAPSER case, multiple judicial complaints, complaints on a court reporter, bar complaints, a mandamus, multiple interpleaders into my case, and family law corruption being exposed. In the last SAPSER case, my wife was battling leukemia, And we mourned the loss of our unborn child due to her cancer. This case continued on despite me begging for this to stop. Can any legislator or family law attorney tell me how this was in the best interest of my son? However, her attorney was still filling her with lies and nonsense as that greedy attorney grew fat on money given by untruths. We finally came to an agreement after, in my opinion, her corrupted attorney, Daryl Weinman, was broken by me and ran cowardly away from this case, having robbed my son's mother of money that could have been spent on him instead. After this devil, and I extend that to most family law attorneys, was no longer whispering in her ear, she realized I wasn't the bad guy I was made out to be. You want to remove disincentives to father involvement? Start with equal custody. Second, get avaricious attorneys out of our court system. My son certainly one day will be grateful for my tenacity, but you have to ask yourself, is this really what it takes to be a father involved in a child's life in Texas? The state of Texas must wake up and realize the importance of fathers. Every legislator on this committee has been bombarded with research relating to this, and yet nothing is done session after session.
All right, thank you. Thank you. Let me see if there are any questions. Mr. Champagne, are there any questions? Thank you for your testimony, sir.
Thank you.
The chair calls Brandon Johnson.
Thank you, Chairman Dutton. Brandon Johnson for this resolution and represent myself.
Wait, he says he's on it. Is he on there for it?
Our records show that you were neutral, but now you're for it.
Yes, sir.
Would you like us to change it?
Please.
And we have your permission to do so.
Yes, sir.
All right, we will change it to show that Brandon Johnson is now for HCR 81.
Thank you, Chairman Dutton. There's so much with this, but I do support the resolution. There has been research done on this funded by the Attorney General's office with Cynthia Osborne when she was employed by the University of Texas that pointed to fatherhood involvement, maximizing fatherhood involvement was best for the children, but not for the Attorney General's office. And so basically that Cynthia's work has been buried, taken off the internet, and I imagine we can get it through some information requests, but other than that, it's hidden. All the statistics point to negative impact of fathers being mandated absent by the state. You opened this session. I was not here, but I listened to it about the ineptness and understaffed state agencies that are raising our children. And then today's testimony has piggybacked off of that same sentiment. And, Representative Vasut, he's talking about being old school and wants families to stay together and all that kind of stuff. That's great, except for that's just not the way it is. And I say this to people all the time. It's the difference between what ought to be and what is. And it'd be real nice if parents stayed together, but when you have the state interjecting itself into family affairs for state profits through this Title 4D program, then it's a conflict of interest. And although I would agree with Representative Vasut, it's just not the way it is. And also it's been mentioned that equal rights, duties, but also possession is going to, I know it's a tiring thing to hear, Representative Wu, but every woe in the state has to do with mandated absent fathers, period. Thank you.
All right, thank you. Mr. Johnson, Chair calls Cody Taylor.
Cody Taylor for myself and my daughter. I am for this resolution. It's 2023. Could you imagine what 100 years ago was whenever you, or could have been, whenever somebody had to actually make a resolution about fathers? What built this world? I'm not here to degrade or anything about women and what they do for our lives. Clearly they bear the children for us all to be called fathers when that time comes. But can you imagine what it would be like if we had to degrade a woman to a piece of paper to say that she's a good mother or that she should have been? Almost everybody here on this panel probably is either married or has kids or has grandkids or has nieces, nephews. You wouldn't have that without a dad. You wouldn't have that without a male. What would you be today, Representative Cook, Wu, Dutton, Miss Jones, and James, if you didn't have your father? Do what?
Not traumatized.
Well, I can tell you this. I wouldn't have the balls to stand up here and talk to you if I didn't have mine. My father stood up in front of you at 73 years old and talked to you about the corruption inside of Jefferson County and what it took for me as a father for over 3.5 years to fight a judge, not the system, a judge, in a biased nature. The only way that I get to talk to my daughter now, due to everything that happens, is through a FaceTime. This is it. This is how I get to talk to my daughter for 15 minutes. And unfortunately, I have to work on the weekend. So guess what? If I miss 15 minutes, I may not even get to talk to her. My job does not require me to sit at a desk all day. It requires me to be in the field. And if you could, for 2 minutes, see what the average male work life is here, it's people out there. They're not in offices. They're on the roads. They're on the streets. They're leaving their house like I did at 3:30 in the morning to try to be here, to be in front of y'all. Fathers need a little bit more. We don't ask for much, but we ask that you start taking this seriously. We all have our backgrounds. We all have our history. And I get that there's not always a father that's perfect, but there's also not mothers that are. But we're proposing a resolution on fathers. They're that important. I wouldn't be here today without mine. And here's the problem with that, Mr. Cook, and I'm bringing this to you. I'm adopted. That's not even my father, not blood. That man stood up and took ownership of me after the fact that my mother and dad didn't want me for their reasons. That's the only father I know. What would I have been like if I'd have been in the system and didn't have that father? Please start looking at this thing as the standpoint of 50-50, equal for both. If we start there, you wouldn't have to spend my taxpayer money for new facilities and more people.
All right, thank you, Mr. Taylor. Any questions, members? Mr. Taylor? I don't think there are any. Thank you for your testimony.
I appreciate it.
Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am representing myself. I'm also going to represent Dad Talk today. We have over 500,000 followers nationwide, not just in the state, not just in the States, but even overseas. Since the last time we met.
Hold on, Mr. Morgan.
Oh, I'm sorry. I'm for the resolution. I'm sorry.
Yeah, but you registered as representing yourself, but I mentioned.
Oh, okay. Okay. I didn't realize that I am representing myself. Then.
Not the agency. Oh,
forget
okay.
that. I'm sorry. I did not realize that. I'm so sorry.
Oh, thank you. Okay.
The first time I've done that. So anyway, but yes. So since the last time we met here last Wednesday, I received this text message from somebody, and let you know, I don't advocate just for fathers. I advocate for parents, grandparents, aunts, uncles, everything. This lady wrote to me, I know you advocate for fathers' rights. I had a Facebook acquaintance that committed suicide this weekend in Midland. His ex-wife was tormenting him. He was posting screenshots. He shot himself to death. He killed himself. And when I talked with the lady, I reached out to her. She said, 7 years this has been going on, harassing, bullying, tormenting. Paid $2,000 a month for 3 children and child support, lived on $2,300. Couldn't see his children because of what she was doing. She said 50-50 shared parenting would have actually saved his life. Leah Ward Sears is a Supreme Court justice from Georgia. And she was actually being considered for the U.S. Supreme Court by President Barack Obama. She talks about what happened to her brother and how it changed her life. Her brother's name was Tommy. And Tommy enlisted in the service, was killed overseas, and they got the phone call. She kind of knew what was going to be happening, what the call was about, but she was shocked because it said Tommy killed himself. After Tommy's sudden death, we found my brother's personal effects. In his personal effects, a questionnaire he had completed in 2005 for a church class. The very first question was a fill in the blank that went like this: at the end of my life, I'd love to be able to look back and know that I had done something about fathers. That's what he said. This is happening nationwide. And how sad it is that we have to have a resolution like this to say, wow, you know what? Fathers are important. I miss my father every week. I wish I had one more hour with him. And yet what you guys are doing with the laws that you have, you are kicking fathers out of kids' lives and not even giving them an explanation as to why. Almost everybody here that I know in this room has been because we've been fighting against this evil system. I knew none of these people 6, 7 years ago. These are my friends. I have their back. They have mine. There's no reason I should know them. We come from all over the state. With Dad Talk today, we've been through various states. We've been up to at the federal level. We've been to conferences, multiple, to advocate on behalf of we need to have father involvement. We need to have intact families. And Representative Schatzlin, is that how you say it? I'd like to talk with you further. I did talk with you one time, but I just want to thank you so much for this resolution.
All right, can you go ahead and conclude?
Yes, basically all I'd just like to do is, it's just absolutely a shame that we have come to the place that we have declared such war on fathers and families that we have to have a resolution to say fathers are important.
All right, thank you.
Thank you very much.
Mr. Morgan. Chair calls Delilah Crosby.
My name is Delilah Crosby. I represent myself, the Crosby family, and a lot of the fathers that I advocate on behalf of. I am for this resolution. I would like to start by saying this resolution immediately acknowledges the important roles of fathers, yet in a lot of your counties, over 85% of fathers are the non-custodial parents. The Texas Family Law Foundation will tell you that the standard possession order is basically 50-50 custody, but in reality, why is it that only fathers are placed on these orders and mothers fight tooth and nail to ensure that they're not the parent who gets 4 days to 6 days a month? Some of my background is I am a PTA president all over Mansfield and Arlington, Texas. I am also a civic leader with multiple veteran groups. I do a lot of community service everywhere. And if there's one thing I have learned, it is that the biggest lie is that there are children without fathers. I have actively brought people onto my PTA who are fathers who had trouble accessing schools. They had to join my PTA just to be involved in their child's lives. Our principals calls for Doors for Dads. Right there in Mansfield, Texas, we are always engaging our fathers. In Arlington, Texas, we have Fathers for Engaged in Excellence. So we do all recognize this, but we are not legalizing it. In fact, fathers are literally told that they are simply money providers for these children. Also, I noticed that Representative Wu, respectfully, you scoffed earlier at Cody Taylor for saying that this is traumatic. This is an extremely traumatic event, and I can tell you that myself because I am the mother of 5 children. My children's father is in their life. I don't have these issues where I expect him to pay me to raise my children. But my husband, a Purple Heart veteran, permanently and totally disabled, he's allowed to raise all 5 of our children, but he's not allowed to raise one because the family court decided that Mom gets to make all the decisions. It is so traumatic that we have dealt with police altercations at school events. We have dealt with him going to jail for child support, even though his Social Security disability benefits pay his child support. So it is very traumatic, so traumatic that One Safe Place took our family in for this and considered him a domestic violence victim. Him, myself, and all of my children have had to go to counseling over this, and the Department of Family and Protective Services ordered his daughter to have continuous counseling for a very long time. Her counselor also testified that she needed counseling for the rest of her life for the grief that she suffers with her father not being included. So I do hope that you guys pass this resolution and consider 50-50 custody for our fathers.
All right, thank you. Let's see if there are any questions, Ms. Crosby. Any questions for Ms. Crosby? I think not. Thank you for your testimony. Chair calls Kimberly Classic. Klacic. Kimberly Classic. Says here that she was testifying for herself and testifying for the bill, for the resolution, and what she will be shown as not having testified, but for it. You know.
No, keep going, scroll up.
Oh, the chair calls David Green.
Thank you, Chairman Dutton and members of the committee. My name is David Green, and I am testifying on behalf of myself, and I am in favor of this resolution. As many people have previously said, children raised without a father actively involved in their lives are at higher risk for a variety of ills compared to children with two actively engaged parents. They're more likely to experience drug abuse, be victims of abuse and neglect, and have behavioral problems. They're twice as likely to drop out of high school and 3 times as likely to carry guns and deal drugs. Girls raised without both parents involved are 7 times as likely to become pregnant as a teenager. Texas can't increase the role fathers play in children's lives when parents separate by passing an equal parenting bill. For over a decade, we have been trying to get a floor vote and have not been able to. It's time Texas shows it values fathers in children's lives, and I'm in hope this resolution passes. Thank you for your time and allowing me to speak.
Right. Thank you for your testimony, Mr. Green. Are there any questions? Members of this witness? Not hearing any, thank you. Chair calls John Helwig. John Helwig will be shown as not having testified, but for the resolution. Chair calls Kimmy Lynn Reed.
My name is Kimmy Lynn Reed. I am testifying for this bill, and I represent myself and Lone Star Family Advocacy Group. In 2018, I entered into the family court system where immediately it was clear there was corruption going on behind the scenes. Opposing counsel conspired with my attorney, and they decided how my case was going to be handled right at that very moment. At that very moment, within 2 months, a silver bullet was fired. And as of March 19th, 2023, it's been 3 years since I've seen my son. 4 years ago, when this all started, I was fortunate enough to come into contact with several other advocates, several other family advocates. And I started advocating also. What I came to know is that in this process, I was a minority. I was less than 10% of women fighting to see their children. Everybody I went anywhere with and shared this concept of having your child stolen from you in family court with all of the validation I give. Taryn Champagne's allegations, all listed: family court corruption, lawyers seeking nothing but money. All of that is valid in so many cases. It is not a situation that happens only some of the time. Family court corruption and the theft of children through family court happens all day, every day. But the people who don't get to see their children more often than not are men. Men leave without their children. The difference between having a silver bullet fired, typically speaking, at a woman is that we, more often than not, do not get the allegation of sexual abuse. The number of fathers who are shot with a silver bullet that includes sexual abuse allegation is astronomical, and no penalties go to these women who go there and do that. And then a large percentage of these fathers go on suicide watch. These fathers do not deserve to be put through that. I have gone on suicide watch with many fathers who first have gone through the trauma of having their children stolen from them, and then through the trauma of defending themselves in court. I would like to verify and speak for myself. If it wasn't for my dad, the skills, the love, and care that my father gave to me when I was a little girl, the same age as Cody Taylor's little girl who was being deprived her father because of a corrupt judiciary, I would not have survived having my son stolen from me. So I am absolutely for this bill, and I highly encourage you all to seek out getting the shared parenting bill, because so many people would not be victimized by the family court system if you do.
Thank you, Ms. Reed. Any questions, members, of this witness? Not hearing any. Chair calls Justin McLeod.
Good afternoon, Chair and committee. My name is Justin McLeod, representing myself, and I am absolutely for this resolution. So typically, I know you've heard a lot of information, a lot of data, a lot of statistics today, which is phenomenal. From David Bellows, Karen Champagne, and typically I would deliver the same information. Over the last 2 sessions, I did. Today, a little something different, and I was hoping to speak with you as a parent, right? As a father to father, or somebody who grew up with a positive male influence in their lives. And as such, I want to take you back just a little bit, right? I want to take you back to the days where you read bedtime stories to your kids, to the times you made breakfast and got your kids off to school, played one-on-one basketball, showed them how to throw a ball, catch a ball, right? Or the days when you did absolutely nothing except sit and talk and bond, right? And I can go on and on and on with that. Do you remember those days? Now I want you to imagine someone took that all away from you. How would you feel? I guess more importantly, what would you do? And I'm certain you'd be standing behind this podium fighting for change like we're doing back here. You know, and that's really what it is. In closing, I know that you're great parents, right? You're great fathers and moms. Otherwise, you wouldn't be where you're at. You wouldn't work so tirelessly for Texas children, right, and families. But I want to leave you with this, I guess. Would your kids be the people they are, or would your sons be the men they are today if you were not involved in their lives? And I want you to think about that. I hope that resonates with y'all, because I know that you're fathers and your mothers, right? Just think about that. I appreciate your time. Thank you so very much.
All right, thank you, Mr. McLeod. Any questions of this witness, members? Not hearing any. Thank you for your testimony. Chair calls Wanda Best.
Hi, my name is Wanda Best. I'm representing myself, and I am for this resolution. Please bear with me as I'm very nervous to be up here. I would like to share some statistics that you will not hear from anyone else. These relate specifically to my family. Within my immediate family, there have been 25 marriages. 15 of those marriages have ended in divorce. That is a 60% divorce rate. Within my immediate family, there are 21 children. 18 of those children are from divorced parents. That is an 86% of the children in my family impacted by current family laws. All but two families were given standard possession schedule, which meant that the children were given very limited time with their fathers. Of those 18 children, there were 10 teenage or unplanned pregnancies, or 55%. One child has been in and out of jail since he was a teenager. 3 had problems with drug use for several years. 1 still does. Another died at the age of 25 from a drug overdose. 4 were abused physically and or sexually by their mother or their mother's new husband or boyfriend. 1 child at the age of 14 was described by her counselor to have the emotional maturity of a 7-year-old at the age of 14. 2 children were forced to testify against one of their parents, only to finally admit after questioning that they had been coached by the custodial parent to lie. Other effects of no access to their fathers meant 5 children had no father at their high school graduation, 3 college graduations, 4 weddings, and the birth of 1 grandchild. 7 children were never allowed to have a relationship with their fathers. One of the families was ordered by another state to share 50-50 custody with their 2-year-old son, while the parents lived 1,200 miles apart. These parents reconciled after 2 years and are still together 13 years later. Another family had agreed to equal parenting when they divorced. Their son was 18 months old and lived over 2,000 miles apart. Once the child became school age, the parents learned how to co-parent and made decisions on parenting time that worked best for their son. He has grown into a successful young man and never suffered what the other children in my family have suffered from. I personally made the decision to change the agreement with my ex-husband after 13 years of standard possession to give my daughter equal time with her father. It immediately ended 95% of the fighting that had been going on between us. Today we enjoy gatherings for birthdays and other celebrations with our daughter and grandson. My parents have been married 60 years. That's not anything special, but I can't imagine it any other way. I proudly was my father's guardian in November 2019 on Honor Flight 43 to Washington, D.C. in recognition of his military service. A memory that we will treasure forever. My grandfather fought on islands, Okinawa, Saipan, Tainan, and fought his way to the top
Would you
of Mount.
please wrap up for us?
Yes, sir. I'm almost there. He fought his way to the top of Mount Suribachi on the island of Iwo Jima. He was there for the first flag raising. I would not be who I am today without either of these men in my life. Please give our children their fathers back.
Thank you.
Thank you.
Thank you, Ms. Best. Any questions of this witness, members?
Thank you.
Not hearing any. Thank you. You were great. Chair calls David Bello.
David Bello. I'm testifying for the bill, representing myself. I think that this is a fantastic resolution addressing the issues that fatherlessness has created here in America and in Texas. And it's not even just about fathers. If we had more fathers involved, we would change so many children's lives. You've already heard the statistics. You know the statistics of the majority of teen crime, teen pregnancy, teen drug use, all come from homes without fathers, with unequal parenting. I actually walked around the Capitol today with Kimberly, and you actually called her up earlier, but she already had to leave. She's actually from Baltimore. She ran for Congress. And very widely popular, in the nation, running for Congress in Baltimore, walking through the streets of Baltimore, talking about the crime and the problems. And she was here because she heard Texas had a bill, or Texas was recognizing fathers, and and the need for fathers to be equally involved with equal parenting. And she wanted to testify on this because she is a single mother, a black single mother from Baltimore. Said that equal parenting is best for mothers. She would not have been able to come up here today if her ex-husband wasn't being equally responsible and watching the child today while she was able to come up here. So equal parenting, fatherless, being fathers involved in children's lives helps women. It gives them more freedom to go out and have the same job and the same pay as fathers, because the fathers have to be equally responsible. This is about equality with men and women, and it's about what's best for children. The fatherless epidemic has harmed children drastically. And then lastly, it's harmed men. All right? We live in a society where men are committing suicide at crazy rates. Last session at the Equal Parenting Bill, we had 150 people testify on fatherlessness, and one guy was in the military and testified that he had more men in his unit die from suicide because they couldn't see their children when they came back from fighting for America. All right, we have an epidemic of children being taken from one parent or another in the unequal parenting system, and typically it's the fathers, but it can be the mothers too. And so the best way to help fatherlessness issue, this epidemic, is to promote equal parenting. And so thank you for this resolution, recognizing this is such a large issue. And there are some people in the movement, like in every movement, that maybe they do some things that not everyone agrees with. And let me tell you right now, please don't judge the whole issue based on a couple people that might not, be doing things the right way. Please stand up for fathers, and please set a hearing for equal parenting as well. Thank you.
Any question, Mr. Bello? Not hearing any. Thank you. Chair calls Charles, and I can't remember how to pronounce his last name. Charles Suez. That's not right.
There's no W.
Suez.
Go with Dr. Seuss or Ceasefire. Which one would you like?
Well, I want you to tell me.
All right. I'm Charles Stephen Cease. I am here. Well, the question of representation is interesting. So I was talking. Do you see Ted Vincent registered to also testify?
I'm sorry?
Do you see Ted Vincent also registered to testify?
We're just going to listen to you testify right now. Okay.
Well, he had to leave, and he handed me his notes. I told them that I would try to pass them in as testimony if that's possible, and if we can't do it for me representing him, then I'll just tag him on my own.
Does it have his name on it?
Nope, I don't.
We can't.
I can write it.
We can't enter it into the record.
All right.
Okay.
Well, in that case, how much time do I get?
I don't know, but you're using it up now.
All right. So I'm Charles Stephen Cease. I am for the resolution. I want to praise y'all for please pass the resolution. I don't want to be mean, but I have to say some unpleasant things. I want to encourage y'all to pass the resolution, but also go the next step further. You have a bill in the committee that embodies this resolution, 3379. Take it to the next level. Set it for a hearing, please.
Now, you have to limit your testimony to this bill, right?
This resolution
right.
wraps around the concepts that are embodied in that other bill. I wish Ted were here to run through his notes. He's got some good ones, but what it boils down to, $50 billion industry around family court incentivizes the state of Texas and the judiciary and contributes to corruption in our family courts. And we know that there's a sugary diet involved with Title 4D and the lobbying organizations and family law and attorneys. We know how it works now. We're going to help y'all work on it. Do you have any questions for me?
Okay. Let's see if there are any questions. Any questions, members, for this witness? Not hearing any. Thank you for being here. Chair calls Ted Vinson. That's right. He is not here. He was for the resolution, testifying on behalf of himself. We'll show him as not testifying, but for the resolution.
If I go ahead and write his name on this, can I contribute it?
No, sir.
All right.
No, sir, you can't do that.
All right. I did tell him I would try. Thank y'all.
Thank you. Chair calls George Saldano. George.
I'm sorry. My name is George Saldani. I'm for this resolution. Is there one more question? George Saldani. I'm for the resolution.
And you're representing yourself?
Yes, I'm representing myself.
Thank you.
And I'm here, when I come to Austin, I come here to do business. I don't come here to fluff every legislator up, to tell them how great of a job they're doing. I'm here to conduct business for my children. The Supreme Court has said we have a duty, right, to support our children. We don't have a nay out here that has come up and say we don't like this resolution. It's pretty sad that we have to have these individuals come and grovel to the JJFI and beg to hear some bills or to have parents reinstated in their children's lives. What are we doing? Martin Luther King. Let's talk about Rosa Parks. Let's talk about equality. Transgender is a big movement right now. Everybody wants equality. But we're showing you statistics straight from the Attorney General's office that y'all are overlooking. Their own non-custodial handbook printed with our tax dollars, our state, that there's 90% non-custodial are men. Is that equal? Absolutely not. Could we treat our transgender population with 90%? Absolutely not. It wouldn't look good, would it? So y'all want to hold us accountable, and the reason why everybody's fighting about child support, which everybody welcomes child support, y'all all want the fathers to be involved, right? But y'all don't give us a chance because we have to come over here. We have to, instead of filing a bill, we have to do a resolution to come over here. And then we get snide comments by Representative Wu. We're the taxpayers. When I come here, I come to do business. I'm not here to play with you guys. I'm doing my due diligence as a father for my 3 kids whom fit that statistic everybody's been telling you about. My daughter got pregnant at 15. They filed a bogus protective order. I'm not being paid to be here. I'm sitting over here with everybody else coming, and they're all telling you their sad stories. And it's sad. In San Antonio, in 2016, there was 12,354 visitation violations. I started a movement, Interference with Child Custody, because fathers want to be in the lives of their children. So if the JJFI wants to hold fathers accountable for child support, why don't we equally share that duty and make sure that that mom is allowing that father to be present? Because you can't call him an absent father if he's trying to be there when the judge has mandated he be there.
All right, Mr. Saldana, let me see if there are any questions. So, any questions, members? I'm not hearing any. Thank you for your testimony.
Thank you.
Is there anyone else here who would like to testify on, for, or against HCR 81? Chair hears none.
Mr. Chairman.
Chair.
Representative Slats
Oh,
wanted to step out.
okay.
To another committee.
Yeah, Chair recognizes Representative Cook to close.
Thank you, Chairman. Representative Chatsline asked me to reiterate the following points as part of his closing, that HCR, this resolution simply affirms that the legislature recognizes the importance of fatherhood in the lives of children. It affirms the legislature is committed to researching and understanding the root causes of fatherlessness and crafting public policy that supports and encourages fully engaged fatherhood. And lastly, that this resolution supports the message that Texas families, and the rest of the nation that here in Texas we are committed to solving the issues that affect our next generation. And with that, members, I'd be glad to entertain any questions. Otherwise, I close on behalf of Representative Slatsline.
Yeah, I just had one question. I wish he was here, but I'll ask him on the House
I'll do
floor.
my best, Mr. Chairman.
Yeah, and on the second page, on the third page rather, line 5 through 9, it says the legislature recognizes the threat of government growth in prosperity, responsibility, and liberty. And
Did you say, I'm sorry, did you say page 1? Or?
page 3, I'm sorry.
Okay.
And I just wondered if that ought to go in a separate resolution someplace as opposed to the resolution about fathers.
Is it lines 5 through 9?
Yes.
Okay. I'll be glad to make a note of that and ask Representative Slatsline if he'd be willing to remove that.
Yeah. Okay.
Before a vote's taken.
Well, I just didn't, I didn't see the connection between those lines and, okay.
Thank you, Mr.
All
Chairman.
right.
I close.
All right. It's the chair's intent to leave House concurrent resolution number 81 pending before the full committee. Without objection, chair hears none, and so ordered. Chair lays out House Bill 969 by Cook. Chair lays out House Bill 969 by Cook and representatives, and recognizes Representative Cook to lay out the bill.
Which one, Chairman?
969.
Thank you, Mr. Chairman. Thank you for the opportunity, members, to lay out House Bill 969. I'll preface this bill with saying this is probably the shortest bill I have filed in my short tenure here in the legislature, but it is a very meaningful piece of legislation. It's literally one paragraph. I'll warn you, one of the other bills I have will be one of the longest bills that I filed. But this bill simply talks about another option when a non-custodial parent is denied their right to possession. And so currently under Texas law, there's a provision in the Penal Code 25.03 that is actually a felony offense where a law enforcement officer can charge an individual with the crime of denying their children. I've been practicing family law since 1997, actually even before that, as a law clerk. So in my experience from 93 through 2023, which is what a 30-year period, I've never seen a violation under 25.03 in the Penal Code ever occur. That doesn't mean it hasn't occurred in Texas. I've just never seen one. And I only say that to say this. This is a very good tool to have in the toolbox. This is a situation where if a non-custodial parent, a lot of what you've heard in the committee is if that's the father, if he shows up to get his visitation and he's denied, he will have the opportunity to call, and a police officer would actually be able to come out and issue a citation. It's a Class C misdemeanor, and which is a fine-only offense up to $500. And I think in my experience, this would be a more meaningful tool. It would be more widely utilized. This is not mandatory, it's permissive. A city or county would be able to pass an ordinance that would propose a civil penalty for interference with child custody. I'd be glad to answer any questions the committee has. Otherwise, I would like the opportunity to close when appropriate.
Any questions of Representative Cook, members? I guess I was wondering, Representative Cook, would the police officer who shows up have to resolve factual issues or something, or would he just look at somebody has an order that says?
I think that's what you're going to see. I think a lot of times, Chairman, you probably have had the same experience at this state of the game. If a officer is called out, I think we all know that the officer's most likely going to say, call your lawyers, go back to court, and that sort of thing.
Right.
So this bill was actually offered by Representative Raymond last session, and I was sitting on this committee, and at first blush, I didn't really think it was a great idea. But then after I saw the practicality, I really do think it's very effective, because I think it's a situation where if the custodial parent is denying visitation and a citation is issued, my guess is that that's going to stop there. So I think it'll be an effective tool. But it would require what you're talking about. I think it's going to be a situation where, an officer is going to have an opportunity to read a court order and see what it says and make a determination. But that's what they do on almost any type of crime. They talk to both sides, he said, she said, and make a determination.
Yeah, because I wondered if one parent says, we're supposed to drop the kid off at XYZ place. You weren't there, so I brought the child back home.
Mm-hmm.
Police shows up and says, well, it looks like you're engaging in something that's different than the court order says. He said, well, yeah, no, I had no choice. And what's the police officer going to do at that point?
Like I said, I think it's just a situation that the officers find themselves quite often, where they're just, they're going to have to do a little bit of investigation, ask some questions, and make a determination.
Okay.
Yes, sir.
All right. Let's. Do we have any people? Okay. Well, if no further questions, we'll start the public testimony.
Thank you, Chairman.
The chair calls Taryn Champagne.
Good evening. My name is Taryn Champagne. I'm representing myself, and I'm for the bill, and I think I got it right first up to bat. So to Representative Cook's point, right, Texas Penal Code 2503 is somewhat of a joke of a law in Texas. Not that it's a joke in that the way it's written, but in the fact that it's not enforced. Custody orders in Texas are oftentimes minimally enforced. He even testified that, he's never seen it enforced. Parents, mainly fathers, can go for years without seeing their child because one parent has withheld the child from them. Parents are routinely told by the police that interference with child custody is a civil matter, despite being in the penal code. And additionally, odious to what often happens with this, once the parent is finally able to get custody of their kid, they got to go through reunification therapy with their kid because they haven't seen him through years due to the malicious intent of a parent. One has to look no further. There's a Facebook group, the official Team Texas Penal Code 25.03, Interference with Child Custody, to see how much of a problem this is. I checked last night and had 2,367 members constantly asking questions on how they can get their child custody enforced. I get it. No one wants to send a parent to jail because they fear it might be traumatic to the child. However, what is equally as traumatic is playing head games with that kid and keeping them from a fit, willing parent for whatever sick or twisted agenda or maybe upset feelings that one parent has. I've only had to deal with this once, and it was here in Austin, and fortunately, APD came out, and I know they get beat up in the public a lot, but a good kudos to them. They talked to my son's mom and told him, hey, you can't do this. You can't withhold him. There was a miscommunication. Just turn the kid over, and we're good to go. And I ended up okay. But I'm one of the rare people in a situation like this. It upset my kid a whole bunch. By authorizing a civil penalty for failure to follow custody orders, local governments have another tool available to them that's not just jailing one parent. If individuals know there's a consequence for failing to follow those custody orders, they may be more inclined to follow those orders as written. As it stands right now, while there is a penalty on the books, it's not enforced. And those kids, they're denied that access to a loving parent. This is harmful to children, and we need to do something about this issue, and I believe Representative Cook's bill would help solve this problem. Please pass this bill so it can become law and help our children. Are there any questions?
All right. Thank you, Mr. Champagne, for your testimony. Any questions, members? Not hearing any. Thank you.
Thank you.
Chair calls Brandon Johnson.
Brandon Johnson. I'm going to testify, change my testimony to neutral, and I'm representing myself.
And you're shown now as being against the bill.
That's
that
right.
But you want to change that to for?
Neutral.
Neutral. Okay. with your permission, we'll do that.
Yes, sir. Thank you.
Okay.
I appreciate the sentiment in at least proposing the bill. That's my reason for changing it to neutral. But the bill admittedly does not have any teeth, and because the language is may adopt, so it has no shall or duty to enforce. And I sympathize with that because my concern is this would be used as a punitive harassment to a non-custodial mandated absent father who's trying to maximize the little bit of time he does have with his child. And I've had this happen to me, so I'm speaking from experience on this particular bill. Now, if it were amended to say there was mandatory for habitual behavior, where 5 minutes before, whatever, it could become habitual, and it does in many instances. Then possibly amend it where it does have those teeth that says, look, she's going to have to pay $500, go to jail. As soon as you start implementing some consequences for that behavior, it'll stop. And then as far as the police go, if they'll just create a file, which they in most jurisdictions they are not doing, if they would just create a file, then they would be able to establish the history and able, to be able to connect the dots, because it may not be the same officer every time. He doesn't know the history of the case. And then you have documented evidence so that so that the interference of child custody could be enforced. Thank you.
All right, Mr. Johnson. Thank you. Chair calls Cody Taylor.
I'm Cody Taylor, representing myself, and I am for the bill. And thank you, Representative Cook, for understanding constraint of parents. So for years, since this has been put in, I've witnessed myself through others the possibility that they may never see their kid again. So I'll put it to you this way. It does say may. It would be awesome if it said shall. The reason why, aggravated robbery. There was a case not too long ago of an individual who came in to a convenience store. We hear about it on the news every single day almost. If you put that terminology in there and said a city may devise a ordinance on aggravated robbery, well, they could, or they don't have to. But if that aggravated robbery turned into murder, it would be totally different, right? So we're now hearing of these situations where they're going to a drop-off point and they don't care where it's at, and it's becoming violent. It's becoming also deadly. When I say this with all due respect, why do we even have to have this? Our penal code is set in place. Our police department and officers are trained to uphold the penal code, not to come here and say it's civil. If it's already in the family code and it's already a part of the penal code, then why would we need this? And I'm only asking that in more of a retro conversation. I have been a part of this. I have tried to file it. I have actually heard district attorneys tell you that we're not going to push it. I've actually heard officers say it's not going to be enforced. Our DA won't do it. But yet they'll break in a door to go get a father that has a warrant if they have done anything against the child, whether it be a false allegation or not, whether it be child support or not. They will break down a door to go get that father. Then they'll put him in jail. Again, it goes back to, why do we need this when we already have a penal code that establishes it? I think that it should go back to the root is why are judges not enforcing it? And why is our law enforcement not enforcing it? Those should be the individuals that are held accountable. This right here should hold a parent accountable, but again, they don't care. And there's a lot of them out there that are habitual with that, right? We see it on a daily basis. If you spent 30 years in the industry, you probably saw it on day one and probably as you were a law clerk. I want to appreciate y'all's time. Thank you. We're going to be here, I'm sure, late. How do you say your last name?
Lujan.
Lujan. I want to commend you. I drove 4.5 hours to be here today, and you're the only person who sat here and looked me in the eye the entire time I've been speaking. I appreciate that, and so does the public. Thank you.
Any questions with this witness, members? Chair hears none. Thank you for your testimony. Chair calls Steve Bresnan.
Mr. Chairman, my name's Steve Bresnan. I'm here very much in favor of this bill on behalf of the Texas Family Law Foundation. I really appreciate Representative Cook bringing the bill again. We supported this bill last session in 2017. We offered legislation to better enforce custody orders. We're down here a lot. We have different views from some of the people that have spoken tonight. People are complaining about having to pay child support when they don't get to see their kids. They're complaining about how much time they get in their orders. But what we've seen over and over and over again is many of the root causes of this problem are the lack of enforcement of custody orders. When you read 2503 that's cross-referenced in this bill, you'll see it's a pretty steep penalty. There's a state jail felony at the bottom of the list of defenses and affirmative defenses. It's a pretty steep hill to climb. Frankly, I think law enforcement and prosecutors ought to do a better job on that because it's clear from the decade or more that we've been representing people down here that there's been this problem. One of your colleagues in a previous legislature filed a 50-50 bill, and once we got to the bottom of what his son's case was, it had to do with he had the time, it's just that he was being thwarted in his efforts to see his kid by his ex. So something needs to be done. I want to point out some of the benefits of this that may not be immediately apparent to the non-lawyers. This is a broad grant of authority to municipalities and counties to adopt ordinances and orders imposing the civil penalty. When the law grants an agency the power to do something in general terms, it carries with it the implied authority to write the procedures that would go with it. And so officers can be directed via that procedure on how to conduct themselves. There'll be due process built in. Very frequently what happens is on the Class C misdemeanors, fine only, people don't pay the fine. And when they don't, their warrant goes out for their arrest. They can be arrested, brought to the magistrate, put in the jail. When that starts happening, people are going to start complying with these orders. The other great thing about this is it allows the municipalities and the counties to have a variety of different kinds of orders. So some things that might work in Dallas or be a good idea there might not be in Abilene or San Angelo. And so there can be some experimentation going, if you will, and this can be developed in a way that becomes more of a lower laser focused. And finally, I want to point out that in many of these cases involving family turmoil, the cops have been out there before. Addresses get known to police forces. And after a while, they begin to sort things out. And I think that this has the potential to do that. It's not a panacea, it's not the end all, but it's a step forward to enforce these orders. We're going to have our differences on policy, but we ought not to have our differences on whether when an order is issued by a court, it should be enforced. Yes. Period, end of story.
All right. Thank you.
I'll be happy to answer any questions.
Thank you, Steve. Any questions of Mr. Bresnan, members? Not hearing, I guess I had one, Steve. I was
Yes,
trying to reconcile in my mind. And I guess you're right, the municipality or the local government's going to have to kind of decide how to put the teeth in this.
Yes, sir.
So that police officers who go on the scene of something like this knows how to conduct themselves in terms of what they're supposed to ask and what they're supposed to find. Where there's competing claims, which there's going to always be, the police can, I mean, in here, I guess they would end up writing a ticket to whoever they found on the scene at fault.
Yes, sir.
And that person who was given the ticket could always go challenge the ticket, I suppose.
Yes, sir.
And then what happens in a municipal court is the state or the municipality would have to prove that the person was guilty.
Yes, sir.
And I'm trying to convince myself how they're going to do that.
Well, it's going to
Because
be,
a court order, if the court order says one thing and the other party says, well, I didn't violate the court order, but what happened was this or something totally anathema to the court order. What, I mean, and I guess like most municipal cases, you could even have a jury.
correct.
And I'm trying to convince myself in my mind how you get to the end. Because if the court fined the person and the person didn't pay the fine, you're right, they would issue a capers for you and you'd have to go to jail. And I'm not sure just how that all works.
I don't think it would necessarily have to, I think this is in addition to what I said earlier. I don't think you'd necessarily have, based on this language, there has to be a citation issued. I think, I'm just going to stereotype here for a minute. If the man is being denied the benefits of the order, they could file a complaint and go down, and the other party may have to come to court. JPs and municipal courts sort out these kinds of things all the time. It could be on the basis, take your don't have insurance for your car when the officer pulls you over for some traffic deal. You show up with your insurance card, and you show, now we don't have this so much anymore, some of these people are too young to remember when you had to do that, but, you know, all that's online now for the officer on the street, but, or on you could have it on your phone. It used to be you'd show up with your proof of insurance, but you had to show up, and if you didn't show up, in this case, if there's an officer on the scene, the child's not with one of the parents who's claiming that right, you may have to go down, they may not have the order with them, and you know, officer, there's problems even with presenting an officer with evidence out there.
Right.
But officers sort these things out all the time on the street, and somebody ends up having to go down and show that, no, they were in the right or they were in the wrong. And the broad nature of this language, I think, allows for municipalities and counties to customize and work some of these things out.
Yeah. Okay. I hear you, and I think I understand it a lot better. And I think the devil would be in the details of how the local governments respond to this.
Yes, sir.
Yeah. So.
Well, somebody, I think it's far better than this legislature doing nothing. These orders have to be enforced. A good amount of the conflict that shows up in your committee could be resolved, I believe, if these orders were being enforced. And you know, it's lawyers are expensive. So to go back to court and seek a contempt order and to do it pro se is difficult, and to have lawyers is difficult. This is a non-lawyer way to go about it.
And judges sometimes don't want to find the custodial parent in contempt.
Sure.
Yeah. Okay. Any further questions, member? Mr. President?
Thank you all for your
Thank you,
service.
Steve. Chair calls Jeffrey Morgan. Going.
My name is Jeffrey Morgan. I am testifying on behalf of myself. I am testifying in support of this bill as well. A municipality may adopt an ordinance in order that imposes a civil penalty of not more than $500 for describing conduct, for the conduct described in Section 2503 Texas Penal Code. Section 25 of the Texas Penal Code is crimes against the family. This is a criminal action. And as others have said, nobody necessarily wants to see the other spouse have a criminal action against them. It's traumatizing to the children. This is something that, but it is law right now, it's just being ignored. When police officers get called, they say it's a civil matter. Well, make it a civil matter then, fine them. And I would say that perhaps instead of saying may, it should say shall, but that's something that the committee and others would have to decide. The devil is in the details, somebody said, I think it was Chair Dutton, you said that actually. The devil is in the lack of education of our police force. They always say that it's civil, generally speaking. Okay, so I've been in a number of these cases where I've watched them. Mr. Champagne, I've been able to watch his Olga Ventura. She's a disabled veteran and practicing nurse, pediatric nurse up in Rockwall, Texas. I've been to court with her about 4 times just to watch and observe what takes place. Police want to testify on her behalf. The judge would not let the police testify. She has not seen her kids frequently for years. So it happens not just to men, but to women. Like I've said, we've advocated for both men and women. Brandon will not talk about his story in the detail that I might. But he has an ex-wife that left him and went for another woman and everything else. I tried to go out there to just be a reasonable person to say, let him see his kid. I went into the restaurant and just said, can I talk with the manager? She kicked me out and she said, the kids don't want to see you. And so I called the police officer. I showed them the Texas Penal Code, and they would not enforce it whatsoever. I actually have video footage of that. Then we saw the video footage later on of the police officer, and he's joking about it, like, oh, I've seen this happen and everything else. That was dereliction of duty on his part. Went to the judge, the attorneys, everything else. It's been very bad what took place in that situation. Brandon's mother died several months ago. Had not seen the grandchildren for several years, was being brainwashed by the ex-wife. My stepfather is in a situation, again, he was kicked out of his home by his wife at the time. Police came to protect me. One day I was in the yard, and the police came to protect me. What's going on here? His ex-wife, or his wife at the time, was making threats to kill me, so the police came to protect me. What did I have to do with any of this stuff? Never miss a child support payment. Everybody's concerned about child support. Never miss a child support payment, everything else. He hasn't seen one son for over 40 years. And that's a shame because of the brainwashing that has taken place. Still trying to see him right now, but that's the result of not enforcing this. The only recommendation I might make is that perhaps, Representative Cook, you might consider a sliding scale, 500, 1,000, 2,500, or maybe at the 4th offense, flip custody, and also the child support obligation. That would have a very strong effect. Anyway, that's it. I appreciate it.
All right, thank you, Mr. Morgan.
Thank
Any
you.
questions, members? Not hearing any, thank you. Chair calls Delilah Crosby.
My name is Delilah Crosby. I'm representing myself as an advocate for Team Texas Penal Code 25.03, and I am in favor of this bill. First, I'd like to say thank you, Representative Cook. You are my representative, and Mansfield PD has tried to enforce this, the current interference with child custody. Not only has Mansfield PD, I have been successful with Waxahachie PD, I have been successful with constables in Dallas, and I have been successful with Mesquite PD. This is because I'm a woman. None of these fathers have been able to advocate for themselves, but I have been able to successfully advocate on their behalf to get these orders written up, these charges written up, I apologize. But the DAs is where we cut off. So if we're gonna have the DA saying we can't charge this, we can't move forward with this, then we must move towards another solution, which is a civil penalty at this point. Our group, Team Texas Penal Code 25.03, originally had 13,000 members and growing. That group ended up hacked. We have since been growing in massive numbers still, even with our hack. And that right there shows that this is a continuing issue. Another issue about this is that if a father were to deal with interference and we are turned away, we are told we have to pay about $7,500 and up just to get back into the courtroom to get new orders, new temporary orders. And those attorney fees are never awarded to these fathers who had no choice but to go back to court. They already have orders that are not being enforced. Also, if we start writing up this as a civil penalty, that would become evidence for family court issues. That would be evidence to show the mental health effects on these children. My nephew has not seen our family for over 5 months now. Mother is in contempt of court orders, but father cannot afford an attorney right now. So we won't be able to see him until father can afford an attorney. If we put this through where the municipalities will be able to handle it, we'll move quicker with these issues instead of burdening the family court with more trials and cases. Also, I wanted to address your concerns about how the police will confirm that this is true. I kind of look at it as like child support. If fathers will say, I paid cash though, but I did provide diapers, but I did do that. And the courts will say, well, we didn't see it, so now you're gonna go to jail. This is kind of the same thing. Like, this is the orders, you could say that, but these are the orders, so we're gonna go by this, and police are not the law. So they just need to write up the charges and let the courts decide that. And then from the civil court, that father can now take it to the family court to truly address the custody battles and the issues that are going on with the high conflict parent. And as we stated, police officers do know the same address. As I've stated, I've had to do this numerous times with my own family, unfortunately. And Waxahachie PD eventually was able to get mother to start giving us the child. But that doesn't always happen, especially not for the fathers. So I do recommend that, yes, the language maybe needs to be clearer on how the police are going to. I already tell these fathers that court order you have, make sure you have a certified copy in your car at all times. It's more important than your birth certificate at this point. Just 2 weeks ago, I had a father go down to Mesquite PD and provide it in advance because we knew that mother was going to be violating the court order. And since then, the constables have assisted him. They have reached out to mother, and they have been able to resolve the situation. But it stops right there. It depends on who wants to help us. So this would bring a lot of resolve to this issue.
All right, thank you, Ms. Crosby. Any questions for Ms. Crosby? Thank you.
Thank you.
Thank you for your patience, too. Chair calls David Green.
Chairman and members of the committee, my name is David Green. I am testifying on behalf of myself, and I am for this bill. In the family court system, there needs to be more penalties put into place when one parent withholds a child from the other parent. This bill will encourage parents to encourage their children to have a relationship with the other parent. I understand sometimes children may be hesitant to go with the other parent as they may be hearing negative comments about the other parent, but having a monetary penalty will help discourage that kind of behavior, as the penalties for not transferring children over to the other parent is going to increase with the civil penalty. This bill will also reduce attorney fees, as there will be less cases of enforcement in family courts for denial of possession. Additionally, the parent who is being denied possession may have also had plans with their children, vacations planned, or expenses that have already paid for that they're not able to get refunded or reimbursed after they've been denied access to their children and they have to cancel everything they were planning to do. So this bill will prevent that from happening. So I encourage the passage of this bill. Thank you for your time.
All right. Thank you, Mr. Green. Thank you for your testimony. Any questions of this witness, members? Not hearing any. Thank you. The chair calls George Saldana.
Hello, my name is George Saldana. I'm for this bill. Thank you, Representative Cook, for bringing up this bill again. What was the third question? I always forget that one. Who do I represent? Yes. I represent myself, my children, and Texas Team 2503. I am the founder of this movement. September 1 of 2017, I started this. I started this because...
Wait just a minute now. Your registration says you're only representing yourself.
Oh, okay, well, we can represent myself as well.
Okay, well.
I mean, if you want to change it, you can, if not.
What do you want us to change it to?
And represent all the parents of Texas Team 2503.
Texas Team 2503.
Can I get my time back just a little
Yeah,
bit?
sure.
Okay, thank you.
What is it?
Oh,
Texas Team 2503.
correct, the parents, yes.
T-E-A-N?
Texas Team, T-E-E-N, 2503. Okay, is that what?
I don't know. Is it Texas Team? Just Texas Team 2503?
Yeah, that's what he said. Texas Team 2503, right?
Yes, sir, I'm the founder.
Okay, all
It's a
right.
grassroots organization.
Okay, so we'll show you as representing yourself and Texas Team 2503.
Yes, sir.
All right,
Okay.
you may proceed.
And I can get my time back, sir?
Sure.
Yes, sir. Okay. Do you want to restart it or no?
Go right ahead.
So I'm the founder of Texas Team 2503. There are systematic failures in place, and I'm going to go over some of them. I consider myself almost a expert in this field because since September 1, 2017, that's all I've been doing. Before that, I didn't know where my son was for 22 months. I called law enforcement. Law enforcement told me, if you want to find your son, go hire an attorney. Even though interference with child custody is included in the Code of Criminal Procedure 63.001 that states the retention in violation of a court order or judgment. 63.001 of the Code of Criminal Procedure refers to what a missing child is. So when I am awarded custody and I show up to the location, I call law enforcement, I want to know why my child isn't there, because at that time, child custody determination set by the Texas Family Code goes over possession and access as visitation and me having legal custody by the authority of the judge that gave me my court order. When I call law enforcement, I have a problem. For them to refer me and tell me it's a civil matter, this is a big issue. This issue is for me and for Team 2503, but it really goes out to Mr. Chad Reed. Chad Reed was shot in the chest while trying to locate his child. He has made the ultimate sacrifice for his child. Now, with these systematic failures, the Code of Criminal Procedure 2.05 says that a district attorney, if it be a felony, shall forthwith the felony before a magistrate of the county. Every policy and procedure that we have obtained through public information requests on these law enforcement agencies say they have to report this felony. We have to now go through internal affairs. Internal affairs has to do their investigation just to give us an offense report for interference with child custody. All this just to see my child. I haven't seen my child now. I saw him. I didn't know where he was for 22 months. I saw him for a little bit, got back into heavy litigation, and now I haven't seen him for 18 months. Kim Ogg, the Harris County DA, has an unwritten policy is to send them back. We obtained it through public information. That is an elected official oppressing me, my right to know where my fundamental right to my child, and going against the court order by not allowing me to bring that felony complaint before her office. I didn't legislate that. In fact, if this passes, September of 1973 was the first passage of this bill. It's going to be 50 years that people have been telling all these parents wanting to see their children, it's a civil matter. The Texas Attorney General sets up possession and access if they have Title 4D orders. But guess what? We don't help with that. But they'll get possession and access grant money from the federal government, and they'll give it to agencies to do research, just like all the statistics that everybody has been spewing out today. About 80% of the children that don't have fathers involved end up going to jail. So the passage of this would be great. Thank you, Representative Cook. Some of y'all might think of me as a bad man, but I come here to do business. I'm not here to fluff any feathers. Thank you.
Thank you, Mr. Saldana. Any questions, members? Not hearing any. Thank you. Chair calls Kimmy Lynn Reed.
My name is Kimmy Lynn Reed. I am testifying for this bill. I'm representing myself, my son, Johnny Mason Murray, and Lone Star Family Advocacy. So, as previously mentioned, I have been advocating for approximately 3.5 years. The primary thing that we advocate for, that started me in advocating, is the enforcement of Penal Code 2503. Penal Code 2503, just to walk you through the procedure, Chairman Dutton, since you've heard so much testimony, I'd like to just walk you through that. So we will typically go to a police station on a Friday night or at around 6 o'clock and just wait around. You will, at 6 o'clock, you'll see the fathers, typically fathers, standing there waiting for an exchange to happen. They'll wait, 7 o'clock will roll around. We'll go up and say, hello, would you like some help with trying to garner access to your child? We'll walk them through the procedure. Do you have an original copy of your order? Okay, walk inside the police station. We walk inside the police station. May we get an officer? We wait for about an hour to get an officer to the co-ban. Once the officer shows up to the co-ban, we get the dismissiveness, just like you've heard others testify to. Civil matter, take it up with your wife, don't call us, basically. So then we've decided to escalate it. Well, give me your boss. So the boss comes out, and he is more often than not angered that we've bothered him. But then we amp it up by saying, listen, if you don't do your job and give this father a Penal Code 2503 felony offense for the parent who is withholding the child, we're going to do an internal affairs investigation for you come Monday morning. So begrudgingly so, we can twist the arm of a police officer and make them do their job. Now that we've made the police officer do their job, that father can do pretty much nothing with it. He'll go file it, and just as you've heard everybody testify to, district attorneys get to pick and choose the laws that they enforce, and 2503 is one of the laws they just choose not to enforce. They just choose not to. I have one father that I'm working with right now that we've actually been able to get 18 felony offense reports for, but the judge doesn't care. The judge sees 18 of those roll in, and this father still does not have access to his child. Adding a fine to this will significantly increase our ability to be able to leverage a parent to do the right thing. It's all we want is access. Thank you.
Okay, thank you, Ms. Reed. Any questions, members? Not hearing any, thank you for your testimony. Chair calls Robert Garza. Robert Garza. He is for the House bill, but will be shown as not testifying. Chair calls David Bello.
David Bello, testifying in favor of this bill, and I'm testifying for myself. Thank y'all for being here, listening to us testify in favor or against some of these bills. It's you know, it is a tough job. Politics in general is tough, and you got some people one side hate you, some people on the other side love you, and then the next day they flip it and they'll love you on this bill and they hate you on that one. But at the end of the day, this is what's best for kids is what we should ultimately look at. And it's best for kids to have both parents involved in their lives. And it's a shame that in Texas, we have judges ruling on custody, and then when one of the parents goes to get the child, the other parent just decides, oh, I'm not going to give you the kid in violation of a custody order. And, you know, there's no remedy. It's against the law to do that. It's a state jail felony, and yet it's not enforced. Who knows? Maybe if the state passes a bill to require DAs to enforce the law, like it's going through the House right now, maybe you'll actually see a lot of people handing over their kids so they don't get hit with a felony. But a lot of DAs don't, I suppose, enforce this law because it is a drastic it's a felony. And so this bill, what it would do is it would give officers the option to issue a citation. You know, nobody wants to pay $500. You know, that alone is going to make them know, let the parent who's doing the wrong thing know, this is a serious matter. And you're going to keep getting hit with $500 or worse if you don't follow the order and let the kid see the other parent. Because we've already gone over the detrimental effects of unequal parenting and fatherlessness. And it's not even, this issue is not even about fathers. Equal parenting and 2503, interference with child custody, actually has to do a lot with women. We've heard of a lot of women who also are denied access to their children in violation of a court order. And so this is going to help women, men, and mostly it's going to help kids. And so I ask that y'all support this bill to help enforce penalties. And also I ask that you look into the root of this issue of why do parents not want to let their kid go see the other parent? And it's because when they first go to court, they're already starting off fighting because they're uneven and they're told they can fight for more time or keep the kid from the other parent. So if they go to court on equal footing as equal parents, then we wouldn't have a lot of these issues. But while we do have the issues, a fine for violation of interference with child custody would really help a lot of parents see their kids. And so thank you, Representative Cook, for filing this bill. And I
Thank you, Representative.
hope that y'all support this.
Thank you, Mr. Bellows.
Thank you very much.
Any questions, members? Not hearing any, thank you. And the chair calls Charles Sisk. Cease. Cease, okay. I'm going to get it before the day's over.
We've got a few more opportunities to train you up. My name is Charles Stephen Cease. I'm testifying for this bill, and I represent myself and my family. This is a good start. It's not perfect. It's not great. Could go further. We could say shall instead of may. It relies on the municipality to go ahead and adopt an ordinance. I have been advised to always carry a certified copy of my orders with me. I have them in each of my vehicles, and I have one by the front door, and I have an electronic version in my phone all the time. So the way I see this playing out is, you'll have the complaint, officer will come out, look over the orders. The municipality will already have trained him up, and he writes a citation right there and hands it over. I don't know if they use carbon copies anymore. In my day, last time I got a warning, it was there was a carbon, and I think I got the carbon, and he kept the original, and it went to the JP. That I think that's the way. And nowadays it may be electronic. This will probably work the same way, and then I might, if I'm making the complaint, I might have to show up and bring my orders with me. That might be part of the requirement. I don't know yet. This is a step in the right direction. It's not perfect. It'd be better. I'll take questions.
Okay, any questions of this witness, members? Not hearing any, thank you.
Thank you.
I believe that's all of the witness affirmations we have. Is there anyone else here who would like to testify for, on, or against House Bill 969? Chair hears none. The chair recognizes Representative Cook to close.
Too many bills now. Sorry, Chairman. All right, thank you. I'm going to try to address just a few of the comments very quickly. I know we're short on time this evening, but this is local control. This does, as the last witness testified to, the may or shall relates to whether or not they adopt. It's not part of the elements of the offense, and so it is whether or not a city or a county decides to do that. Another issue was whether or not the fine of $500 was too much. This legislation gives the city and counties an opportunity to assess a fine or actually create an offense of anywhere between $0 and $500. It's not automatically $500. It's up to $500, no more than $500. And Chairman, I think to your question, I think what I would say is, we always hear like, the possession is 9/10 of the law. And in this case, that's what we're talking about is possession. And so I think the best thing that this bill will accomplish is compliance. And that's really what we want. That's what, as lawyers, as parents, as human beings, as people just trying to get things done in life, really what we want is compliance. And so when people go to court and they get a court order, they expect it to be followed. The judges expect it to be followed. And so whether this is a situation where a citation is being issued on the scene, like this bill provides, or someone in the alternative has to spend money and take it to court and seek an enforcement, I believe this is a much quicker and much more inexpensive option to enforce court orders. And whether or not there's jail time involved, I think a couple of witnesses talked about that as well. If you receive a civil offense and you don't show up, a judge can issue a second charge, which is a failure to appear, also can issue a summons or a warrant to have you arrested. Also, if you violate a court order in family court or in your divorce court, then you also can be thrown in jail for violating that court order as well. So lots of different options here. I just think this is a quick and easy opportunity to establish compliance, and I would ask your favorable consideration. I appreciate the opportunity to lay out House Bill 969, and be glad to answer any further questions.
Well, I was just looking at Penal Code 2503.
Yes, sir.
And it says a non-custodial parent commits interference with child custody if, with the intent to interfere with the lawful custody of a child younger than 18 years, he or she knowingly entices or persuades the child to leave the custody of the custodial parent, guardian, or person standing.
I believe that's Section B. If you look at Section A, it's where it talks about a custodial parent.
Well, that's what I was going to ask.
Yes, sir.
So
Yeah, I think-
Section A is what this bill references. Is that right?
Google is, if you did Google, I think Google is misdirecting you, because for some reason 2503B pops up first, but 2503A would be the most likely scenario.
Okay, so 2503, well, since it's written that way, it would include both A and B, wouldn't it?
Yes, sir. That is absolutely correct.
Okay, and A.
So if your question is, this could also happen, if the non-custodial parent refused to return the child, then this could also be a situation where the officer is issuing a citation to the non-custodial parent who's overextending his or her welcome of the possession of the child.
Right, that's what I was getting.
Yes, sir, that is correct.
Yeah,
That is the intent, and I believe that that's how it would be enforced.
All right, okay, I got it. Any further questions, members? The chair will leave. House Bill 969, pending 969, as a matter of pending business before the full committee without objection. Chair has none, so ordered. Chair at this time lays out House Bill 3380 and recognizes Representative Cook to explain it.
Thank you, Mr. Chairman and members. Appreciate the opportunity to lay out this House Bill 3380. This bill relates to adoptions and is an opportunity to try to make the laws more uniform so that adoptions that take place across the United States have more uniformity. And so right now, as you can imagine, there's just like we hear a lot of arguments on the House floor and in these committees nowadays about cities having patchwork ordinances and having lots of different approaches. The same is true when you look at state laws throughout the United States with regard to adoptions. And so there's been a lot of work, specifically 4 years of study through the Uniform Laws Commission. I know the Supreme Court Justice Lehrman has served on that committee, and many others, and I know there's at least one or two witnesses that we'll hear from tonight that have been involved in this process as well that can give you more details. But the purpose of House Bill 3380 is to simply make it a more uniform approach, and obviously this will be a situation where we will need passage throughout the country in order for this to apply in each state. And so I'll be glad to answer any questions if the committee has any at this time. Otherwise, I'd like an opportunity to close when appropriate, Mr. Chairman.
How many states have already done this? Do you know?
I don't, but I know we have a witness here that can answer that for me.
Okay, all right, okay. Any questions, further questions, Representative Cook? Not hearing any, we'll give you the right to close.
Thank you, Chairman.
Chair, at this time, we'll start the public testimony. The chair calls Heidi Cox.
Thank you, Chairman Dudden, Vice Chair Lujan, and the rest of the committee, and thank you, Representative Cook, for filing this bill. So your first question was, where has this already been passed? It's been passed in Washington, Utah, and Colorado. It's currently pending in North Carolina and South Carolina. This bill came as a result of the Uniform Law Commission, which you know is part of the ABA, and they look at what can they do around the country to bring some uniformity. It's not intended to make everybody's adoption laws exactly the same. It's intended to do some things that protect children. One is limiting advertising for children. And I've given you a handout that shows a specific ad that if you Googled, you could find an ad where it's rich parents looking to give you and your child a rich life, all expenses paid, cash available. This is out there, and that's an attorney from New York who actually is responsible for these ads. I've worked with New York people in the bar trying to do something about it and have gotten nowhere. So it does that. It gets rid of the advertising unless you have your license as an agency to advertise, and also requires license placements so that if you're working with an expectant mom on an adoption plan, that you need to work with a licensed agency in the state unless it's a relative or a close friend. It uses specific language about someone who's within your close personal relationships. So you can still do a private adoption with an attorney if you know the family you're placing the child with. But what we're seeing is facilitators, and most of them are in California, that are advertising and they're really targeting Texas and Texas expectant moms. And then they match these women to families around the country. And then, so then they have the baby, they leave the state, the child is taken from Texas, they leave the state and placed in other states. Lots of money is involved, and women will tell you over and over they didn't know what they were getting into. Obviously they were not counseled, and and then what was promised to them is not what they get in the end, which what they need is services and access to the adoptive family or the child, whatever they thought they were getting out of the adoption. So this bill tries to have all the states follow the same rules about advertising and about who has the authority to match and place children for adoption to protect children. This bill started out as a bill for replacing older children who'd been adopted from foreign countries. Actually, it didn't start as a bill for infants or private adoption in the states. It was brought to the ABA by the Department of State because so many children were being rehomed, which is the term of art that was used for children who'd been adopted and then replaced. Senator Parker, formerly Representative Parker, already passed a bill in Texas to make that a felony in Texas. They used part of that language in trying to create the language for the replacement part as part of this bill. These are the two major sections, and I'm happy to answer any other questions because I know we're out of time. There's a lot of it.
Thank you, Ms. Cox.
Sure.
Thank you for your testimony and your patience for being been here a while. Any questions of this witness members? Not hearing any. Thank you, Ms. Cox.
Thank you very much.
Chair calls Christina Dean.
Good evening, Chairman Dutton and committee members. My name is Christina Dean, and I'm a licensed clinical social worker with 27 years' experience in adoptions, both through Child Protective Services and licensed child placing agencies. I'm also a resident of Keller, Texas, a mother of 5, and have many adoption stories within my family. I'm testifying for myself and Legacy Adoption Services in support of House Bill 3380. As the co-founder and executive director of a licensed child placing agency in Texas that works with voluntary adoptions, not adoptions through CPS, not foster care, just voluntary adoptions, I've met many, many women who unknowingly find themselves talking with an unlicensed organization posturing as an adoption professional. These organizations do not meet or adhere to minimum standards set forth by Texas Department of Protective Services for child placing agencies. These organizations are contracted by hopeful adoptive parents to find a baby to adopt. When a woman with an unplanned pregnancy searches online for an adoption organization and then gets a warm voice on the phone, they think it's safe to start planning their adoption. The problem? She doesn't know if the organization is licensed or not, and even what that would mean to her. Unfortunately, this unlicensed organization is playing the role of a matchmaker only, and once the match is made, the vulnerable expectant parent is left to fend for herself. Pregnant, trying to do the best, most selfless thing she can for her unborn child, with no one to advocate for her, counsel her, or ensure her and the child's needs are truly being met. Having a licensed child placing agency proactively provides options counseling to expectant moms that are experiencing crisis. It allows for healthier parenting plans, which includes voluntary adoptions, to be put into place. Overall, this can result in carefully planned placements occurring, thereby reducing the number of interventions that Texas Child Protective Services is called into. Think about this as a comparison. When we think about health care, like having a surgery or even something as simple as having your tooth pulled, these procedures are required to be performed by a licensed professional. When they are licensed, minimum standards are mandated. They take the Hippocratic Oath to first do no harm. Adoption is a life-altering event, not just for one person, but for many. So in the best interest of the child and in all other members of the adoption triad, a licensed child placing agency should be the standard in working in adoptions. Unsupervised, unlicensed placements put children at risk of improper matches, abuse, neglect, and trafficking. I've also attached and provided a copy to you of a letter from Marcela Marina Carrillo. She, 30 years ago, did a placement through an unlicensed person here in Texas, and she talks about now, as an adoption professional, the differences that she knows she should have had in her adoption and why she went through so much trauma because of what she did not get in her adoption journey.
All right,
Thank you very much for allowing me to speak today.
Thank you for being here, and thank you for your patience as well. You've been here a while, too. Any questions of this witness, members? Not hearing any. Thank you again.
Thank you.
for
Have a
being
good
here.
evening.
Chair calls Jeffrey Morgan.
Thank you, Chair Dutton. My name is Jeffrey Morgan. We're going to testify on this bill. I represent myself. Honestly, I don't think I'm qualified to speak on the bill, so I'm just going to hold it right there. Thank you.
I'll work with Keith. All right, thank you. Chair calls Brandon Johnson.
Brandon Johnson, neutral on the bill, and represent myself. I don't really particularly have any ties to this bill. The previous lady's testimony was, the part that I heard was compelling, that it needs to be passed. What piqued my interest was just the uniformity of it being a more or less a federal bill that's just being handed down to the states. And where my interest kind of peaks up in that is because of the Title 4D being a similar situation and seeing the negative consequence of that, uniformity across the states. I'm not saying that's going to be the case with this bill. It sounds good, but that's my reservation on it. Thank you.
All right, thank you, Ms. Johnson. Any questions, members? Not hearing any. Thank you. That is all of the affirmations I have on this bill. Is there anyone else here who would like to testify for, on, or against? Let's see, I can't read what this is. I'm sorry, I'm trying to read my computer. It keeps going in and out. Chair recognizes Representative Cook to close then.
Thank you, Chairman. I believe the witnesses did an excellent job of laying out what this bill does, and I appreciate their hard work on this. And just with regard to the comments of the last witness, I just would offer that this is not this is not federal. No legislation from the federal government has been passed or anything like this. This is more of a collaborative approach where people in the industry have gotten together and made these recommendations, and so it's up to this state legislature whether or not we want to pass it or not. So, just want to make that clarification. And otherwise, I close. I'm available for any questions.
All right, any questions of Representative Cook, members? Not hearing any. It's the chair's intent to leave House Bill 3380 as a matter of pending business before the full committee without objection. Chair hears none, so ordered. Chair lays out House Bill 2969 by Cook and recognizes Representative Cook to explain it.
Thank you, Chairman. Members, this is another short, straightforward bill, but a very important bill. It's also in the arena of adoptions. And this bill simply, it's like I said, it's very important. It's brought to us by a constituent that it's also from Mansfield, and he had a situation where he felt like he was being discriminated based upon his age and his efforts to adopt a child. I believe they were here earlier. I'm not sure if they're still here, Chairman, but I guess we'll find out here in just a moment. But he had to take legal action in order to protect his rights, and after Health and Human Services got involved, and after the lawyers got involved, and after he spent significant sums of money, he was later able to move forward with an adoption. But what this legislation does is quite clear, very straightforward. It just says that the Department of Family and Protective Services, a single source continuum contractor, or a licensed child placing agency, which are experts, as we've been told this evening, they perform a great service. It's very important for the children of Texas. And what it says is that these organizations may not implement or enforce a policy that sets a maximum age or sets a maximum age differential between a child and a prospective adopting parent. And so it also allows and says that however, they may consider the health and expected lifespan of each prospective parent. So basically, it's just saying don't make a broad-based stroke, but you can look at the expected lifespan and the health of an adopted parent. So that's all that this bill does, and I'd be glad to answer any questions and appreciate the opportunity to lay out this legislation.
All right.
I'd like an opportunity to close when appropriate, Chairman.
All right. Any questions of Representative Cook, members? Not hearing any. We don't have any. We will start the public testimony. We have Chair recognizes Brandon Johnson.
Brandon Johnson, for the bill and represent myself.
Okay.
I just want to make sure that I didn't testify or I didn't put on your sheet that I was neutral.
You did.
I did put neutral?
You did put neutral.
So I would like to change that to 4.
4, okay. With your permission, we will do that. We will show you Brandon Johnson as being for House Bill 2969 as opposed to being neutral.
All right, thank you. No, I'm not going to testify.
All right, thank you. Chair recognizes Jeffrey Morgan.
I'm sorry, I didn't go to use the facilities there. Can I ask which bill we're on, 2969?
2969.
Okay. I apologize, I don't even know what the bill is right now. Can I have a moment or not?
Well, you can always catch it next time. It comes around.
Hold on, let me get my paper. I might be able to pick it up here, sorry about that. Okay, 2969 is, you know what? I'm registered as for.
Please identify yourself.
My name is Jeffrey Morgan. I'm registered as for the bill. I'll stick with that.
You're registered as neutral on the bills.
Oh, okay. Obviously, I don't have the bill in front of me, so I apologize. This is the, okay, so it's the maximum age for prospective adoptive parents, maximum age differential between any. I honestly don't remember my testimony right now. I'm sorry. I thought I was going to have more
All right,
time. That's
okay.
why I ran down there. So,
Okay, well, thank you. Thank you for your non-testimony.
thank you.
You want to leave it as neutral, though, right?
I guess so. If I change it, I'm changing it in ignorance right now.
Okay, all right. Well, we'll show you as neutral. Is there anyone else here who would like to testify on, for, or against House Bill 2969? Not hearing any, chair recognizes Representative Cook. What was the next one they wanted?
Mr. Chairman, I will close unless there's any questions from the committee.
Okay, any questions of Representative Cook, members? Not hearing any, the chair's intent is to leave House Bill 2969 as a matter of pending business before the full committee. Chair lays out House Bill 1546 and recognizes Representative Cook.
Thank you, Chairman. Members, this is the longer bill that I talked about earlier, but it's longer in pages. This one's about 28 pages. And the reason it is longer is because basically it goes through the Texas Family Code and makes it more consistent with regard to attorney fee, reasonable and necessary attorney fees, court costs, and expenses. And so if you look through the code in your spare time and you look throughout, sometimes you'll see references to necessary attorney fees or court costs, but not expenses. And so the intent of House Bill 1546 is to go through and make it consistent within the Texas Family Code that reasonable and necessary attorney fees, court costs, and expenses are consistently referred to throughout the Texas Family Code. And I'd be glad to answer any questions that members of the committee have. Otherwise, I would like an opportunity to close when it's appropriate, Mr. Chairman.
Okay. Let me ask you a question. In a motion to modify, when can the loser be awarded attorney fees?
Can the loser? I would think that's within the discretion of the court, but I think it would be very, very, very unlikely.
Because I had a complaint that that was the case, and I wasn't sure that was the case, but and I tried to find it, but I couldn't.
Yeah, I think it'd still be within the discretion, but I mean, I would think that I would find that to be very difficult, in order to identify a set of actual facts where that would occur, because I would think that the court, if they granted fees at all, which, as you know, most of the time they don't, each pays their own most of the time, but if they did, yeah, I would think it would be a situation where the losing party maybe went overboard, let's say, with regard to the litigation. I think that's a situation where you might see a judge grant it in the instance of a modification.
Okay. All right. Well, any questions of Representative Cook, members?
Thank you, Chair.
Not hearing any, we'll give you the right to close. Chair, we'll start the public testimony. And the chair calls Charles Cease. Okay, I got it. It's been a long night.
You got it. I'm Charles Stephen Cease. I'm testifying against HB 1546, and I represent myself and my family. I'm concerned that freeing the attorneys to be debt collectors, quote, by any means available, will be seriously abused. I think it deepens the established peonage instead of relieving it. And I'd like the committee to not pass this bill. I can take questions.
All right. Thank you, Mr. Cease.
Perfect.
Any questions, members? Chair hears none. Thank you for your testimony. Chair calls Delilah Crosby. Oh, there she is.
My name is Delilah Crosby. I am speaking on behalf of the Crosby family, and I am against this bill. So I'm against this bill because most of the times we are required to respond to a lawsuit in family court. We don't even have a choice, and if we don't respond, as you can see, my husband's rights were terminated because we could not afford an attorney. We did this for 7 years. My family had to live out of a food bank to afford our attorney fees. It is absolutely ridiculous, the cost to go to these battles. Right now, the average is about $7,500 to get these started. We have spent closer to $40,000 at this point. We won every time we were willing to pay, but we went through periods of time where we could not afford it, so we would not see our child. There's a huge issue with this because, in our case, the opposing counsel, Kenneth Lundberg, regularly filed that my husband was not paying child support, and we would have to pay attorneys to go prove that he was. He would regularly file all kinds of motions, and we would regularly have to fight back. TROs, just the most ridiculous lawsuits, and we won every single time. We went through 2 CPS cases. His hands were involved with both of those cases and with 2 different counselors. All were in our favor. And then he went on the stand and asked for $29,000 from my disabled husband. The court did not approve that. They did not grant that. They also dropped all my husband's arrears, but they also terminated his rights. And my husband could not afford to pay those fees anymore. I also just started pre-law school. I'm sorry, I didn't just start. I'm almost done. And what I have learned in all my classes through all my professors, which are former lawyers and judges and all of the above, is that they tell me I'll be rich in family court. It's not a great place to be, but you'll definitely be rich doing it. And I find that to be appalling. Everyone knows that this is a money-making business. I actually, when my first divorce, sounds crazy. When I went through a divorce, we were supposed to pay $3,500 to an attorney to do a contested divorce. We ended up doing it ourselves, and it cost us about $160, and it took no more than 2 hours of our time. That includes driving to actually file it, the notary, anything. The total hours was about 2 hours, so I don't understand how $3,500 for a contested divorce makes any sense at all. Also, a lot of these fathers are given billable hours, and when we look at these billable hours, there's these charges where reading an email, a 2-line email, is being charged $325 or something of that sort. It does not, I'm pretty sure we can all confirm, it does not take us an hour or 15 minutes to even read a 2-line email, nor should it cost $325. But the fact of the matter is that attorney fees are nothing for the wealthy, but it does hurt the poor and the middle class, and that is something that we should not be forcing upon them to cause further debt. That's money that could go to these children. It could go towards their college degrees. It could go towards any other fees, really, extracurriculars, counseling, whatever they need going through this. But overall, we should not be forced to pay fees when we are forced to respond. And yeah, that's it.
All right. Thank you for your testimony.
Thank you.
Any questions for Ms. Crosby, members? Not hearing any. Thank you, Ms. Crosby, for being here. Chair calls Carlos Salinas.
Thank you, Chair Dutton. Members, my name is Carlos Salinas. I'm testifying on behalf of the Family Law Foundation in favor of this bill. I certainly want to thank Representative Cook for what I think is an excellent and very important bill. And I want to be clear, just to respond to and my read of this, to respond to any concerns that have been expressed. This is not creating a new statute that is going to somehow increase litigation costs. This is simply making uniform the existing statutes within the family code that have to do with attorney's fees. Honestly, I think inconsistency breeds confusion. Confusion breeds litigation. Litigation is what's expensive. Attorney's fee statutes that are useful and enforceable and that give the court the discretion to penalize the bad actor in the case, I think really do mitigate bad acts by people. It discourages them to do the bad acts. So I'm very much in support of this. And honestly, this is really just a cleanup bill. I am happy to cede the rest of my time for any questions if anybody has them.
All right. Any questions of Mr. Salinas, members? Not hearing any. Thank you for being here. Chair calls Jeffrey Morgan.
You skip Cody Taylor.
He comes there.
Thank you. My name is Jeffrey Morgan. I am testifying on my own behalf. I'm testifying against this bill. I do have a handout that I'd like to pass out as well. I thought it was only going to be a couple of pages. I accidentally made it 7 pages. So it comes to the United States Department of Justice, actually. And it talks about, again, the 14 ethical principles, the principles of ethical conduct. And I don't know why this is such a big deal with me, that, that everything be done ethically, that, above board. I am an employee of the federal government, the executive branch of the federal government, and we are held to very high standards when it comes down to this. But one of the things that I was always concerned about, and I'd mentioned it last time to Representative Cook, he mentioned that he took it to the Texas Ethics Commission with regard to Article 3, Section 22 of our Texas Constitution, whether he could use his private office or his public position for private gain. And I understand that you're trying to make this bill consistent and stuff like that. But the thing that concerns me is the idea of reasonable, necessary and reasonable attorney fees. What are reasonable attorney fees? I've been online, I've watched people, and Mr. Salinas, actually one of your partners, Mr. Thompson. I have videos of him.
Excuse
Oh,
me.
I'm sorry, to talk to you, yes. Okay, sorry. Yeah, I shouldn't be doing that. But anyway, the thing is that when attorneys ask for fees, they put out cost surveys. And this is the very definition of price fixing. They have price surveys, and because we're supposed to have a competitive nature where you try to reduce fees. And when I look at the Office of the Attorney General for the state of Texas, he makes about $76 an hour. The governor makes the same. When I look at the business labor statistics data for Dallas-Fort Worth, the attorneys make about $77.72 on average. Median's a little bit less than that. But I've always wondered how reasonable could be $300, $400, $500, now up to $700 an hour. That's my concern with this.
Well, thank you, Mr. Morgan. Thank you for your testimony. Any questions of Mr. Morgan, members? Not hearing any. Thank you again.
Thank you.
Chair calls Cody Taylor.
My name is Cody Taylor. I represent myself, and I believe I put this as against.
You did?
I'd like to change that to neutral on the position of. So,
Neutral, you want us to show you as neutral?
Yes, sir.
Okay.
You can change it. I'll give you.
All right, thank you.
Yes, sir. Good? Thank you. Reason being, right, reasonable and necessary. So I think you've heard over the last 2 weeks my cause of concern with family courts. I've spent 6 years litigating. A costly one was divorce, and then second was child custody, 2 motions for modification. Inside of that, reasonable. We probably have a different opinion on what reasonable is. When I think of reasonable, it's things that you actually have to uphold or use resources to for your clients. How reasonable would it be if a judge absolutely violates the family code, his ethics, and allows professionals to do that, all while ruling that attorney's fees for the quote-unquote winner is now going to be my burden? How reasonable is that? It becomes a statutory ground, because then if attorney's fees are put into play, then it becomes a debtor's type prison, right? You're going to have that levied against you until potentially death or an agreement or payback when you pay back those fees. The language in there seems ambiguous to me. when it comes to reasonable. I think that there's no clear direction on what reasonable fees are. And in my case, because I can speak only to my case, is the fact that a judge who's being investigated by the SCJC, who's also being investigated by the DOJ on civil rights violations, and who also has violated multiple portions of the family code to put me where I'm at and in the position, has now levied a debt against me. So when we talk about reasonable, I don't think that there will be a clear understanding between the profession that uses those resources and the individuals such as myself who hire for you to use those resources. So that's why I remain neutral. I think that the other stuff at the headings is pretty clear, but when it talks about the actual debt that somebody will have to owe another person, potentially for the remaining of their life, that's huge. What resources would you use as the profession to go after somebody to pay those back if you know that an individual is completely on the wrong side of that decision? That would be just something of communication that maybe you and I could have at a later time, but I'll remain neutral. So.
All right, thank you for your testimony. Any questions of this witness, members? Not hearing any, thank you again. Thank you for being here. Chair calls Brandon Johnson.
Chairman Dutton, Brandon Johnson, neutral on the bill, testifying on behalf of myself.
We have you showing as against the bill.
I'd like to change that.
You want to change it to what?
Yes, neutral.
Okay, we have your permission. With your permission, we will change it to neutral.
And that's based on Cody Taylor's testimony. Neutral is or necessary is an ambiguous term. I don't really like it, but what I really want to address is the family courts make up 2/3 of the court dockets. The courts have become a place of plunder. And I appreciate you, Chairman Dutton, asking the question. If losers or the losing party receives attorney fees, which was confirmed that that's not the case in most instances, which means that 92%, 93% of men in Texas are going to pay attorney fees based on that. And so what I'm going to do is I just want to paraphrase or partially quote Frederick Bastiat in his treatise on the law. Life, liberty, and property do not exist because men have made laws. On the contrary, it was a fact that life, liberty, and property existed beforehand that caused men to make laws in the first place. The law has been perverted by the influence of two entirely different causes: stupid greed and false philanthropy. It's easy to understand why the law is used by the legislator to destroy in varying degrees among the rest of the people their personal independence by slavery, their liberty by oppression, and their property by plunder. This is done for the benefit of the person who makes the law and in proportion to the power that he holds. Men naturally rebel against the injustice of which they are victims. According to their degree of enlightenment, these plundered classes may propose one of two entirely different purposes when they attempt to attain political power. Either they wish to stop the plunder or they may wish to share in it. And these are the results of legal plunder. No society can exist unless the laws are respected to a certain degree. The safest way to make laws respected is to make them respectable. The nature of law is to maintain justice.
Okay.
This is so that much of the case in the mind of the people and the law and justice are one and the same.
All right, thank you.
Thank you, sir, but I did lose a couple minutes there in the beginning.
Well.
But that's okay. Since this, everyone else.
You're finished, I'm sorry.
Okay.
Any questions, members? Not hearing any, thank you for your testimony. Okay, the chair calls Taryn Champagne.
Good evening. My name is Terrence Champagne. I represent myself, and I am opposed to this bill. Strewn about this bill is the word necessary, as defined by Black's Law Dictionary 11th edition. It is that is needed for some reason, purpose or reason, essential, or that must happen and cannot be avoided. Based on my observation, the hiring of an attorney is not essential in the vast majority of cases I have observed. They do little to help with family law disputes and often make them worse. To believe that they must exist or happen and cannot be avoided is laughable. In the state of Texas, I'm an outlier. I share custody of my son equally with his mother and do not pay child support. How did I achieve this? It was without an attorney. I have many friends who are attorneys, and they are amazed that I was able to achieve this. My friends who have equal custody have generally achieved this by not being represented by anti-family law attorneys. Having an attorney working on your case is like having a devil whisper in your ear. I say this because in my last SAPSER, my son's mother's attorney encouraged her to keep coming after me despite my wife's diagnosis with leukemia and the loss of our child. Throughout this, her, in my opinion, corrupted attorney, Daryl Weinman, encouraged her to keep fighting. This is somebody who's obsessed with avarice and wrath. Once her attorney ran away scared after I got her investigated by the state bar, the devil was no longer whispering in my son's mother's ear. Rather than continue fighting, I laid down my sword and we worked out a peaceful agreement. This would not have happened should she have been represented by an attorney. Then there's the issue of reasonableness of fees. I have heard attorneys testify to that their hourly rate is $300, $400, $500. How is this reasonable when the Bureau of Labor Statistics states the median salary of attorneys in Texas is $72.28? I have a handout for you that has a link to a portion of a hearing of mine. You can hear a board-certified family law attorney not able to justify her outrageous fees. Others have used my line of questioning to great effect, exposing that these attorney fees are anything but reasonable. They are getting whipped in courts using the logic of the United States Army infantrymen, and we simply are not known for being the brightest. Daryl Weinman even admitted that her and other family law attorneys engage in price fixing. These attorneys, in her words, all submit what our current rates are, what we bill our associates at, what we bill our paralegals at, so that we can look and see that everybody is within the same market range based on experience and specialization. Sounds like an agreement to set at a certain rate to me. Attorneys often fail to challenge each other on their fees as a professional courtesy. The disciplinary rules of professional conduct state that lawyers, as guardians of law, play a vital role in the preservation of our society. I ask you to look at this bill and note, how will this law help preserve society? Can we really agree that it will accomplish this? And that is my testimony, and here's my handout for this.
Thank you, Mr. Champagne. Any questions of Mr. Champagne, members? Not hearing any, thank you.
Thank you, sir.
Is there anyone else here who would like to testify for, on, or against House Bill 1546? Chair hears none, recognizes the author, Representative Cook.
Thank you, Mr. Chairman. And what I would say, and again, I talked about earlier, been practicing family law for almost 30 years, licensed for about 27, and I guess next month will be 27 years, and board certified in family law. And I can tell you throughout my experience, and Chairman Dutton, I know you've practiced a lot of family law, and Representative Wu has, and maybe in a little bit different context within the family code, but I can tell you my vast experience for Representative Lujan and Representative Lopez for sure. My vast experience is that each pays their own is almost always the case. Not always, but almost always. My client pays his or her share, and the other party usually pays his or her share. And I think it depends on which seat you're sitting in. A lot of what you've heard tonight is complaints about, including one of the bills that I filed, are complaints about people not following orders. And so I just wanted to bring this provision to your attention and to the public's attention. It says in 157.167, respondent to pay attorney fees and cost. And so if you're the one that's happened to bear that, if you're the father, what we've heard a lot tonight, and the father's being denied visitation, he has to go hire a lawyer in order to file an enforcement action, in order to file a contempt of court action. I would want this. I would want the law to say this if I were in those shoes. It says, if the court finds that the respondent, which in that situation would be the father suing the mother for violating the court order for denying visitation. If the court finds that the respondent has failed to comply with the terms of an order providing for the possession of or access to a child, the court shall order the respondent to pay the movant's reasonable attorney's fees and all court costs in addition to any other remedy. And so I just offer that to show that, this bill is not adding anything new with regard to this particular statute that I'm quoting. It is an attempt to go through the family code and make it uniform with regard to reasonable and necessary attorney fees and expenses. And I would offer to you that reasonable and necessary is a customary phrase that we hear throughout the legal system on a regular basis. And I know one of the witnesses testified about just starting law school or about to start law school, and that is one of the first things that you learn in law school is what is a reasonable standard. And it's very easy. Just, if you were to guess what is reasonable mean, if you were to ask a judge, a judge would tell you what a reasonable and ordinary person would do. That's all it is. So a judge has discretion, and so he or she must decide what is reasonable and necessary. This bill, as far as adding the word reasonable, you can go throughout the family code or any other civil code, and you're going to find the phrase reasonable and necessary throughout it. So this is not a major change. I appreciate the opportunity to lay this bill out, and I appreciate your attention and be glad to answer any questions.
All right, any questions of Representative Cook, members? Not hearing any. It's the chair's intent to leave House Bill 1546 as a matter of pending business before the full committee without objection. Here's none, so ordered. Chair at this time lays out House Bill 2948 and recognize Representative Cook. There is a committee substitute.
Yes.
The chair at this time lays out the committee substitute for House Bill 2948 and ask Representative Cook to explain it.
Members, first of all, I'll tell you that the committee sub, so that you don't have to go through it extensively, is a non-substantive change. You'll note that on the original bill, there's not a ledge council number at the bottom. Now there is. And so this is their blessing of what we prepared initially in order to get the bill filed. As we all know, that we had delays from ledge council at the beginning based upon getting our bills done, and now it's based upon getting our bill analysis done. But anyway, what this bill addresses to do, last week we talked about, you heard me talk about that a parent has a constitutional fundamental right to parent his or her child. And this bill is along those same lines. And so I want to give you a fact scenario that this situation covers. And the purpose of this bill is to prevent a person in these shoes that I'm about to describe from having to go through a expensive legal battle where he or she's having to spend extensive legal fees. So imagine you have mom and dad, and they're both joint managed conservators, which I will tell you that in most cases, parents are joint managed conservators. They have almost all of the same rights. The court does have to differentiate who has the right to determine the child's residence, who's paying child support, and usually who makes the major invasive medical decisions. But for the vast majority, all the other rights and duties are the same. So what this bill does, it talks about a situation where you had two healthy parents. They're both actively involved in the parents, in the child's life, and tragedy hits the family. And so for whatever reason, the mother experiences a life-changing injury, but she's not deceased. And so what I mean by that is she's incapacitated. So that's what this bill talks about is what happens in that incapacity. Should a grandparent or should a third party be able to come in and at that moment and take over? And the answer is no. And the first question is the surviving parent a fit parent? And if the surviving parent is a fit parent, then we're done. So that, in this situation, if it is, and it doesn't matter which way it is, but if it was the father having the debilitating incapacity injury or the mother, the other parent, if they're both joint managed conservators, they have regular visitation schedules, then the other parent would automatically get it as long as they're a fit parent. And so I think in order for this bill to be interpreted, you have to look at what is incapacity. And so there at the bottom of page 1, we talk about if the conservator experiences a physical condition, a mental condition, or a period of incarceration. So any of those three that renders the conservator substantially unable to do one of the three things: provide food, clothing, and shelter for the child, to care for the child's physical health, or to care for the conservator's physical health, meaning that the parent is on life support or something like that. They're unavailable. Those are the situations that we're talking about here. And then, it can be a temporary order so that if there is a possibility, based on medical testimony, if there's a possibility that the incapacitated person will become regain capacity at some point, then the court can make further orders at that time. So the other provision I would draw your attention to is on page 2, line 12. A possessor conservator of a child is not entitled to temporary possession of as set forth in this bill if the existing order. So if when the debilitating injury occurs, if the order that's in place has a modified schedule or any type of reduction, any type of restrictions, if the non-custodial parent has supervised visitation or has a visitation schedule like we've heard where they're only getting phone access or anything like that, then this provision would not apply in that situation. It applies if both parents have a active ongoing relationship with the child, and there's no longer able to parent, then the other child would step in and take over all of those without having to go through a long, expensive legal battle. And that's the purpose of this bill, and I'd be glad to answer any further questions about it. Otherwise, I would like an opportunity to close when appropriate, Mr. Chairman.
Any questions of Representative Cook, members? Not hearing any, thank you. We will give you the right to close.
Thanks, sir.
We'll open the public testimony. We have first witness, Chair calls Cody Taylor.
I'm Cody Taylor. I represent myself, and I am absolutely for this bill. I'm going to give you a name, Chris Clay. You know him? Look him up. He spent almost $1 million fighting for his kid after his ex-wife and the mother of their child suddenly passed away, and a boyfriend that was with her at the time for 10 months around the kid, and the grandparents actually convinced the boyfriend to go file because the grandparents couldn't, and it actually went all the way to Supreme Court. Could you imagine that? Fit parent. He had expanded standard possession. He was able to do everything that he does in a normal life, and all of a sudden the mother going through that grieving process, and now all of a sudden you're served with papers that a man who spent 10 months of your whatever child's age life has now asked to be an equal part of a little girl's life. One girl. I have a little girl. I don't much less let a little boy or a male sniff the bathroom to try to go in while she's in there, and I'm going to let somebody become now a parent in her life? Absolutely not. I think this bill is kind of overdue for where it needs to be. That man's out $1.5, $2 million, whatever it was, to go to. Not only did he fight it at the lower court, he issued mandamuses. We all know how much that costs if you're in family law. And then you went through the appeals process. Lower courts continue to allow a man, 10 months into this little girl's life, have an opportunity to be a parent. That's unfathomable to me as a parent, but as just a man in general, I don't want to be another person, a parent, especially if I've only known them for 10 months. Now, I've got friends that I've known for 37 years. I just told my age, 37 years, and I'd be glad to be their parents. But I've known them since they were born. I've been in their lives every single day. They are just treated like my kids. This was not that case. It went all the way to the Supreme Court before it was finally shot down, and he was able to have his rights restored, basically. How does a fit parent in Texas lose that ability? I don't get it. And I'm going to be honest with you. We need to start looking at how judges are held accountable. You have to have one or two that you deal with.
Excuse me just a minute. Let me just say this. When the author filed the bill, it got referred to this committee.
Okay.
And this committee has this bill now. He doesn't have this bill.
I
He's just
understand.
the author. So talking to him doesn't do you a whole lot of good. Talking to us is what you should be focusing on.
I understand, Mr.
Because
Dutton.
we're the ones who have the bill now. It's ours. He can't do anything with it. We can do everything with it, or anything, or nothing with it. So he's out of it. So please, if you would, talk to us.
Yes, sir.
All
That's
right.
not a problem. Can I
All
at
right.
least have a minute,
Thanks.
30 seconds
Sure.
to get back on?
Sure.
It's just human nature. I'm sorry.
I know, but we got a process here, and I just want you to be
I'm
familiar
with you.
with it.
And here in a few, I'll
respect that.
probably be looking at him. But
All right.
where I'm getting at this is that a fit parent losing the ability to have their rights completely through this absolutely put a detriment on the 14th Amendment, which is due process. It also put a detriment on what he is as a fit parent. When you start looking at this and people start reviewing, if you don't know that parent or a parent has to go through this, you start thinking, well, is it even fit? and no parent should have to go through that. I think this bill is excellent in the way that it's worded. I think that it needs to be passed almost immediately. September 1 can't come fast enough for this type of bill, and I hope that this committee pushes this through.
All right, thank you. Any questions of this witness, members? Mr. Taylor, thank you.
My
Thank you
apologies.
for being here. Oh, no, you're all right. Chair calls Brandon Johnson.
Brandon Johnson, neutral on the bill, testifying for myself. Piggybacking off of Cody Taylor, yes, in light of the Chris Clay case, yeah, it makes sense. But it just, it brings up a very glaring question in my mind, how you can have a guy who was not the main parent in the kid's life to now, because the mom died, he all of a sudden is. Maybe in the next instance, she doesn't die. Maybe she's incapacitated to a lesser degree. But it's glaring that he's not a primary parent. There's so many different ways they put it in here. Conservator, he's not the primary conservator. But all of a sudden, because of the mom dies, now he is. Now, granted, this bill is good. At least he doesn't have to battle a live-in boyfriend or the grandparents over access to the child. And Chairman Dutton, I'm trying to respect the idea of staying on topic of this bill. But these bills do get amended, and I don't understand how the Texas Family Code cannot have a presumption of equal parenting when both parents are presumed fit. And this guy goes from, and I think he actually had equal custody, if I'm not mistaken. But if he did, he had to pay a lot of money to get it. But in the typical case, he would have had a standard possession order, or if the judges were following the law as it stands now, he'd have an expanded order, and then all of a sudden he has primary care. I'm not saying that the bill's wrong, but I'm just saying it doesn't fully address what is going on in Texas that needs some attention, which is equal parenting from the start, and it takes out all the animosity between the parents, and hopefully would prevent someone from becoming incapacitated due to dealing with conflict. Thank you.
All right, thank you, Mr. Johnson. The chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am testifying for myself. I'm testifying on the bill. As I understand the bill and the difference between what I read in the bill versus the CJC case at the Texas Supreme Court, Chris Clay, there was a death there. And my understanding is this is talking about an incapacitation, so the person is still living. And the only thing that I want to testify on is that even if a person is in that position where they're incapacitated, whether it be temporary or long-term, there still needs to be that relationship there between the child and the parent. It almost sounded to me like perhaps, and I don't quite understand this bill completely, it almost sounded to me like maybe things would be switched, that the incapacitated parent may not be able to see the child. And I would want to make sure that there were some guards in place, because the child needs both parents, and even an incapacitated parent needs to know that there is a child around that loves him or her. That's it.
All right, thank you, Mr. Morgan.
Thank you.
Is there anyone else here who would like to testify for, on, or against House Bill 2948? Chair hears none, recognizes Representative Cook.
Thank you, Chairman. I don't understand all of the response. I hear a lot of discussion about equal parenting and what this bill actually does. Equal means like 50-50. What this bill does is give you 100%. And so how you can be for that, I have no idea. But just so you guys understand, the purpose of this bill is, it doesn't give you half, it gives you 100%. And so what that means is, if you have two parents, one is incapacitated, then what do you want to do? You got to let the other parent. So if you're a fit parent, then you get to control that. Okay, so and if you want to go take your child to see the mother that's on a respirator and fighting for her life, then that's what you should do. But you as a parent should make that decision, no one else. So if you're a fit parent, you're the person that makes that decision, not anyone else. That's your guardrail. And that's what we've been talking about is, fit parents. So if you're a fit parent, you don't need anybody else. That parent makes a decision. It's simple. This is a great bill to address a very limited situation. It's a very unfortunate situation because it's a situation that involves an incapacitated parent, a parent that's physically, mentally unable to care for their child, and the other parent needs to step up and be the parent. This is a bill that I would ask for your favorable consideration. I appreciate all the time y'all have given me tonight. I apologize that I've taken so much, Mr. Chairman. I do appreciate you setting all the bills.
Thank you. It's the chair's intent to leave the committee substitute, or to withdraw the committee substitute, House Bill 2948, and leave House Bill 2948 as a matter of pending business before the committee without objection. Chair hears none, so ordered. What? This? All right.
Chair now.
It's gonna happen fast.
Yeah. All right. At this time, I'll be the chair. And the chair lays out HB 2581. Chair offers up a committee substitute to HB 2581, and the chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman. Members, this bill is a bill that came to me by way of an interested party about child care expenses for a mother, particularly, who is getting child support but needs to go to work or go to school and incurs child care expenses. Child care expenses in the original version were treated almost exactly the same as medical care or dental care was, but in the committee substitute, we've taken that out. We've taken it out and made it a separate claim by itself so that it's not treated the same way, because child care at some point is going to end because the children may go on to school somewhere, and so you wouldn't need to do it. But that's essentially what this does. It just directs that the court could order expenses for child care expenses. It doesn't require that the payment be made to a Title 40 agency, a local registry, or a state disbursement unit. It can be made directly to the child care facility.
All right. Members, are there any questions? All right. At this time, the chair calls Steve Bresnan.
Thank you, Mr. Chairman. My name is Steve Bresnan. I'm here on behalf of the Texas Family Law Foundation in favor of the bill. Appreciate you bringing it under current law in the child support statute, section 154.123B6. The court is allowed to deviate from the standard guidelines and take into account expenses incurred by either party to maintain gainful employment. In this bill, it requires the court to allocate child care expenses between the parties if one of the parties is, if it's necessary to maintain gainful employment or to get some kind of education or vocational training leading to vocational. It doesn't just shift all of the costs to one party, but it allocates them based on the party's individual circumstances. In your packet or your handouts, I've given you two very useful things that were educational to me. One of them is Texas has the seventh highest child care expenses on average. It takes people 20.4% of their income to cover child care. And right now, the child support statute is virtually silent on that. And there's a second page that'll give you a lot of interesting data about how many families there are with kids in the preschool ages where child care would be most needed, and then older ages where maybe after-school care would be needed. And, Mr. Chairman, I'm happy to answer any questions, and thanks for bringing the bill.
All right, thank you, Mr. President. Members, any questions? No? Thank you very much. At this time, the chair calls Charles Cease.
Thank you all for your service.
I know I got that one right. I remember that.
Thank you, Representative Lujan. Lujan?
Yes, sir.
Chair, my name is Charles Stephen Cease. I'm testifying against 2581, and I represent myself and my family. This adds another slot of expense to whoever ends up being the non-custodial parent, and that really needs to not happen until it has to be conditional upon exhausting the possibility for shared parenting. Why should I pay for my children to go to childcare when I work from home and I'm available to be there for my children? Thank you very much. I can take questions.
All right, members, any questions? If not, thank you very much. Mr. Cease? At this time, the chair calls David Green. Mr. Green, your full name, who you represent on for against the bill.
My name is David Green. I represent myself, and I am against the bill.
Okay.
I agree child care expenses during school hours should be split between parents, separated. However, it should not be done as an addition to the current guidelines without modifying the current guidelines. The current guidelines already had the cost of child care in mind when they were developed, so this bill uses the phrase according to the party circumstances. And excuse me, I have not read the committee substitute, which I believe is ambiguous, and I don't believe it considers how much current child support is already paid. I think Mr. President had mentioned child care takes up about 24% of a household's income. Well, the starting guideline support is 20%, so from the non-custodial to the custodial, so take half of that. That covers the non-custodial parent's portion of child care. This bill is also unclear as to how the child's evolving child care needs are to be allocated. Do parents have to go back to court once a child moves from daycare to elementary school to then argue over after-school child care? Then go back again to argue when that child care should end? I don't see how a judge makes an order based on this language that will last and not require multiple modifications later. Let's take the example of one parent who is a teacher, so they have the summers off, and the other parent does not. Does the parent who is the teacher need to pay for the other parents, half of the other parents' summertime childcare needs? HB 2581, while good intentioned, is going to make a bad system worse. The way to solve the burden of childcare expenses is simple. Give fit, willing, and able non-custodial parents the presumption of equal parenting time. That way, each parent can be responsible for their own child care expenses during their days. For over a decade, we have not been able to get a timely hearing for floor vote, and if equal time is not appropriate, the bill will still have language added to consider the child support that's already paid. Thank you for your time and allowing me to speak.
All right. Thank you, Mr. Green. Members, any questions? If not, thank you for your testimony, Mr. Green. This time the chair calls Delilah Crosby.
My name is Delilah Crosby. I'm testifying on my own behalf as an advocate for fathers, and I am against this bill. Once again, this bill is going to affect fathers. They are the majority of non-custodial parents in Texas. There's multiple issues with this. If the language could be changed, or there could be set guidelines as to determine the need for childcare, then I may be in favor of it. But at this time, it does not provide guidelines to prove that a mother may need childcare. For example, Flamingo Island Daycare in North Texas is not willing to accept payments from two different parents, and father is not willing to pay mother for in cash as she prefers so that she can pay this daycare. And then they would not provide a receipt to prove that, which would be giving her the opportunity to take him back to court so that he has to now argue that he did pay it, and he could face a penalty in court. Not only that, he is a Native American, and his family believes in tribal community. So he has grandmothers, aunts, sisters, and everybody willing to watch this child, and mother will not agree to that. So if there's an option for that that takes out the cost for both parents, that should be the primary guidelines, as we do encourage family engagement, not just fathers. So with that, I'm going to be against this bill in hopes that language will change to create more clear guidelines on how we even determine that mother truly needs the daycare cost paid for.
Thank you, Ms. Crosby. Members, any questions? If not, thank you for your testimony. Appreciate it. This time, Chair calls Jeffrey Morgan. Full name, who you represent, on for or against.
Thank you, Chair Lujan. I appreciate being called up again. Jeffrey Morgan. I am on this bill. I have some concerns about it. I'm testifying only on my own behalf. The first thing, I think it's kind of been alluded to. I think that if there is a situation where there are two parents, that this bill here should say something about the right of first refusal. And I know because, as Charles mentioned and others may also mention, if they're available to provide childcare, why should they have to pay for something that they are willing to provide? And we've talked about extended family and stuff like that too. There's oftentimes family that will be involved with that as well. When it comes down to the courts actually making the determination, I've seen personally, like I said, I've been in probably 200 different cases over the last couple of years, either virtually, in person, Zoom. And I've seen types of judges. I've seen a few that I think are really good, but I've also seen the white knight judges, and I've seen the feminist judges. And then I've seen some that maybe have been the other way too. So I don't really trust the judge's judgment on this. The court all of a sudden gets to act as if the court is the super parent or something like that. I think that can be a disaster at times. But the big thing is for me, and the other thing is that we'll say a mother for this instance, she gets her new job. Does that readjust the child support then? Because if she's making more money, from my perspective, it only makes real sense if you have an income shared model versus what we have right now, the single payer model. And I know that Chairman Dutton has had a bill regarding that. So some of these things with the Texas Workforce Commission, do they offer any type of child care? If you're going back for training, some of the schools actually provide child care for the people that are going back for a degree. And then is there a limitation on this? Is it going to be a 6-month thing that the person gets a certificate and then maybe wants to go back for another year or 2 years? This could be a long-term thing. So I think that there are situations that would make this not fair, not equitable. I am testifying on it. I'm not going to be with my friends who testify against it, though I lean that direction. There are some issues that I think need to be addressed and clarified. Thank you. Any questions?
Mr. Morgan, thank you so much. Members, any questions? If not, thank you for your testimony. Appreciate it. Chair calls up Cody Taylor. Cody Taylor once, Cody Taylor twice. I don't see him. All right. He's testified. Where is he at? Against. Okay, we have against and not testifying. Chair calls up Brandon Johnson. Mr. Johnson, you know it, right?
Yes, sir.
Full name, who you represent, on for or against the bill.
Absolutely. Thank you. Brandon Johnson, against the bill, testifying on behalf of myself. And I also want to thank you, Representative Lujan, for your undivided attention today. Not that we haven't gotten it from everybody, and Mr. Cook, you as well, and Ms. Lopez. and everybody else when they don't drift off. It's been a long day, so I understand. This bill needs to be amended so that only if equal custody was waived by the father, then it would be, I think it would be justified. If the father said, hey, I don't want to have equal custody, I can't, say he's unfit, he's unwilling, or he's unable, then I think it's justified. If the father has, and then also on this bill, if the father had a first right of refusal to keep the child instead of putting the child in the daycare, even if it's not on his designated time within a standard, expanded, or equal custody order, if he had that first right of refusal and he said, I don't want to take care of the kid, then fine, make him pay for the child care. That would be fair. But if equal parenting for fit, willing, and able parents was passed or amended into this bill somehow, it will promote parents working the issues of child care among most every other issue out amongst themselves without state interference. Thank you.
Thank you, Mr. Johnson. Any questions, members? If not, the chair calls Taryn Champagne. Full name, who you represent on for against the bill.
My name is Taryn Champagne. I represent myself, and I am opposed to this bill. Kind of looking at this bill, we're trying to add additional costs for childcare expenses. It's my understanding that that's kind of what child support already is there for. If we kind of look at what the state of Texas does for foster families who are raising children 24, well, not exactly 24 hours a day, but the idea is they're the responsibility of the parents 24 hours a day. The state of Texas reimburses them at $27.07 per day. If child support is being ordered for this child, should this not be considered what is needed, the basic needs for the child being met? While I understand we want the best for our children, we should all be kind of held to the same standard. Just because somebody makes more doesn't mean the child needs more. That's a discretionary decision by the parents. If that $27.07 is not enough, then our foster care system is failing children. I think we've had plenty of testimony on that. I would say if a parent needs time to get that education or find stable employment, perhaps the child should be in the care of the other parent who already has that stable employment. Honestly, if parents had that equal custody, there would be more time for one parent to pursue gainful employment or additional education. Texas's child support system is already heavily broken as it is. It's one of 3 states, the other 2 being Mississippi and New York, that does not look at either both parents' income or the time the children spend with the parent. This leaves one parent at kind of a severe disadvantage. Once again, in many cases, this is through no fault of their own. That's just kind of how the system shakes out. Before we kind of continue looking at this bill as it is, I think we should really consider overhauling the child support system rather than trying to put Band-Aids. As my Representative Talrico said, we don't want to put Band-Aids on things. We want a real fix for our children of Texas. And that's my testimony.
Thank you, Mr. Champagne. Anybody have any questions, members? If not, thank you for your testimony.
Thank you very much.
All right, that's all of the folks that's registered. Is there anyone else who would like to testify on for or against the bill? If not, if there's not anybody else, I'm going to recognize Chairman Dutton to close on HB 2581.
Thank you, Mr. Chairman and members. It's somewhat predictable who was going to be for and against this bill, so I close.
All right.
I got a question.
Yeah, I'm sorry. Yes, sir. Go ahead.
Thank you, Chairman. Chairman Dutton, the question I had in reading the bill, I don't think that this bill would preclude. We keep talking about fathers being the non-custodial parent. The way I read this bill, it looks like a father could ask the mother to pay his child care expenses on his time as well, correct?
Absolutely. I was going to suggest that my reading of the bill was that way too, but apparently I don't think some people read the bill I certainly didn't see the committee substitute.
Great, thank you.
Thank you, Rep. Cook. Anybody else have questions?
I close, Mr. Chairman.
All right. The committee substitute is withdrawn, and if there is no objection, HB 2581 will be left pending. All right. At this time, the chair will lay out HB 2583. The chair offers up a committee substitute to HB 2583, and the chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman. Remember that they didn't like the last bill, they'll hate this one.
We'll be great.
Currently, if the parent who pays child support is a successful business person, grossing more than $12,322.99 per month, or as a self-employed person, $13,257.36 a month, then the person's child support obligation calculations are capped at $9,200 in net income. The original bill, as introduced, raised the cap to $30,000, but the committee substitute differs from the introduced version by raising the cap only to $15,000. And that's essentially all it does.
All right, members, any questions? No? All right, at this time, we'll go to public testimony. This time, the chair calls up David Green.
Excuse me.
Mr. Green, of course, your full name, who you represent on for against the bill.
My name is David Green. I'm testifying on behalf of myself, and I am opposed to the bill. So this bill would increase the child support burden on many parents throughout Texas without having to show a proven need and without considering the income of the receiving parent. If the child does have more expenses than what is covered by the maximum current guideline child support, there's already a remedy for that. They can show the court under Section 154.126, application of guidelines to additional net resources, and ask the court for more. But they must have evidence of that need. Therefore, this bill is not needed and only makes the current system worse. If the purpose of this bill is to prevent a very high-income parent from not paying their fair share of child support, there is a solution to that. It's called an income sharing model, and Chairman Dunn, you have actually written that one. It's HB 2582. That one is just requesting a report on the income shares model for the state, but I would suggest passing that first and then considering changing the maximum net resources. Because currently there's just really, you shouldn't have cases where one high net earner is transferring significant amounts of child support to another high net earner. More and more these days, people with high net incomes marry people with high net incomes. And so they end up getting divorced, and there's just no sense in making those transfers without considering the income of both parents. Thank you for your time.
Thank you, Mr. Green. Any question, members? Now, thank you for your testimony. At this time, Chair calls up Charles Cease. Mr. Cease, also your full name, who you represent on for against the bill.
Thank you for the reminder, Representative Lujan. My name is Charles Stephen Cease. I'm here to represent myself and my family, and I am against this bill. This bill simply isn't reasonable on its face. $30,000 a month is not child support. That's we're using the child support word, but it's disguising something else. I'll take questions.
Members, any questions? Thank you, Mr. Cease. Appreciate it. Oh, I'm sorry. Go ahead,
I
Representative.
was just going to ask you, did you understand that the original bill was to set child support at $30,000 or to use that as the number that you would multiply?
That was the cap, is my understanding. Was it $30,000 a month was the new cap?
So the way I read it, it says the guidelines in which the obligor's monthly net resources are not greater than the maximum amount of net resources to which the statutory guidelines are applicable, as most recently published.
That was the guidelines most recently published, I thought was the part that was stricken out, and we were replacing that with a $30,000 monthly cap.
I guess I'll defer to the chairman, but that's not the way I.
No, that's not what the bill does at all. That's, it's as he was suggesting, that was a cap on which we multiplied to determine child support, the maximum amount, but.
Yeah,
but that was
$30,000 a month.
But that was
monthly.
even lower.
So that's not the cap. That's what we take the multiplier factor, and we with the salary part, the income that right, and so 360,000. So you're basing it on a $360,000 income. That still seems unreasonable.
Well,
How much? 6,000. Is that what you said?
You said
The committee substitute half of that to $15,000.
was
per
the
month
committee
in net
substitution the bill that was linked by 9:30 a.m. this morning?
I'm sorry.
Was you're talking about a committee substitution of the bill? It's been adjusted and then it's been reposted.
Here's a copy.
I'm not sure what you mean by reposting.
Sorry.
So I looked at the bill at 9:30 this morning because I thought the hearing was going to start at 9:30 this morning.
Yeah, but you didn't see the committee substitute. You didn't see the substitute.
Resources. So we're essentially raising the multiplier again? I still oppose the bill.
Okay. I didn't think you'd like it, but I thought you'd like it. Hate it half as less.
I just wanted you to know that it's $27,000 less than what you thought.
Thank you. It is important, but I still oppose the bill.
Still oppose it, okay.
Yeah, okay, thank you.
Any other question, members?
Thank you for your patience.
All right, this time the chair calls Jeffrey Morgan. I'll remind you again, Mr. Morgan, full name, who you represent on for or against.
Thank you very much. My name is Jeffrey Morgan. I am representing myself. I am going to be against this bill. And I'll say at the very beginning, I've never paid child support, so I don't know how the system works. So you can say, well, he's just an angry, bitter dad or something. No, that's not what I'm saying. I'm just trying to say something should be working right. So I think that child support is not supposed to be a lifestyle support. I think sometimes when we have a person who makes more money, they say, oh, we have to get more child support, and really becomes a lifestyle support. As Taryn mentioned earlier, the Texas foster care system pays about $27 a day for a foster care child, and that is what they consider to be the basics for a child. And if you look at right now, what it's saying, a person who makes $180,000 would be paying $36,000 for an individual versus what? I think it was $10,800 for a foster care, so over 3 times the amount. If that's the case, maybe the state of Texas should be paying more in child care and foster care expenses. And I can say this as well because my daughter is a foster parent and has been for many times. Again, the child's needs do not change. I've also watched cases where it seemed like the judges and the attorneys really didn't understand finances nor accounting. They would look at the total revenue and not consider the cost of goods sold, not consider capital expenses. They say, well, you made so much money this month, $20,000. I say, yeah, but I have to pay loans off. I've got to do this, I've got to do that. And really, when it comes down to net income, the net income may be $4,000, but they see the $20,000 and they're like, eyes light up like that. So I don't trust the courts and the attorneys to be actually very good at financial analysis and accounting from everything that I've seen. With regard to well, maybe the child needs to have more and stuff like that. I'm sorry, this is, that was going to refer back to the other bill, so I'll drop that section. But the other thing is that, when you're adjusting payments based only on income and not on time shared, I think that there's something wrong with that model as well. Again, people have talked about the 50-50 and stuff like that because the way that our model is supposedly justifies itself is that there's a custodial and a non-custodial. The non-custodial pays the custodial. That's only the right thing to do. And yet I know people that have had 45 to 50, like as far as 55 for timeshare, and yet the guy or the woman who has the 45% pays the entire fee. I think there's something innately wrong about that. In fact, I have a friend who is 50-50, and he's paying not just guideline, but above guideline because he makes good money. So they're going to punish him. I think it's a punitive system, and it gives in his case, it gives the mother the ability to stay at home and just collect money. And that's all it is, because it becomes lifestyle support. Anyway, I think that maybe you should look at a study for this before you just raise this amount indiscriminately. But that's really all I have to say. Nobody wants to not support their children, but they don't want to pay the other parent a nickel more than what they deserve. Isn't that right?
Well, Mr. Morgan, appreciate your testimony. Members, any questions? If not, thank you, Mr. Morgan. This time the chair calls Steve Bresnan. Full name, who you represent, on for or against.
Thank you, Mr. Chairman. I'm going to reveal to you in the course of telling you who I am and who I'm representing and who I'm for, a little known fact. My actual name is Stephen Green Bresnan, so I may have a relative on the other side of this issue testifying here tonight. It might be good if we straightened out a little bit of the confusion. The number right now, the monthly net resources.
Excuse me, real quick.
I'm sorry, I represent the Texas Family Law Foundation. I'm for the bill.
Perfect. Now we can go.
Right now, the monthly net resources against which the guideline percentages are applied is $9,200 a month. That's where it's capped. I've passed out a comparison to you that'll show you what this bill is about in easy numbers. Before I go on, let me say that Mr. Green was almost right, that 154.123 B, 2, and 3 allow everybody's income and finances to be considered in the equation. So if you had two high wealth earners, that court could take that into account when it arrived at the final number. What this shows is that when you take the gross income and you take the deductions out that are in the statute under current law, at $9,200 net resources, that generates $1,840 for one kid at 20%, or $2,300 at two kids at 25%. But the person that makes $6,000 a month more pays the same as the person who makes the $9,200 a month. Under this bill, these payments are not for any lifestyle expenses of the ex. These are payments for the support of a child. Under this bill, one child substitute at $15,000. The benefit to the child is another $1,160. That keeps that child able to enjoy more of the kind of life that they had before the parents split, assuming the parents were ever together. And it also makes it more fair because the person with the $15,000 in net resources today pays 12% of their net resources in effect. And because that's above $9,200 cap, under the $15,000, that $3,000 comes in at 20% of net resources. And you can see from the bottom, you can see the numbers on the bottom. So under the current law, every 6 years, the cap gets changed according to the CPI automatically by Mr. Chairman, you may have carried this bill to achieve that result. In a time of high inflation, that's not keeping up.
Mr. President,
yes, sir. And it's inherently unfair because people who make a lot of money get capped out and they get off and don't have to support their children in the lifestyle to which they should be supported.
Thank you, Mr. President. Members, any questions? Representative Cook?
Yeah, Mr. President, in this bill, does it matter and I'm going to talk the way it, I guess, most traditionally, with the mother being the custodial parent and
Yes, sir.
the father being the non-custodial parent. Does it matter if the mother makes more than the father under this bill?
Well, it could, because the court has the option under 154, 123, but the mother could pay child support to the father. The family code is gender neutral. And so it could, I mean, is your scenario that she makes more money than him and she's the custodial parent? Is that your?
Correct. The answer is no. I mean, there's no, and that's, I mean, very rarely.
Not just under the guidelines,
Correct.
except that's where 154, 123 comes in, and the court has the discretion to adjust that.
At the risk of admitting that I rarely agree with Mr. Morgan's testimony, he suggested that a study needs to take place with regard to this issue. And I know there's been some discussions, and I think someone maybe mentioned it earlier about, shared parenting and, looking at, the actual expenses and actual incomes of both parents. And so I would support that type of concept, looking at it from a holistic standpoint, looking at both parents' incomes at the expenses. I mean, I think we all know that the most expensive expense of a young child is daycare.
Yes, sir.
I've talked about that before. But I do think it's noteworthy to look at the last part of section 154.126. And I think it's very telling from a legislative standpoint. And this is 154.126 is the application of guidelines to additional net resources. So what we're talking about here is if this person was making $30,000 that y'all were trying to get child support all the way up based upon $30,000 of net resources, but now you brought the bill back down to $15,000. But so if someone was making $20,000 and you wanted to go after more child support above and beyond the calculation for the $15,000, 154.126 would actually control, and it's the application of guidelines to additional net resources. And it says, however, in no event may the obligor be required to pay more child support than the greater of the presumptive amount or the amount equal to 100% of the proven needs of the child. And that's what we need to be talking about here. We need to be talking about what are the needs of the child, not just a number based upon what the non-custodial parent makes. And so I would encourage the chair to request that this matter be formally studied. I think it's something we should take up over the interim, and I can't support this bill, just so you know, but sure. I would support an opportunity to study it further and look at both parents' incomes, parenting time, and the actual expenses of the child, which you talked about in your testimony.
Yes, sir.
All right, thank you.
Well, I would venture to guess we would stay actively engaged in that process, and we'd look forward to working with you on it. Yes, sir.
Thank you, Mr. President. Any other questions, members?
Thank you all for your service.
Thank you, sir. This time, Chair calls Cody Taylor. I think Cody Taylor's gone once, twice. All right.
He'll be shown registered.
He'll be shown registered against the bill and not testifying. This time, Chair calls up Brandon Johnson. Mr. Johnson, full name, on, for, against, and who you represent.
Thank you, Mr. Lujan. Brandon Johnson, against the bill, and for myself. But I would like to mention only half as much against the bill as previous to knowing about the substitute. Thank you, Mr. Dutton. Look, it's been a long day, so I think a little bit of humor can't hurt any of us. So I've got to tell y'all, look, I didn't know about Title 4D. I didn't care about paying child support until I was limited to the very bare minimum of time with my kids. And then I had to go through the whole process. You don't know what to do, so you listen to the attorneys, you file a modification, you go to trial. I actually ended up going through the Court of Appeals to learn that process. I came down here to the Capitol. I've been invited to, there was about 25 of us to talk with the Attorney General Ken Paxton at one time, several years ago after becoming involved. And I realized that the reason I couldn't get any more access to my kids was child support, was the Title 4D. And I've come to actually appreciate the Bresnans because they do bring up good points on a lot of things. Even though they do represent zealously, they're lobbyists, as lobbyists, they represent family law attorneys and apparently the Attorney General's office, where they want to maximize the profits to that industry and those clients themselves. But the reality is, child support is for the benefit of the state. It is a reimbursement to the state, and it's a profit center. The benefit to the mother and the child is merely incidental to the contract. I appreciate you, Mr. Cook, for bringing up the fact, even though that I'm saying that is the case. I appreciate the fact that you did mention that the child's needs are at least in the code. And all we're really asking for is saying we want to be involved in our kids' lives. That's really it. Throw these other guys under the bus. Raise it back up to $30,000 as a max. If they're not willing, if they're not fit, they're not willing, and they're not able to be fathers to their children, raise it to $45,000. I'm not worried about that. Unlimited, but leave us out of it. And I promise you, we can solve a lot of problems if we can incentivize fathers back in the home. Thank you, gentlemen and gentle ladies.
All right, Mr. Johnson, thank you so much. Any question, members? All right, I think that's all we have registered. Is there anyone else who wishes to testify on, for, or against HB 2583? I see none. If not, Chair recognizes Chairman Dutton to close on HB 2583.
Thank you, Mr. Chairman. I close.
All right, committee substitute is withdrawn, and if there's no objection, HB 2583 will be left pending.
And I thank all the people who have opposed. They were half right.
All right, at this time, the chair lays out HB 5103. The chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman. Members, currently the court grants one parent exclusive rights to determine where the child lives, where the child attends school, as well as decisions that impact the child's physical care and support. What this bill does is simply clarifies that courts will appoint one parent to make the decisions for the child's educational needs when parents are divorced. There's been some argument about whether or not who makes the decision about certain educational decisions. And what this bill does is simply says that the court is going to make that determination, and that's what this bill does.
All right. Thank you, Chairman Dutton. Members, are there any questions? If not, we'll go into our public testimony. Chair calls Harold Oliver. Mr. Oliver, full name, who you represent, if you're on, for, or against the bill.
Yes, sir. My name's Harold Oliver. I'm the other half of the Herald Caucus. So we're happy to have a quorum here. I'm representing the law firm of Schulman, Lopez, Hoffer, and Nadelstein, and we are grateful for Chairman Dutton for filing this bill. The issue that we're trying to resolve
Are you on, for, or against?
We're for this bill.
For this
Yes,
bill,
sir.
okay.
Yes, sir. The issue that we're trying to resolve is, as you know, when the courts grant a joint managing conservatorship or an appointed managing conservatorship, each parent gets 50-50 rights. And in those rights, they're spelled out in the code, and it says they have the right to determine where the child lives, where the child goes to school, where the child goes to church, and his basic support. A specific issue that is presented itself is that a school will call and say, Junior needs to be tested for special education needs because he's falling behind One parent says yes, the other parent says no. The only person that's hurt in this situation is the child because nothing can be done. Courts, even though the word education is in the code, some courts and some schools are interpreting that to mean where the child goes to school and not for his general education needs. So I know this seems a little redundant, but we're adding the educational needs into the bill to let that parent, whoever that parent is, make those decisions. I'm happy to take any questions.
Thank you, Mr. Oliver. Members, any questions?
And the Herald Quorum has
It's broken up. Mr. Oliver, thank you for your testimony.
Yes, sir, thank you.
All right, at this time, the chair calls Jeffrey Morgan. Full name, who you represent, on, for, or against.
Thank you. Oh boy, what just happened here? Okay, my name is Jeffrey Morgan. I am representing myself. Am I on? Did I register for this?
We have you registered for the bill.
I'd like to change that to on the bill.
All right, with your permission, we will change from for to on.
Right.
That's good.
And first off, I just want to say thank you to everybody who has taken the time out here. I know that some people don't like me, and I know that, I've ruffled people at various times. But I appreciate it because we're fighting for our grandchildren, we're fighting for our children, we're fighting for our families. We have seen the devastation that divorce has caused upon our society, and we've seen the devastation that the courts have wreaked upon many people. Other than that, we wouldn't be here. And Representative Talarico, you've seen it in the classroom. I've seen it in the classroom as well. Seen it all over the place. There's no place that is untouched by this as far as the devastation of divorce and never formed families. So I just want to say thank you to everybody. When I come down here, I do want to represent myself. I know I ruffle feathers, but I appreciate the fact that we can have a dialogue. With regard to the courts making some of these decisions, I always question that. I mean, right now we have judges that have said they have 3,600 case backlog. 3,600, how do you deal with anything efficiently when you're behind in 3,600 cases? With regard to this bill that that Chair Dutton proposed, I know one family that they had an agreement where the mother chose what the educational decisions would be from grades 1 to 8, and then the father from grades 9 to 12. And I think that's important because you do need to have two people. If you just have one person making some of these decisions, you may lose the value of the input from a father or a mother. And a mother might say, yeah, I'm homeschooling. Trust me, we've homeschooled, and we're for homeschooling. But there are times that I've also felt, too, like you needed to transition from that to a public school system or a Christian school system or something along those lines. So that might be another option to be considered. Again, my own bias is that I've watched the courts too much. I don't trust them. And that's a real big problem. The lack of trust in the judiciary is a huge issue. And I've talked with judges and said, if you can bring my trust level up to 0, you'll be doing a great thing. And I was a person that wanted to trust this stuff. I'm a person that believes in society, law and order, everything else. But anyway, like I said, primarily just what I wanted to say is that I appreciate you letting me be here, hearing me, arguing with you. And I was surprised, too, that we actually were on the same side of things. Thank you very much.
Thank you, Mr. Morgan. Any question, members? If not, the chair calls Cody Taylor. In case he came back, I can see that he's not back. Chair is going to call Brandon Johnson once, twice. Oh, there he is. Full name, will you represent, on, for, against the bill?
Brandon Johnson. I'm going to remain neutral, and I am representing myself. It's a minor change, but it strengthens parental rights nonetheless. So I'll agree in part. But as Mr. Harold Oliver had stated, he was an attorney that testified a few minutes ago, he's right. We have equal rights and duties. But again, I'm going to hammer on it. We don't have equal possession. And even though it says in the code currently that we have equal rights and duties, and I wouldn't, we're being plundered across the board. on not just our rights, our property, all of it. And yeah, we want to have the educational decisions. Right now, the schools are wanting to mandate that they don't even have to tell us what's going on. So I agree with that. But when a father goes to a school and wants to be involved, he's treated like a second-class citizen. He really is. And so we'll just keep beating the drum. I mean, if you do not have, I just do not understand, out of all these, and there's so many conservative representatives who do not understand that they're incentivizing pushing the father out of the home, which, once again, all day long we hear, and all session long, we've heard about how the courts, every institution in the state is overburdened by the results, by the consequences of fatherless children. And it disgusts me, really, because I don't want to fight with my ex-wife to the point where I don't want to put my children through having to go to supervised visits and all this bull crap, okay, or nonsense. Let me back up. Nonsense, Mr. Dutton. But it's like, honestly, I'm just like, I'd rather come down in here and talk to you folks. I'm not fighting for anything, because who am I going to fight? Y'all got the warehouses, you got the law stacked against us, everything to punish us with. So I'm not going to fight about anything. I'm just laying it out the way I see it. Thank you for your time.
Thank you, Mr. Johnson. Members, any questions? We got a question for you. Representative Cook?
What warehouses do we have?
Those warehouses are jails. They're jails and what do you call them? I haven't visited one yet.
Thanks for clarifying that. Appreciate that. All right, at this time, the chair calls up, it's getting late, right? Taryn Champagne. Full name, who you represent on for against the bill.
Good evening. My name is Taryn Champagne. I represent myself, and I'd like to change my position to on the bill, and you have my permission to change it.
All right, we have your permission to change it. We are changing it. Is it changed? It's changed. Thank you. Go ahead.
All right. Thank you, everybody. I'm based on the testimony of the other half of the Herald Caucus. I am changing my position on this bill to on. The reason is this public policy is outlined in Chapter 153.001, encourages parents to share in the rights and duties of their child. And my concern is if you are giving one parent that kind of sole decision-making on the educational decisions, it violates the public policy of the state. And we really, ideally, right, once again, ideally, we want parents to kind of both be involved and come to agreements with their kids. Because ultimately, right, when y'all are agreeing, that's what's going to be best for the child, and you'll get that warm and fuzzy feeling with it, right? Now, I get it. Not everybody is going to come to an agreement, but there's got to be kind of a better solution here where maybe there's some sort of tiebreaker where, you know, if they can't come to agreement, maybe it defaults to the school district where the custodial parent lives. That's what my son's mother and I have. We have equal, but if we can't come to an agreement on that, that's kind of our tiebreaker there. And just a thought, I just don't want it to be so one parent kind of has tyrannical control over maybe those educational decisions. And are there any questions?
Thank you, Mr. Champagne. Any question, members? Not, thank you for your testimony. Appreciate it.
Thank you very much, y'all.
Time, the chair calls Delilah Crosby. Ms. Crosby, your full name, who you represent on for against the bill.
My name is Delilah Crosby. I represent myself, and I am for the bill. I believe this is a great bill. As I've stated, I am a PTA, not just a member, I am a president. I've been a president for 4 different schools. I've even been on council of PTAs in Arlington. So you guys have seen my peers back in February. I just want to tell you 2 quick stories. One is my bonus daughter. She actually had an issue where she was bullying children at school. That child that she was bullying was the one that ended up removed from that classroom. My bonus daughter then escalated and brought a knife to school and bullied that girl at recess. This information was withheld from our family. This child was ordered to be in counseling, and her mother had removed her because the things that she was saying in counseling were reflecting poorly on her mother. The school would not provide us information. When my husband reached out through email, they told him email is no longer a good form of communication. When he contacted the police department because he was able to get a hold of the child that had been bullied, the police department wouldn't give him any information. It took us going through discovery and family court to find out that she got a 30-minute detention because mom ran up there and said, don't do anything to my kid. The school was aware that she needed to be in counseling, and the school was aware of multiple CPS cases and the 5 years long of family court battles that had ensued and were all over the school campus as well. Had my husband been given the right to have a decision in that, she may have been held to a higher standard, been put back in the counseling sooner to prevent these issues from happening, as that was a danger to not just herself, but numerous other students. Another situation is going on in Royce City right now. A father has finally been able to find his child, went to the campus last week, and they were very relieved to find him. They have expressed concern that mother does not want her son doing the STAR and will not put him in any tutoring. He is a 5th grade child with a 1st grade level in all subjects. The school has stepped forward and asked the father how they can help him help his son. And they have agreed to send notices to the court, to testify in court, and do all that thing. But it shouldn't have to be that way. It should just be written like you have right now into the law so that he can go over there and advocate for his child. And if mother doesn't agree, then the school has an outlet to show the court that, hey, this is the parent that's not in agreement of the child's best interest. And therefore, I am in favor of this just for multiple reasons. I mean, it's the safety of the child. As you said, it's in the child's best interest.
Thank you, Ms. Crosby. Members, any questions? If not, thank you so much for your testimony.
Thank you.
And I think that was the last witness. That's our last witness. Is there anyone else who wishes to testify on, for, or against HB 5103? Chair hearing none. I'll recognize Chairman Dutton to close on HB 5103.
I close, Mr. Chairman. Thank you.
All right, if there's no objection, HB 5103 will be left pending. All right. At this time, the chair lays out HB 4953. It's supposed to be by Representative Leo Wilson, but we'll be having, who's going to do that? Representative Lopez. Oh, Representative Lopez will be laying out and explaining the bill. Time's up. No, go ahead. I was just kidding.
That was quick. Thank you, Mr. Chairman, members of the committee, for this opportunity to lay out House Bill 4953 for Representative Terry Leo Wilson. If there are any questions about the bill, she is welcoming any questions afterwards with her office staff or herself. So whenever possible, children should remain with their parents. This simple tenet is a reason that the court may allow a monitored return of a child who has been removed from parental custody once the parents in question have stabilized. The Department of Family Protective Services must provide evidence which meets an exacting standard to warrant removing a child in first place. However, under a monitored return, the standard for removing a child from his or her parents' custody is much lower. This is why HB 4953 amends the Family Code to add that children can only be removed from a monitored return after notice and a hearing, except in cases of emergency. If parents have put in the hard work to regain custody, they should also regain the deference which our great state rightly affords to parents as a rule. Mr. Chairman, I humbly reserve the right to close.
All right. Thank you, Representative Lopez. Members, are there any questions? This time we'll go to public testimony. Chair calls up Brandon Johnson. Full name, on, for, against, and who you're representing.
Brandon Johnson, I believe I put down for the bill. What else?
Yeah, neutral.
Neutral. I'd like to remain neutral and for myself. There are some good things in this bill that I see. And once again, I haven't really dealt with the Department of Family and Protective Services. However, they have an overworked caseload as it is. That's one thing that I do know. Janice Jack the judge, she gives him scathing reviews. And so anything with them named in the bill, again, it kind of throws a red flag. I will say that given a time limit or a deadline on the first page there and taking out the 180 days to 30 days, that sounds like a good idea. And, overall, it looks pretty good. What really, again, raises a red flag to me, and maybe not justly so, I don't know, is just the preponderance of evidence on line 14. And then I know that, they throw in there about immediate danger and reasonable efforts. I don't know how that's defined. I haven't drilled down in the code on that, but I just know that echoing Jeff Morgan's sentiment, I don't trust these courts. And honestly, too many times a judge is incentivized, I'll just say for liability reasons, to err on the side of the caution and say, well, I left them with the state, and so therefore I was protecting them. And I feel like as a fallback, too many times, and it really is the way the code was designed, that under these, I guess the way the statutes are written, that, hey, we're going to err on caution. We're going to take the dad out of the home. We're going to take the kid out of the home and put them with strangers. And I just think it's a bad idea and something we really need to look at hard because, again, Jeff and I are pretty hard on the judges, along with most of us as advocates. But the reality is that judge is kind of protecting his own skin, and defaulting back to the state, if that's the way y'all are writing these statutes. That's all I've got. Thank you.
Thank you, Mr. Senator. Any question, members? Not, the chair calls. Jeffrey Morgan.
Okay, I thought it was done. Last bill. Thank you for putting something out here.
Full name, will you represent on, for, against the bill?
I will be for this bill. I think that's what I have. My name's Jeffrey Morgan. I'm speaking for myself. I'm for the bill. Anything, as Brandon just mentioned, anything that will protect parents against the abusiveness of CPS, I'm all for. I think about some of the people that I've seen that have gone through this. I've interviewed a number of people. They are on my YouTube channel. I know that the Pardo case was another one that even Senator Bob Hall was at. Janice Jack Graham, I think, yeah. I mean, I've read some of her stuff regarding CPS and everything, and she has been scathing. She said we've had problems that have existed since 1995 under Bush, under Perry, under, it's been going on and on and on. As Representative Tallarico said, lots of Band-Aids, but no real solutions that are there. I have, with regard to CPS, I have, again, seen them when they will lie. I was at a case one time, at a court hearing one time, when CPS basically, they wanted to get me arrested and thrown out because I was watching on behalf of a father. And two people there said the reason the father got the child was because I was there because the judge knew who I was. But the CPS was saying, take the kids out because the parents are getting the divorce. The mom wants the kids to go to a foster care. The big thing that I see here is to make sure that when it comes down to parents, there's got to be more than just a preponderance of evidence. I think CPS is not necessarily trained on some of these things. The training of CPS workers is not high quality. So I would want to see more than just the preponderance of evidence there. I would like to see some accountability. If CPS messes up, I wish that they would make reparations. I wish that they would write something. Again, I got involved with this because of CPS, because they filed that they would not tell my daughter that I had nothing to do with an incident. I was out of state. And that's why I've been down here. You wouldn't know me otherwise. And I wouldn't know these great people that I'm friends with at this point either, more than likely. But CPS was the main cause. So I will do anything to back up the reining in of CPS, standing for parents. And again, I would like to start seeing reparations being made. Because some of these parents have been abused by this agency. They've had to spend thousands and thousands of dollars. And they should be recompensed for their pain and suffering and their expenses. There was the case out in Houston a couple of years ago. The judge only gave like $115,000 or $30,000 in reparations because he did not want the taxpayers to bear the burden of it. But really, I'm sorry, that was the bare minimum that they were given. They should have been given a lot more than that. We've got a guy in Texas right now. He's been in California. He has sued CPS for millions of dollars, and I hope, to be honest with you, that he picks up his practice here. I know he's living in Texas right now, because the only way that our abusive CPS agency is going to start being reined in and protect the rights of parents is if we start suing them. And unfortunately, that's just the plain cold reality. So anyway,
Thank you, Mr.
once
Ward.
again, thank you so much. And one final thing, if you don't mind, and I'm going to go here. I know you talk a lot, different people talk with the Texas Family Law Foundation. They're a lobbying group. We would also like to offer other experts, child custody evaluators and stuff like that. They would make themselves available for free to give a different perspective, not one for the industry. Thank you.
Thank you, thank you. Members, any
Again,
questions?
Thank you so much, everybody. Appreciate it.
All right, this time Chair calls up Christina Peroni. Close? Perone?
Close, Representative, it's Perone.
Perone.
Thank you, Christina Perone, and I'm here on behalf of myself as well as the Texas Association of Family Defense Attorneys, and I am an attorney in Northeast Texas.
On for or against the bill?
I am for the bill.
For the bill, okay.
Have that next on the line.
Okay, sorry about that.
That's okay, that's okay. And I am for the bill. So as I think the committee is probably well aware, children on a monitored return to their parents have already been traumatized more than one time, right? They've been removed by the system. They've been put into some sort of a placement. Ideally, it was a family or kinship home, but it might have been a foster family with whom they had no connection. Now they're being removed from that home and placed back with their parents. And then we're looking at what I call the re-removal, or a removal from a monitored return. And so I think that in the situation where we have children who have been reunited with their parents because the parents have been able to work their services, been able to alleviate the concerns that caused the removal in the first place, we need to have a heightened standard and review process by which we allow CPS to single-handedly determine whether or not these children should be re-removed. So when we have quick judicial oversight like the bill provides, by having a hearing within 3 days if there's a removal done without a court order, or by requiring that there be a hearing prior to a removal from a monitored return, we take away from CPS that power, that exclusive power that they had to decide whether or not these children should be removed. I've personally been a part of a number of cases where obtaining a hearing on a removal from a monitored return on behalf of a parent or the child that was removed. So in that case, we're asking that the court hear the removal and determine that the child should go back home on the monitored return. Unfortunately, because of the backlog in our judicial systems, sometimes that hearing can take 8 to 10 weeks to get. So now we've caused an additional trauma simply because getting a hearing to have the court say, no, CPS, you got that one wrong, send that kid back home on their monitored return, takes so long. So having a bill that requires that the court set these hearings within 3 days or hold these hearings before we ever even allow CPS to come in alleviates that concern entirely. Allowing CPS to unilaterally make this decision without judicial oversight completely obliterates the valuable and important insight that we have from attorneys ad litem who represent these children, guardians ad litem who also work very closely with these children and these families on a regular basis. And so while it's true that the Family Code already requires that the department consult with those individuals who are court appointed on these cases, CPS policy doesn't specifically say whether or not they ever have to agree with them. And more times than not, I'm told, you don't like it, you object? Okay, thanks, consider yourself consulted. By having the courts require that we have a hearing, it allows us to voice our concerns to the judiciary. And so while I know some of the other participants here today say that they don't have a great trust of the judges, I'm here to tell you that I distrust CPS quite a bit more. And so I'm for this bill and would ask that the committee continue to move it forward so that we can continue to have that oversight.
Thank you, Ms. Brown, for your testimony. Members, any questions? Very good.
Thank you.
Thank you so much. All right, at this time, the chair calls Julia Hatcher.
Chair Dutton, committee members, I don't think I can beat that, but I'll try. My name is Julia Hatcher. I'm an attorney in Galveston, and I'm the president of the Texas Association of Family Defense Attorneys. We have attorneys all over the state, And just to give you a little bit background on
You're for
monitored
the bill,
return.
right?
Yes, we're for the bill. We support the bill. Just to give you a little bit of background on what a monitored return is. After the department has removed children from their parents, parents work a service plan, and it can take, it really depends on the parents. It can take 3 months, it can take 6 months, it can take 8 months, it can take a year. But at whatever point, they've either completed most of their services or all of their services. The court feels that there's no longer a continuing danger in the home, then the court returns the children to the parents in what we call a monitored return. And it's 263-401 of the code. And there are actually two different kinds of monitored returns. There's a regular monitored return where they just get the children like the next day or in a couple of days. And then there's a transitional monitored return where it might start out with like weekends or something, and then it kind of, develops into a return to the home. But in any event, the department is continuing to monitor the children in that home for a period of up to 6 months. And if the department, what's been happening is if the department feels for whatever reason that they don't like something that the parents are doing or not doing, they'll just go in and yank the kids because they have custody and they can do that and they don't think they need permission. What we would like to see is that we have to have a hearing to just let the court decide. The court put the children back in that home. Let the court decide whether or not the children should come back out of that home. And that would be more fair for everybody. So, I'm really tired. I'm sorry. I lost my train of thought.
No, that's good.
On the time requirement, there was 180 days in there for if the children have to be removed from a monitored return, then the court could extend the case for another 180 days. And what we've been finding is the court, it's like a cycle. They'll go on the monitored return, the court removes the monitored return, then they get another 180 days, they'll go back on a monitored return, and then the court removes from a monitored return. And each time that they're placed and removed, the court can extend 180 days. So what we thought would be best is if we just said, look, you're going to get your monitored return, and unless there's an immediate date, I mean, you're going to keep your kids. That's why we heightened the standard on this removal. You're going to keep your kids in your home unless there's an immediate danger and the court feels they need to be pulled out. And so if that occurs, we don't want to give you another 180 days, right? You can have 30 and everybody can get ready for trial, and then we'll decide whether or not you get your kids back. But that was the purpose for that.
Thank you, Ms. Hatcher. Members, any questions? All right, thank you so much for your testimony. Appreciate it.
Thank you.
I don't think we have any more. We have anyone else? No one else? Is there anyone else who wishes to testify on, for, or against HB 4953? Chair sees none. I'm going to recognize Representative Lopez, who's representing Representative Leo Wilson, to close on HB 4953.
Thank you, Mr. Chairman. With this, we close and we ask for your favorable consideration.
All right, if there's no objection, HB 4953 will be left pending. This time I'm going to turn it back over to Chairman Dutton.
Thank you. Members, thank you all for being here. And certainly thank you all the witnesses who've been here. We're going to end this, but tomorrow, members, we will have a formal meeting on the House floor, and I'll announce what time at my desk. We'll probably do it on some recess or adjournment. So, but I'll let you know. I'll make sure that you're aware of it, okay? So, if there's no further business, the Committee on Juvenile Justice and Family Issues will adjourn.